All right, let's see how we're looking. We should be good up in here. But make sure y'all can hear me. You know what to do. We're looking all crispy and clean on the screen. Drop a 1 in the chat if you can hear me. Drop a 1 in the chat if you can see me. We're going to go ahead and get into it. Welcome, y'all. Welcome back to another YouTube live stream and another episode of the ClassE Morning Show. I'm your host, ClassE, of patreon.com/ClassEbeats. The link is in the description as well as in the pinned comment in the chat. And happy Monday to y'all, man. How are y'all feeling this Monday morning? We've got a lot going on today. Just when I thought things couldn't get crazier, we're going to be ending one trial shortly, probably this week, and starting another one. We're going to talk about it here a little bit later. We got Karen Reed, we got Dr. Wolfe back on the stand today for day 29, so it's going to be a good time. But before I get into it, I got to say what's up to the people, man. We got everybody up in here on this Monday morning, ready to go. Shout out to the gang. Let me see if I could see y'all up in here. We should be good to go. Let me see. There we go. Shout out to my dog James for letting me know we're good with the sound. My awesome, amazing Amy is in the building. Thank you for being here. Shout out to Amy. We got Kara in here. Les Cleaver, Wendy W. We got Texas Rose. Good morning. Slim Life, New Jersey. Wendy W. I already said that. Shout out to you 2 times. We got Jay Buckmaster back at it. Good to see you. Gerald's in here as well. Good morning. Dang, y'all were in here commenting like crazy. Julie's in the building. Good morning, Julie. We've got Taco Tuesday in here a day early. Shout out to Taco Tuesday. Who else is in the building? I want to make sure I don't miss any of y'all. And Blue is in here. Trisha's in here. Good morning. We've got shout out to all the members, by the way. Y'all know I got to show love to the members in here. Y'all holding it down every single day. Kitty Cat's in here. Nana Banana's in the building. All right, I know I missed some of y'all. Shout out to Dennis in here too. We've got, oh man, Miss Dudley. I'm gonna mispronounce your name. I'm gonna mispronounce it. Ocean Grove is in here. The Honorable Attorney Kel Bell is in the building too. Libby22 SC Girl. Oh, Dottie's in the building. Shout out to Amazing Grace. Good morning. Good morning. Good morning. Good to see you in here as always. All right, we're gonna go ahead and get into it. I do not ask for a lot on this show, but the number one thing I do ask, the only thing I ask, is that you guys like the video. It's free. It helps the channel grow. It lets the algorithm know that you guys are enjoying the show. It shares the video. This live stream, all the videos we've done in the past, all the live streams done in the past, it shares it out with more people. It really does help us continue to grow. So if y'all could, make sure you like the video. I know there's already nearly 1,700 of you that like the video, which is insane. Absolutely insane. So thank y'all again. I'm going to be continuing to ask throughout the show because I know we got a ton of y'all that are leaving, coming back. I know Les is out there working like crazy, working hard. So please like the video on your way in. All right, we're going to go ahead and get into it. I'm not going to waste any time. I know some of you have went the extra mile and shown some major love by sending in super chat. So I got to acknowledge y'all. Grace said, have a great day to the best dad inside and out. And to the best Dottie inside and out. Thank you, Grace. I love you. I appreciate you. And thank you. And I hope you're going to have a great day too. I know you're going to have a great day. We've got a couple super chats I want to get into, and then we'll get into the court proceedings today. Oh, before I start reading these, I mentioned to y'all, we've got the Karen Reed trial is going to be wrapping up most likely this week. And then we've got Christian Eppinger. We've got YSL part 2 is going to be starting here shortly. They're actually doing jury selection today. Shouldn't take that long, to be honest, with jury selection here. And this is going to be an interesting one. So I'm glad we get to go from Karen Reed right into another trial, YSL 2.0. So make sure y'all are here and you stay ready for that. We're going to be covering a little bit of what's going on in YSL 2.0 during lunchtime. So make sure y'all stay here for that because you don't want to miss out on that. All right, we got Slim Life, New Jersey in the building with the 5 bomb. Says, good morning, ClassE, Amy, and my amazing CEB family. Happy Monday. And remember, God is good all the time, and all the time God is good. Can I get an amen, y'all? Let's get it. Thank you, Slim Life, who also has a membership milestone of 6 months. It's been 6 months already, Slim Life. I feel like we just started this thing, and you've been over here for 6 months. That's crazy. Says, I'm so blessed to have been here all this time with my amazing CEB family. I've been here a while longer, but made it official a while ago, and so glad I did. I love all of you. Thank you to Slim Life, man, consistently showing up, and especially during this trial, has not missed a day. So thank you so much. We've also got Wendy W is in the building with the 4-month milestone. Shout out to Wendy. Shout out to all the members over there. Good morning, ClassE and Amy. This is the kindest chat family on YouTube. I think so. And with the best people, love you all. Thank you so much. We've got Slim Life in here with another super chat. She says, don't forget to continue to pray for Shauna. That's so true. Yeah, waiting to hear an update from Shauna. So hopefully she'll stop by the chat and let us know what's going on there. She's had some surgery this Friday. So y'all definitely continue to keep her in your prayers. We've got my awesome, amazing Amy is in here, gifting 5 memberships. If you got a membership from Amy, y'all do the right thing. As the commissioner said, do the right thing and make sure you say thank you to Amy. Amy, I appreciate that. Y'all also go check out all the members only content that we have over there. Use the custom emojis in the chat and let us know that you are in here. All right. We've got Kara in the building with the 5 bomb. Says, good morning to you all. There is no better day than today, the first day of the week, the official first day of the week, to have a great day on purpose. Absolutely. Now let the circus begin. Handsome tax and beautiful tax. Thank you so much, Kara. Let's have a great day, a great week on purpose. All right. And then last but certainly not least, we've got my guy, CPE is in the building with the 5 bomb, just showing some love. Appreciate you, man. Thank you, CPE, for the love and support. Absolutely appreciate you so much. All right, let me see. I'm gonna say what's up to a couple of y'all. I see Raunchy Dog is in here. We've got Cynthia Hartz is in the building. Where did Miss Dudley go? Oh, thank you for the pronunciation. She said it's pronounced Tahani. It's Hawaiian. Ooh, exotic. I like it. It's pronounced Tahani. That's a beautiful name. Shout out to Tahani Dudley in the building. Thank you for stopping by, Tahani, and thank you for being a member as well. Tahani, it's in there. Tahani. I got it. You're supposed to wink when you say do the right thing. Oh, do the right thing. Thank you, Green Man. All right, y'all are tired of me talking. Let's go ahead and get into our coverage today. I think we're starting today with either a voir dire or Hank complaining. I don't know which one it is. I got to ask y'all in the chat, though. How many... Let me see here. How many sidebars are we having today? What do y'all think? How many sidebars today? I have no idea how many sidebars we're going to have. With now keep in mind, Dr. Wolfe is back up there today, and we may hear from, I'm going to mispronounce his name. Is it Welchner? His colleague. So let's go. We'll do 0 to 5. Is it going to be 0 to 5? 6 to, I want to say 6 to 9. I got to do it. All right. Hey, yo. And then we'll go 10 to 13, or is it going to be 14 plus? All right. Y'all let me know what you think. How many sidebars today? And if I can get the poll in there. All right, here we go. Y'all check it out. We're going to go ahead and get right into it with our coverage of day 29 of the Karen Reed trial. Let's see what's going on here. Oh. And thank y'all for your patience. I know I'll be up here talking.
But now open, you may be seated.
Hi, good morning.
Uh-oh, don't do that. The feed's going out.
So I just saw a transcript that was placed here on maybe reference this morning, and there's a motion to limit Dr. Rentschler that I just got that I'm not prepared for. So that we'll do later today, okay? All right. So the Commonwealth's motion to call witnesses in rebuttal. I've read everything. Ms. Little, I appreciate you getting your opposition to me. I think I had it by Saturday morning, so I appreciate it.
I appreciate
all
it
the
too.
cases on it. Does the defense want to be heard any further on this?
Honor.
Okay?
With regard to Dr. Crosby and Ms. Coon, as the
Speak into a microphone. Speak into a microphone.
Come on, Ms. Little. You've been here before. Let's go.
With regard to Dr. Crosby and Ms. Coon, the Commonwealth has been on notice that the defendant intends to present a defense regarding the arm injuries, that this was caused by a dog bite. They have been on notice of that, not just for months, but for years. That was presented at the first trial. The Commonwealth does not have a right to rebut information that they have been on notice of from the start of the case. So their decision to wait for rebuttal to call these two witnesses is improper, and we're asking the court to exclude their testimony.
Kel Bell said, can we just cut to the
As
chase?
it relates
Motion
to
denied.
Dr. Welcher, the scope
Yeah.
of his testimony, our request is that be limited to very specific information, specifically responding to the new testing that ARCA has done. As the court knows, the Commonwealth has proposed a number of new testing ideas, as well as information that is greatly outside the scope of what ARCA intends to testify to. And so we're asking that the court limit their testimony from engaging in new testing that has nothing to do with what ARCA has testified about at this trial. With regard to Dr. Welcher's testimony, the court has made very, very strong rulings that Dr. Wolfe, as well as Dr. Rentschler, are not allowed to speak to the credibility of Dr. Welcher himself. And so some of the information that the Commonwealth proposes is to directly attack
Yeah,
the testimony
Miss
of Dr.
Little has
Wolfe
one
and
of those
Dr.
crying
Rentschler. Under
voices.
the court's rulings, we're asking that the court
Sounds
limit
like
that
she's about
scope
to
as
cry.
well.
And I told you I would.
Thank you.
All right.
That's all,
Brennan.
Your Honor.
Thank you. Mr. Brennan, do you want to be heard?
Regarding DNA evidence, evidence cannot be rebutted until it is introduced because the defense has a number of potential ideas of areas of testimony. It does not compel the Commonwealth to try to anticipate or deflect attacks, especially if they're meritless. And so the issue of dogs and dog DNA does not become relevant until the defense calls a so-called dog expert. They raise the issue, it's proper grounds for rebuttal. There are three witnesses.
They called it
Martin,
that's
UC
a dog
Davis,
expert.
Dr. Crosby.
It's
If
Dr. Russell.
Dr. LaPosada is precluded from testifying about dog bites, we would not call Dr. Crosby as a witness. However, regardless of what Dr. LaPosada says, we would ask to call Ms. Hartnett and to call the witness from UC Davis. It is an issue that directly affects the assessment of Dr. Russell, the very expert they chose to call in their case in chief, and so we can now, from my perspective, properly rebut it. The second issue regarding Dr. Welcher, limited to the new information you will see from the testimony or have heard. Most of the testimony is new, but we understand it's limited. We don't expect Dr. Welcher to have a direct comment on the credibility of any witnesses, but he will address the tests, how he believes would be the proper procedure, and there'll be a number of issues that have been raised on direct examination, but he will not in any way have a comment on the credibility of the defense experts.
All right. So the case law supports me allowing this motion. I'm allowing the Commonwealth's motion. So
Of
the
course.
motion for rebuttal witnesses is allowed. Mr. Brennan has said he will not call Dr. Crosby, depending on the testimony that comes in. So, all right, Jim, I'm just going to give you this.
Thank you.
All right, so the motion regarding the testimony of Dr. Lopesada. So the Commonwealth is moving specifically to exclude, there's a motion to exclude irrelevant photographs. We'll deal with that after the main motion to
we
exclude certain
surprised?
testimony. So if we start on page 7 of the report, that's where you want me to start, Mr. Brennan?
Your Honor?
Okay, page 7 of your report. I have some questions. So, Mr. Jackson, Dr. LaPosada cannot opine about the investigation of the case, the law enforcement investigation. She does that throughout her report. So she can't opine to that, but when we get to page 7, what do you say is out Mr. Brennan? I mean, I've gone through it, I know what I think, but it's the Commonwealth's motion.
I think that her opinion about no object being present to cause a pattern injury is appropriate.
And where are you, on page 7, the first paragraph?
Yes, photographs and descriptions of the site.
It's where you can hear the court reporter
It is
too.
the-
All right, I might have a different page 7. So my page 7, okay. Okay, yep.
Dr. Laposada's proposed opinion that photographs and description of the site where Mr. O'Keefe's body was found show no object capable of producing a pattern injury, I think is appropriate. His body was found on flat, grassy ground, probably frozen and covered with a minimal amount of snow. I agree is appropriate. It is the next paragraph where it begins in the middle of the sentence. It is logical to conclude that Mr. O'Keefe was injured elsewhere and his body was moved to the front line. There is no basis in fact for that. It's an improper opinion.
Yeah.
We left the argument.
So I told you that on Friday, Mr. Jackson.
We're not seeking that.
Great, okay, so that's out. And Mr. Jackson, again, the medical examiner erred in her diagnosis of hypothermia. Again, that's the improper critiquing of the expert. She can say that it wasn't hypothermia, obviously. Okay, so same with the first sentence of the next paragraph, the Wisniewski spots were misidentified.
We're not seeking that.
Great, all right, so we can probably do this much quicker then. All right. All right, so page 8 is fine. So now we go to page 10. So this is the dog bites. So if you want to pick it up at, what does the Commonwealth say about this?
At this point, there's no basis provided that she has the training, expertise, methodology to provide an opinion regarding a dog bite.
What's the offer of proof on this, Mr. Jackson?
It will be more extensive when I establish the foundation.
Y'all are saying the voir dire is not
Not
a sidebar. Okay.
autopsies involving dog bites, the wound pattern recognition related to the source of those dog bites. She's also taught classes on wound pattern recognition, source of coming up with diagnoses concerning the source of specific pattern wounds. She has a methodology that she uses. Medical school classes, if I didn't mention, the courses.
What does she teach? Is this in her CV? Because I didn't see it.
It will be in her foundation that I will lay in front of the jury.
All right.
I won't seek any opinion unless and until the foundation is properly laid, but she has extensive experience, not only with, specifically with autopsies that she's conducted herself, but supervising autopsies of others that deal with pattern recognition, the methodology involved with pattern recognition.
How about dog bites?
Dog bites specifically, 5 autopsies. I believe she will indicate that she's done 5 autopsies as they relate to dog bites.
Okay.
A medical school class specifically on the issue of wound pattern recognition, which that class includes dog bite recognition.
All right, so we'll need a short voir dire of her on this before she testifies.
Because the court doesn't believe that I can lay the foundation
Interesting.
for the jury and just forego a voir dire. I won't ask any ultimate question until we go to sidebar, but I think we can short circuit that.
Well, she's very specific about the dog bites here. So if she's seen 5 autopsies with dog bites,
So we are
I'm
gonna
not
have
inclined to give it to you.
a dog
Okay.
expert too.
Seen only 5 in her 40 years or whatever.
It's not that she's only seen 5, she's performed 5 autopsies.
Okay, so that's why we need a voir dire. So we need a very short voir dire.
She's also been qualified on the issue
Interesting.
of dog bite wound pattern recognition in federal court as well.
Okay.
So she has a plethora of foundations.
They're
Has
really
that been
doubling
provided to
down
the
on the
Commonwealth
dog
in
bite.
advance of today?
I don't know.
None of it has, so here's the difficulty, whether it's a voir dire or it's in front of a jury, I have absolutely no ability to research and cross-examine her on dog bites. She can say she had 1 case or 50 cases, that she testified in state or federal court, or she took a class. I can't verify it, I can't contradict it. I have no ability to prepare for this witness about her basis, methodology, and experience in dog bites. What I have is her showing a couple pictures that she pulled from a book, and then she has some Google or Shutterstock research in her report. And so the idea that she has a history or basis is going to be uncontested because there's nothing I can do to contest it, and that's not appropriate. I should be able to research, get transcripts, vet, and be able to approach the witness on whether or not she actually has the reliability and education and experience. I can't do that if we call her an access in front of the jury. Or a
Just
witness.
beverage.
But that's where, if we want to compare apples to apples, Dr. Wolfe, ASIC Wolfe, was allowed to testify, to specifically testify to the wound pattern, or his interpretation of wound pattern recognitions back then. That was nowhere in his report. That was objected to by the defense. Mr. Alessi went to sidebar, strenuously objected, said this is nowhere in the reports, we didn't have any notice of this, and the court said, overruled, he's allowed to testify to the pattern of recognition, at least in his mind, you can cross-examine on. There is no requirement that the Commonwealth have every single case that Dr. Lomasada has ever dealt with, dealing with.
No, we had an expert on dog bites who I allowed to testify as to dog bites based on, we had a whole, as you know, it was Mr. Leslie, I think 3 days with Dr. Russell on the voir dire. This is new to me. I'm going to have a short voir dire on to what she can testify to.
I have no problem with voir dire, I just wanted to short circuit it, but I have
So,
to entertain that.
all right, so let's go on to page 17.
Commonwealth has an objection to the third line, Mr. O'Keefe's pattern injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm. She is not qualified as a reconstructionist or biomechanical engineer. She has tried in other courts and been rejected. She does not have the experience, the background, or the ability to do that improperly.
What do you say, Mr. Jackson?
Your Honor, I believe she does, as a medical examiner, have the experience, and it's the qualification, it's the specific job of, and the qualification of a medical examiner to opine on pattern injuries. If the foundation is laid, especially as it relates to motor vehicle accidents, and now we're not talking about.
I can't wait to see that dog expert too.
A more defined subset of her overall experience. Now we're talking about motor vehicle incidents and accidents that she has specifically seen thousands of.
Okay.
Thousands, multiple thousands of.
So-
But if she does have the qualification to say, if the proper foundation is laid, that the wound pattern that I see on Mr. O'Keefe's arm is inconsistent with anything that I've seen in terms of a motor vehicle accident.
Let's just find out how many motor vehicle accident autopsies she's done during that voir dire. What I have a question about is tail lights are typically made of durable polycarbonate or acrylic plastic. I would keep that out. I'd be inclined to allow in the injuries on his right arm do not correspond to injuries that could have been produced by plastic pieces impacting his arm. But let's hear about
That's
that.
appropriate. I wouldn't ask about polycarbonate. I have no intention of asking about that.
And also, the last sentence, I think it's okay, and we'll see with voir dire. Neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes, assuming she has experience with autopsies of motor vehicle accidents. But I would keep out the part as would be expected from pieces of shattered tail light. Was there more on that?
I object to that because this is now yet another witness that is coming in under the guise of some type of specialty, but really for accident reconstruction.
All right, so let's see what she says on voir dire regarding her experience with accident victims. I think she gets more into the accident reconstruction on the next page that I don't think is proper.
Which I am not seeking to achieve.
All right, so that whole first paragraph on the next page, you're not seeking to introduce? Yeah.
At least the first, we're starting with the first sentence, yes, we would be seeking to introduce that. Pedestrian injuries produced by contact with motor vehicle include a component of tissue crushing force as the car profile protrusions connect. That's basic. I believe that she does have the qualifications to opine about that. That's pretty standard, and that should be admitted.
She has absolutely no experience in accident reconstruction or the injuries she is not a biomechanical biomedical engineer. They have one, and he's going to testify to it.
Yeah, I have that as out, Mr. Jackson.
The reason that I believe that it's appropriate is because you don't have to be a biomechanical engineer to understand when you see, for instance, a known pedestrian accident, what are the results, especially if you've seen hundreds or maybe even thousands, what are the results that you typically see in the movement patterns? For instance, crushing forces, broken bones, fractured bones, crushed soft tissue, things of that nature, internal bleeding. That's the province of medical exam.
Okay.
That's exactly what they are trained to identify and to opine on.
Okay,
I
so
wouldn't get into things like, for instance, what she doesn't have the experience to do is say, when a car is involved in a rollover collision, these are the mechanical forces that are exerted on the body during a rollover, and the G forces that are subject, that the body is subject to in a rollover, things of that nature. When a car is impacted head-on by another car, there are a number of G forces that are put upon the body, etc. Those are biomechanical issues, have nothing to do with her expertise, and I wouldn't be seeking anything like that. But once the body is removed from the car, and then it's on the autopsy table, that's where her expertise begins to fly. if you
Okay.
will. She can talk about, and I believe she has the experience and the qualifications to talk about, what the body suffers at the hands of a vehicle, pedestrian incident, or accident.
okay, so the first two sentences are out. The third sentence, she can testify that Mr. O'Keefe had no bruising on his arms or torso. And she can testify, and she cannot say that would have resulted from the impact with the SUV rear profile. She can say Mr. O'Keefe did not have bruises on his legs. She cannot say from bumper contact, but she can say as shown by dissection of leg tissue and muscle at autopsy. And she can't testify to anything else in that paragraph.
Okay. Your Honor, is the court ruling that she cannot say anything about the human body contacting a motor vehicle? That sounds like what the court's saying.
No.
I think that's too narrow a ruling.
It is. You can put this in, what I said you could put in, can come in, and the rest cannot. We
For
could,
instance, and this, for point of clarification, if I ask her, would you expect, I'm just gonna make it a hypothetical, would you expect if his legs were contacted by a moving vehicle, would you expect to see bruise or contusion?
what do you say about that?
I don't object, one, it's leading. Secondly,
Well, I'm not asking the question.
Secondly, this is asking to have Dr. Lavasada do accident reconstruction. She's not assessing a wound. I'd ask you to consider the case.
I don't know why this sounds so low. Can y'all hear okay?
I think we provided at 105 Mass Ave 1124, 2025 case. And a similar attempt was made to try to use Dr. Lavasada as a biomechanical accident reconstructionist. The trial judge did not credit her proffer and found that she failed to meet the requisite criteria pursuant to Daubert-Lanigan. And so recently it's been found by at least another court that she is not competent to do this. Because she's a medical examiner, does not allow her to come in and start endorsing.
All right, hold on, I'll fix it.
for the
It's because no one's using the mic.
And so, not only on page 18,
Hold on a second.
going back to page 17, about the pattern injuries don't correspond to injuries to a light, she would only know that if she had the training
Where,
and experience.
I'm sorry, where,
You said on page 17 you would allow Mr. O'Keefe's pattern injuries on his right arm do not correspond to injuries that could have been produced by regular fractured plastic pieces impacting his arm. That's not her role as a medical examiner. That is the role of a reconstruction or a biomechanical engineer. And she clearly is not competent, at least as cited by the appeals court. to have
Should be
that,
better now.
opinion. And so one thing to assess wounds is another to try to correlate or draw a distinction between the wounds in a car collision. It is essentially giving an opinion to the jury, he didn't get hit by a car. That is the core fundamental theory of the defense. This is simply trying to bootstrap another witness to give that opinion. That's improper.
Is that better?
right. Sure.
Mr. Brennan's going to cite the Tompkins case. He needs to cite the Tompkins case. That dealt with a situation in which the witness was called and she was asked by the lawyers, specifically in that case, the people that called her, the lawyers that called her, to opine about blood-stain pattern recognition, blood spatter evidence on the driver's seat versus the passenger seat, and what her opinion was about who actually was driving the vehicle. It was a rollover collision in which people were ejected from the car. She was then asked to opine about bloodstain patterns in the driver's seat and whether that was more or less consistent with the blood, the originator of the blood, one particular individual. Was he more likely in the driver's seat or the passenger seat at the time of the bleeding, and was it before or after the rollover? Very, very different set of facts. And of course, that is a biomechanical engineer's province. And the court was correct in saying, I'm not going to credit her testimony on that issue, but that's what she was asked. She opined on it, and the court said, I'm not going to credit her testimony.
All right, so
To do with this type of analysis and wound pattern recognition, which is what she's being asked to do.
So let's see with her voir dire this morning.
Okay.
She actually.
Oh, so they're gonna have one this morning.
Blood spatter is the reconstruction testimony that she was not.
Okay, good.
I read the Superior Court judge's decision. I have not read the appeals court rescript, so I need to do that. I'd like to get going, but there are photographs of inside the garage. You intend to put this in through Dr. Lopesada?
No, not through.
Through whom?
If I could just have.
Yeah, can I get this? With regard to these photos, well, ultimately, the Lopesada will be shown them, correct? That they'll be introduced through our investigator who took the photos. We intend to call that investigator after Dr. Wolfe testifies.
And what will that investigator say? These are photographs.
So he will testify to two subject areas. One would be took measurements from the street to the various entrances to 34 Fairview. You just have to testify about what those measurements were. And then where he took several photographs, we have pared them down to, I think, 3 or 4, just of one establishing shot showing the garage from the street, and then a couple of photos showing the side entrance to the garage, the pedestrian entrance to the garage, which also shows the interior.
Yeah, we need that.
Including a step and a
For what purpose? How are they relevant?
I'm sorry?
How are they relevant?
So the defense is presenting a Bowden defense in this case. We are alleging that the police did not do a thorough investigation. They did not really investigate anyone other than Karen Reed. The Commonwealth's own evidence, including the testimony of Ian Whitman, is consistent with John O'Keefe after what they claim to be the trigger event in Dr. Welch's initial report. John O'Keefe walking in a westerly direction, which would be from Fairview Road to the house, taking approximately 36 steps over a distance of 25.4 meters, which is approximately 84 feet. That is consistent with him entering the house. It's consistent with him entering the garage. The police did not take photos of the garage. They didn't investigate, is there a hard surface in the garage? Is there a ridge-like surface in the garage? And these are photos are introduced on that Bowden issue to say that there was evidence in the house. If the police only went in there, they would have seen that. And that may have sent them in a different direction. So it's relevant for that purpose.
Do you want to weigh in on this?
These are not only relevant and not material, it's misleading. They are not seeking to have measurements from the flagpole to the door. They're trying to seek measurements from the driveway to the door. There is no evidence whatsoever John O'Keefe was ever on, near, or anywhere by the driveway. The evidence is that he was at the flagpole. While the data showed there was a turn westward, it didn't show movement westward. It did not. If there was a measurement from the flagpole to the garage door, that is something that I think would be appropriate. From the driveway, totally irrelevant. There's no evidence, no witness, no substantive evidence in this case that John O'Keefe went in the house, went near the house, was dropped off. They're relying.
There's no evidence he was hit by a car either. True.
They have no idea what direction or where. What they want to do to argue this is to show inside the garage and then posit a theory that somehow John O'Keefe was killed in the garage. It was colder than it was in the regular house. That would account for the temperature on the battery. They have no evidence to support that. You can't use Bowden as a panacea. You can't just say Bowden, they should have done what we want them to do. It is what is reasonable. The police went into the house, they spoke to the occupants of the house. There was no evidence that Mr. O'Keefe went into the garage. You might as well take a photograph of anybody else's garage in America and put it up in front of the jury. So this is going to create a mistaken, baseless argument that this evidence somehow shows that Mr. O'Keefe was A, in the garage, and B, he was injured in the garage. That's why they want to show it to Dr. LaPosada. Couldn't some of these angles have caused the injury? Total speculation, no relevance at all, and it is just prone for an opportunity to mislead this jury. This should not come in.
If I may respond in 4 ways. First of all, Mr. Brennan just informed this court that there was no evidence of movement of the phone. I'd like to quote his own witness. At 12:25:30, the device's bearing shifts to a westerly direction, as location records also show the device moving west from the roadside toward the house. So that was false. Secondly, with regard to, we should be measuring from the flagpole, our theory is not that he entered the house from the area of the flagpole. Our theory is that he was placed at that flagpole. And as Mr. Brennan correctly points out, there's no evidence that they introduced as to where he was on the road prior to walking into the house.
They think somebody put him there.
Our theory is as good as his. He cannot prove anything to contradict our theory. The third thing is that Ryan Nagel and Heather Maxey saw Karen Reed in her vehicle alone. The passenger seat was illuminated and empty. John O'Keefe was nowhere in the area of that vehicle. He was not in that vehicle. There's only one other place that he could be, and that is in the house. So finally, the fourth point, Your Honor, this court has continually always done, as the court should, a 403 analysis. The probative value we have established through their own witnesses. They called all these witnesses, and they established the foundation for the admission of these photos. There is no unfair prejudice. I argue that any time there's exculpatory evidence or a case that advances the defense theory, that's by definition going to prejudice the Commonwealth's case. This is not unfair prejudice. He is allowed, Mr. Brennan is allowed to cross-examine this witness and to make whatever arguments he wants to make about the likelihood of the garage being involved or not. But he does not and should not get the benefit of the fact that his investigation, the police investigation, didn't do what we just did. And this evidence should be admitted.
The argument is purely rhetorical. There's not one fact he offers. The witnesses that saw the car saw it in front of them. Nobody ever got out. A light on doesn't mean that he wasn't near the car. It means they didn't see him in the front seat. So there is no evidence that Mr. O'Keefe went anywhere near the house, on the breezeway, in the door. It is speculative. It is baseless. They want to take that baseless argument and then bootstrap it to Dr. LaPosada to further speculate that something in the garage that could have caused the injury. That is not Bowden. That is not a due process right. That's not 403. It's empty. It's no factual predicate whatsoever.
Okay, so,
The only other thing, just to put a cap on this, the location data circles, again, Mr. Brennan's own evidence, he introduced it, puts John O'Keefe in the house as well.
all right, so I'm going to allow you to do the measurements. These photos will mark
Nice.
for identification. The photos are not admissible. So, all right, Chrissy, can you just
Oh,
mark
she said
those,
no
please?
photos. Dang.
All right, let's bring the jury over. We will do, Mr. Jackson, how long will you be with Dr. Wolfe?
Probably
2 hours.
20 minutes.
All right. And
So that's like an hour.
Yes.
On that. All right, so during the morning recess, we'll do the voir dire of Dr. LaPosada. All right, bring him on over, please.
Okay, there it goes. I'm excited to hear about this dog expert. I did not realize that the defense was going to call another expert with dogs. I thought they really cleared up everything when Dr. Russell was up there, and the Commonwealth just looked bad the way they handled that cross-examination too. So I'm looking forward to that. Obviously, we've got some more things they're going to cover during the lunch break or during the morning recess. So we'll see if we cover that. Let me know what y'all think about that in the comments in the chat. Interesting stuff. And real quick, all right, we're going to skip ahead and go ahead and get the jury in here. And we'll bring y'all's favorite guy back up here. Dr. Wolfe is going to be back in the building. I know you guys are so disappointed about that. Here we go. Hold on.
All persons have any business.
I love to hear ye. Here we go. Let's see what Dr. Wolfe has to say this morning.
All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, hear your tenant, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Here we go. Hear ye.
Okay. All right. Good morning again, counsel. Good morning, jurors. So we appreciate your patience. We were in here trying to streamline things, so we got a lot of work done this morning, so thank you.
Nice.
I do have to ask you those same 3 questions. Were you all able to follow my instructions and refrain from discussing this case with
Nope.
anyone since we left here on Friday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively.
These jurors lie.
Did anyone happen to see, hear, or read anything about this case since we left here on Friday? Everyone said no or shook their heads. Right.
And they lie, Judge. They lie. They straight up lie. Oh, shout out to Officer Token,
You're still under oath.
the only black
All right,
female
good morning.
in Boston.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Dr. Wolfe, thank you for joining us again this morning. I'd like to draw your attention to a picture. May I approach, John?
Yes.
I'm going to show you. Do you remember seeing that photograph?
Yes,
You were shown this photograph last week, is that right?
correct,
By Mr. Brennan, correct?
correct.
Do you recognize the photo as the same photo that you were shown last week?
Yes,
Under questioning by Mr. Brennan?
yes.
And what does that appear to be a photo of, just generally?
It appears to be a photo from the test dummy from the 29 mile per hour impact test.
And does that appear to be a true and accurate photograph of the condition of the dummy following that 29 mile an hour crash test?
Yes,
With the court's permission, I'd like to enter this as next in order, please. If you could hand that to the floor corner.
Yeah, y'all know they're subscribed and watching. Shout out to Dr. Wolfe in here.
Permission to present that, Your Honor?
Yes.
Oh, I don't want to
Is
screenshot
this
him
the
like
photograph?
that.
yes.
Dr. Wolfe, first of all, what caused the damage? Well, let's start with the most basics. Which arm is this, left or right?
This is the left arm.
What position was, you called this dummy Rescue Randy, is that right?
Correct,
What
yes.
position
Shout out to
generally
Randy.
was Rescue Randy in upon impact during this test?
He was oriented such that the right side of his body and his right arm would be contacted by the vehicle.
What caused the defects in the and the damage to the sweatshirt as we see it here?
That was due to the interaction from the Rescue Randy sliding on the pavement surface to his position of final rest.
Is that sometimes called road rash?
Yes.
Did you see any road rash in
He
any other
looks
place
tired.
on Rescue Randy? In this photograph?
Doesn't appear so in this photograph, no.
Can we highlight the face? What about there?
Sorry, I thought you were talking specific to the clothing. Yes, as I mentioned on Friday, there were signs of road rash to the body of the dummy itself on the face and on the torso and arms.
Can we zoom in on the sleeve a little bit? Do you see any staining on the sleeve as well as the defects, the holes and the tears?
Yes.
What is that staining from?
Again, just from that sliding contact with the pavement, so it's just likely debris and kind of a film from the pavement surface being deposited onto the material.
With regard to John O'Keefe's sweatshirt that you reviewed photographs of, did you see any other defects other than the right arm and the fact that it was cut off of him medically?
No.
Any other indication or any indication whatsoever of anything that you see consistent with road rash?
No.
Okay, let's go back to the full frame. There's a second image I'd like you to take a look at. If we could have the lights for just a second. Do you recognize what's depicted in that photograph?
Yes.
How do you recognize it?
It is the backside of the test dummy from the 29 mile per hour full-on impact test.
Which arm is featured in that photograph?
That would be the right arm.
Move that into evidence as next in order, Your Honor, with the court's permission.
Okay. Exhibit 219?
Permission to display.
Yes.
Does that appear to be the right arm of Rescue Randy as he's face down?
Yes.
Is that following the impact?
Yes.
Do you see any? Were you shown this photograph by Mr. Brennan on cross-examination?
No, I was not.
Can we highlight the right sleeve just a little bit, please? Do you see that defect in the sleeve?
Yes.
Do you also see some artifacts above that defect, above and to the left?
Yes.
Can you tell what those are?
They appear to be fragments from the back window of the test vehicle when it shattered.
Does there appear to be any additional, let's go back to the full frame. Does there appear to be any additional defects on that particular sleeve?
There appears to be some material transfer likely from the pavement and also some road rash.
Does that appear to be transfer from the pavement?
They opened the door to this. You gotta ask.
I think
about
that
it.
might be a shard of glass from the back window.
What was the condition of the back window after this
They
test?
being the Commonwealth.
It was completely shattered.
The defect that we're looking at, that large gash, was that on the pavement?
Yes.
We can go back to the full frame, please. I'd like to show you an additional photograph. Do you recognize what's depicted in that photograph?
Yes.
What is it?
It is the front side of the test dummy from the 29 mile per hour full-on impact test.
Does that appear to be a true and accurate depiction of the condition of Rescue Randy in that sweatshirt after that 29 mile an hour impact?
Yes.
Move for the admission of that photograph, Your Honor, is next in order.
Okay. Exhibit 220?
Permission to display.
Yes.
Can you describe what we're looking at in this photograph?
This is mainly showing the upper body of the test dummy from the 29 mile an hour impact test, showing the road rash to the front side of the body.
Were you shown this photograph on cross-examination?
No.
What caused the holes in the bodice of the shirt? In other words, the part that covers the chest and the torso.
After the impact, the dummy was projected and sliding on the pavement surface. So again, this is consistent with the front side of the body sliding, making sliding contact with the pavement, creating those abrasions and holes. And again, that asphalt material transfer that you see on the front.
Can you go out back to the full frame, please? Do you see additional road rash? Take a look at his right arm. You see additional road rash on Rescue Randy?
Yes,
On both the fabric and the arm itself?
correct.
Go back to full frame. And can you see his face as well in this photograph?
Yes,
Are those the chin and nose
His
defects
face is
that you
messed
saw?
up.
yes.
This is good though. They talked about the hard ground.
Are the defects in the shirt that you see here consistent with the condition of the shirt of John O'Keefe as you saw it in the photographs?
It is inconsistent.
May I approach you?
Yes.
Another photo that I'd like to show you. Do you recognize, do you recognize what's depicted in that photograph?
Yes,
What is that? We can take this down.
it is the rest position of the test dummy after the 29 mile per hour impact test.
Were you shown this on Friday?
Buffering? Hold on a second.
Is that a true and accurate
Should be good.
depiction of the condition of Rescue Randy just from a different angle after that 29 mile an hour impact?
Yes,
Move for the admission of that photograph.
Okay. Exhibit 221.
Permission to display that photograph, Your Honor?
Yes.
Is this an overview of the entire body of Rescue Randy after that impact?
yes,
Take a look at his torso, the exposed portion of his torso. Do you see road rash on his exposed torso?
yes,
Do you also see that the road rash that you earlier described on the bodice of the shirt, the front of the shirt?
yes,
And what about, let's go back to the full frame. Is there also road rash on his jeans?
yes,
We could go back to full frame. Have you ever heard a phrase, knocked out of your shoes?
yes.
Where are the dummy's shoes?
They're still on his feet.
And this is at an impact of 29 miles per hour, correct?
What's the form of the question? Mr.
Sure.
Jackson?
What was tell us one more time, what was the speed of this impact?
This was a full-on 29 mile per hour impact.
We can take that down. May I approach?
Yes.
Take a look at that photograph and tell me if you recognize what's depicted in it.
Yes.
What is that?
It is the back of the test Lexus after the 29 mile per hour impact test.
Is that a true and accurate depiction of the condition of that Lexus following that 29 mile an hour impact?
Yes, and I should be more specific. It's post the 29 mile per hour impact with the test dummy, not just the arm.
Understood. Thank you. The collision that caused the damage to Rescue Randy that we've just been looking at.
Correct, yes.
Okay. Move for the admission of that photograph, Your Honor.
Okay. Exhibit 222.
Permission to display that?
Yes.
Is this the the photograph that we were just talking about?
Yes,
And this is the condition of the vehicle after that rearward impact with Rescue Randy, correct?
correct.
did the subject vehicle photographs that you looked at, were those consistent or inconsistent with this photograph?
Those photographs were inconsistent compared to the test.
Was there anything consistent about the shirt that you were shown on Friday, the left sleeve that you were shown on Friday with John O'Keefe's actual sweatshirt?
Was any of that consistent with?
Correct. Was that consistent or inconsistent, now that you've seen all the photographs, with the condition of the shirt that John O'Keefe was wearing on January 29th?
The test clothing was inconsistent compared to that of Mr. John O'Keefe's.
Thank you.
Yeah, why didn't John have any of
You were
those
asked
injuries?
on cross-examination several times about the weight of the hybrid 3 arm. Do you recall that series of questions?
He said, "Wait." Brendan said,
Yes.
"Weight matters," right?
You were asked how much lighter the hybrid 3 arm was than the static estimate arm, correct?
Correct.
I want to make sure we're clear about this. The hybrid 3 arm is the physical arm that you attached to the ATD and did testing with, correct?
Correct.
The statistical estimate arm is something in the ether, right? It doesn't exist.
Sustained.
How would you describe a statistical estimate arm?
It's probably from taking a sample of the population and getting an average and a high and a low.
Okay.
A sample of the population.
That's
Interesting.
not is that a physical arm? You can touch and feel?
No.
Okay. Do you have any information based on everything that you've reviewed at all about the actual weight of John O'Keefe's right arm?
Nothing in terms of a weighed measurement of the arm, no.
Okay. What was the percentage that Mr. Brennan gave you in terms of how much lighter the hybrid 3 arm was than the statistical estimate arm that he gave you?
From what I recall, I think the percentage was 26%.
Did you calculate that yourself, or did you take Mr. Brennan's word for it?
I believe I took his word for it.
Do you recall what the weight of the hybrid 3 arm was exactly?
9.38 pounds.
What is the difference, if you can calculate, what is the difference between what was the statistical estimate arm, the number that Mr. Brennan gave you?
I think I heard him say 11.8, but I also think he said at one point 11.6. So I'm not sure of the kind of the final number he landed on.
Does
That's funny.
Sustained estimate. Ask the question and stop striking the answer.
Wait, he's striking the answer.
does 11.86 sound right?
Yes,
Okay. Let's use 11.86. Do you have a calculator with you?
I do.
With the court's permission, could Dr. Wolfe use a calculator if he needs to?
Yes.
Thank you. What's the difference between 11.86 and 9.38? Just in raw numbers?
You're looking at just the difference between those two?
Subtract
Okay.
9.38.
Yep. 2.48.
Does that mean there's a 2.48 pound differential between the statistical estimate arm, the heavier arm, and the 9.38 arm from the hybrid 3?
Yes, that's the difference in pounds.
All right. How would you calculate how much lighter? What's the proper way to calculate how much lighter, in terms of percentage, the 9.38 arm is?
You would want to do a percent difference calculation.
Divide 2.48 by 11.86?
Sustained. Watch the form, Mr. Jackson.
How would you tell the jurors how you would calculate that percentage difference?
You would
That's
subtract the 11.86 minus the 9.38, and then you would divide by the sum of those two and divide by 2, the average of them.
Of course, the one time y'all want to see
Can
the
you do that
witness, and
calculation?
they're showing
Yes.
Karen right now. We don't care about Karen, man. The cameraman all of a sudden decided today, yeah, we're gonna see what's going
Okay.
on in the courtroom. He
And
heard
what's
me.
the number?
23%.
Not 26%?
Thank you, cameraman.
Sustain.
Is 23% smaller or no, or larger than 26%?
Sustain, let's move on from that, Mr. Jackson.
What is the number that you get if you were to divide 2.48 by 11.86?
0.21,
In percentages?
21%.
Thank you.
Trying to get a good screen.
Was the hybrid 3-arm
Oh my
21%
gosh.
lighter by that calculation than the 11.86 estimate arm?
Yes.
There we go.
On cross-examination, Mr. Brennan asked you several questions related to kinetic energy formula, correct?
Correct.
You referenced that. Did you reference that formula in some of your answers?
Yes.
May I approach?
Yes.
Oh, we have our first sidebar? Dang. How do y'all think Dr. Wolfe is doing so far responding to some of the things that were brought up during cross-examination? The weight of the arm, the entire reconstruction, the injuries that were sustained to Randy? Will the Commonwealth make an argument that, oh, well, it's not an accurate reconstruction dummy. It's not regularly used, so maybe John wouldn't have sustained those injuries. I mean, Brennan, focus on the hard ground, right? It seems like there would have been more injuries if this is what happened, not somebody just falling back and hitting their head. Let me know what y'all think about this. This is very interesting. And that's our first sidebar, by the way. I don't know if I said it or not. So let's go ahead and update this. And we got a couple of super chats in here I want to read too. And then we'll keep it moving. I wonder if Karen still thinks Higgins is a hottie. Ugh. Amy is in here with the super sticker. She's got the peach up in there. Shout out to Amy with the peach. I don't even want to think about that, to be honest. I'm still, y'all see me over here drinking my smoothie. I'm still trying to work through my breakfast. So Karen and Brian Higgins is not something that I want on my mind right now. Let's just focus on people getting hit by a car, okay? That I can work with, but no, let's not do that. All right, we're gonna skip ahead and get back into the testimony. Jeez, man. I think you're hot. Here we go.
May I inquire?
Yes.
You're looking at something that's been identified, a document that's been identified as 3 X's, XXX. Do you recognize that? Oh, you're not looking at it.
Not yet.
You see it now.
Yes.
Do you recognize what
Rest in
that
peace
is?
It is the formula for kinetic energy.
With that, Your Honor, may we display the formula? We don't have to cut the lights. I think it'll be very obvious.
Yes.
They cut them anyway.
Can we bring the lights back up and see if that's visible? Can you still see that, Dr. Wolfe?
Yes.
Your Honor, is that okay?
Yes.
Great. You said this is the formula for kinetic energy, correct?
Correct.
You were asked a series of questions about whether the weight differential in the hybrid 3-arm would make a significant or material difference in your testing as it pertains to the velocity of the vehicle that you were testing? You remember those questions?
So watch the form again, ask a different question.
Just foundationally, were you asked about weight differential of the hybrid 3-arm?
Yes.
There you go.
Were you also asked about whether it would make a material difference to the testing if you didn't adjust for the velocity?
Sustained.
What were you asked in terms of, what was the question that was posed to you about the weight of the hybrid 3-arm versus the velocity of the testing?
That there would somehow be an influence on, I think, wanting to make a reduction to the velocity of the vehicle.
Does that make mathematical sense to you?
Didn't make sense to us either.
To that form.
Would that have a material difference? With the weight of the arm, that 2.48 pounds, would that have a material difference in the testing that you undertook?
No.
Why is that?
Well,
Because it's a
to start,
giant
that's one of the
vehicle.
reasons why we went above and beyond the 24 miles per hour to impart significantly more kinetic energy to the arm. So if you look at that equation, it's
What did he say,
a
4,000, 6,000
quadratic
pounds?
equation because you're squaring the velocity. So if you double the velocity, you quadruple the amount of kinetic energy. So you get a significant increase in small changes in speed because of that speed differential.
Did you do a test with just the hybrid arm contacting the taillight at 24 miles per hour?
Yes.
Did you also do a test with that hybrid 3-arm contacting the vehicle at 29 miles per hour?
Yes.
I
Yeah,
want
we
to
saw
talk
it.
about those two tests. Okay? Can
We
you
saw
explain
it
to the jurors
in
what they're
4K.
looking at? I want to start with going from left to right. What does the E sub K mean in that formula?
So that stands for kinetic energy, which is the amount of energy that an object has when it's in motion and has a velocity to it.
What is the 1/2 on the other side of the equal sign?
Just a constant.
And what does the M, as in Mary, stand for?
So that would be the mass, in this case, the mass of the arm.
And what's the V, as in Victor?
That would be the velocity of the arm as it's accelerated.
Why is there an exponent at the top of the V?
Because you're squaring that. So you're basically multiplying the velocity times itself. So it would be velocity times velocity.
Is this a formula that's traditionally used in accident reconstruction?
Yes, it's very common.
Is it sort of one of the foundational formulas?
Objection.
When did you learn this formula?
Probably back in high school physics.
I'm going to ask you, if you wouldn't mind, to walk the jurors through a calculation dealing with the 24-mile-an-hour test using the 11.86 pound statistical arm as an assumption of the weight of the arm.
Okay.
You understand?
may I have a pen and paper to write?
May I approach you, Your Honor?
Yes.
I have a pad here too, if whatever's easiest.
Okay, whatever's easiest. If you assume the mass of 11.86, that's the statistical arm weight, and you assume the V for velocity is 24 in miles per hour. I don't care about the units, doctor. Just assume 11.86 and 24. Can you calculate this quadratic equation?
Yes.
What do you get? I want to do it step by step. What's the result of squaring 24?
So you're not concerned about the units?
I do not want to talk about units.
Just, okay.
If you mention the word joules, my head will explode.
That's, I didn't know if you wanted, Newton meters, foot pounds. Okay.
Stop it.
So
Immediately.
just 24 squared
Correct.
is 576.
That's funny.
Do you always, in this calculation, do you always use the exponent first? Do you always do the square first?
Sustain.
What's the first thing that you do in solving for this equation?
You would want to square the velocity, but it's ultimately all going to be multiplied. But yes, you would square the velocity, multiply by itself.
What's the next step after you get 576?
Again, assuming we're not concerned about units, you would multiply by the 11.86.
Can you do that for me and tell me the answer?
How many decimal places do you want? Just nearest whole number?
2.
Okay. 6,831.36.
What's the next step once you get that number?
You would multiply by 1/2 or 0.5.
Can you do that for us, please?
That'd be 3,415.68.
What does that represent in terms of the energy into the taillight? I realize that we're not dealing with the proper units, but does that represent anything as it relates to the energy that's imparted on the taillight?
That would be the energy to the arm
Okay,
that's being transferred.
understood. 3,415.68, is that right?
Correct.
And that was at what mile per hour?
24.
Let's move to a different equation.
Okay.
Now I'd like you to presume different numbers.
I don't know what the question is.
Yeah.
Can you do the same calculation using the 9.38 pound arm that you actually used in your testing for the mass?
So we're actually doing
Yes.
the math.
And can you use the velocity
Here we
of the
go.
actual test you did of 29 miles per hour?
Okay. And same thing, not worried about units?
Correct.
Okay.
What's the first thing you do in solving that equation?
So if you square the 29 miles per hour, you will get 841.
What's the next thing you do?
You multiply by 9.38,
What's the number?
7,888.58.
And what's the next thing you do in the equation?
You multiply by 1/2 or 0.5,
And what's that final number?
3,944.29.
That would be the number or the amount of energy imparted on the arm at 29. Is that right? 29 miles per hour?
So ask it differently.
Sure. What is that 3,944.29 number? What does that mean in terms of the kinetic energy?
That would be the kinetic energy that the arm has if it were moving at 29 miles per hour and weighed 9.38 pounds.
One final calculation. What is the percentage difference between 39, 44, 29 and the other test that we just did, or the other calculation, 34, 15, 68?
So in terms of a percent difference, again, when you're subtracting the two and then dividing by the sum divided by 2, so that's basically the average of the sum, it is 14% difference.
Which of the two tests, the two energy equations that you just did, which represents the higher kinetic energy imparted to the arm? The 24 mile an hour test, that's the hypothetical, or the actual test at 29 miles an hour? Which one?
The 29 mile per hour speed with the arm weight of 9.38.
What does that mean, Dr. Wolfe, in terms of the testing that you did with the lighter arm, 9.38 pound arm, at the 29 mile an hour test, as it compares to the hypothetical 24 mile an hour test?
It would be more force and more energy in the 29 mile per hour impact test.
Even though you used a lighter arm? Objection.
Sustained.
And what was your opinion and conclusion as it pertained to the subject taillight using the 29-mile-an-hour test? What was your opinion and conclusion as it pertains to the subject taillight? Was that consistent or inconsistent with the damage that you saw on the 29-mile-an-hour test?
It was inconsistent.
Thank you, Your Honor. That's all I have.
I think this is going to be a quick recross. We'll see. It's not looking like it. Let's see what Hank has to say, because we're going to be here for a minute.
May I, Your Honor?
Yes.
Good morning, Doctor.
Good morning.
Doctor, did you have a chance to speak to anybody from the defense this weekend?
Not over the weekend, no.
After you left here Friday?
On Friday, I let them know that I was returning back home, and then I let them know last night that I had arrived, yes.
Did you receive any new information or have any conversation before you came in today?
No.
Here we go.
Now, when we asked you about weight last week, you did not go into any calculations about the difference between the standard arm, 11.86, and the 9.38, did you?
I don't believe we did, no.
In fact, when you testified last week, at the end of the day, you were asked questions by Attorney Jackson about the weight of that arm, correct?
Yes.
And when you were asked about the weight of the arm, Attorney Jackson asked you if you were asked a lot of questions about the difference in the weight of the arm, about 11.8 pounds statistically as it relates to Mr. O'Keefe versus 9.4 pounds. Do you remember him asking you about that?
Yes.
And you were asked whether you were aware whether anybody had measured the weight of John O'Keefe's right arm. And you responded, I'm not aware of that, no. Do you remember that testimony?
Yes.
And then you were asked, when you asked questions about whether or not his arm was 11.8 pounds, are you aware of anybody ever just weighing just his arm? And you said no.
Correct.
And finally, you were asked, what is that based on, 11.8? Where did that come from? Remember what you said?
Yes.
I don't know. Remember you answered Attorney Jackson and you said, I don't know where that came from.
Right, referring to, I don't know what source you pulled that 11.8 from.
And so you were suggesting that that is just a number pulled out of thin air, right?
Sustained.
Was that a surprising estimate, 11.8 to you?
I don't know that it was surprising. I don't know what your source is for it.
Well, when you engage in accident reconstruction, you never just take somebody's limb and sever it and throw it on a scale, do you?
I'm not usually doing that part of the analysis, no.
So when you're relying on body weight and different parts of the body, there is strong statistical studies that give you a guide, isn't there?
I would agree with that, yes.
Well, the number's just on the thin air. If you're doing a study and you have to figure out damage to an arm or a foot or a leg, and you have to come to an estimated value or weight, you have to get that information from somewhere, don't you?
I would agree, yes.
So you just make it up out of thin air. You have to find a resource, a reliable, vetted resource. True?
I would agree.
And that's what you do.
In some instances, yes.
Well, in this case, you chose an arm that was 9.38 pounds. Where did you get the support that the 216-pound, 6'1" man would have an arm that weighs 9.38 pounds? Where did you get that from?
Well, it's conservative from the standpoint, if you think about one of the equations we talked about last week, force is equal to mass times acceleration. So if we take the acceleration data from our test and we multiply it by a lighter mass, the 9.38 pounds, it's less force to the arm. So now if you want to increase the mass of the arm, you're now talking about a greater net force to the arm. So it's conservative from a force perspective.
Put aside your story about the force perspective. My specific question is,
So it's sustained. Ask the question differently.
I'll ask you again, Doctor.
Can you stand out of the mic, man? Dang.
Where you got the 9.38 pound value from when considering a 6'1", 216 pound man. Where did you get that from so you could be statistically accurate?
It is the mass of the hybrid 3-arm. We saw the photograph that depicted the weight. Again, how you account for that when you're doing the force calculations is you would utilize the acceleration data that we measured, and then you would apply a different mass, in this case, a heavier arm. And I will note, it's the same thing that Dr. Welcher did in his drop test with the hybrid 3 head. He ultimately measured the acceleration of the head, and then to calculate the force, he adjusted the mass of according to Mr. John O'Keefe's mass of his head.
So for the third time, I'm going to ask you just a very simple question. Dumb it down for me if you can, okay, doctor? Where did you get the source to legitimize using a 9.38 pound arm for a person that's 6'1", 216 pounds? Where is your source to say that arm is validated to use for that size man? Where is that?
Again, it's the weight of the ATD arm. That is what the 50th percentile arm weighs. As I mentioned, in our field, it's accepted to utilize the acceleration data, and then you adjust the force based upon an increase in mass.
Is that your answer?
Yes.
Mr. O'Keefe's body weight and size does not put him in the 50th percentile like the 9.38 arm. He's closer to the 95 percentile, isn't that fair to say?
Correct.
And there is, in fact, the 95 percentile crash test dummy, isn't there?
There is, yes.
Yeah. You chose the 50th percentile, which is shorter, yes?
Correct.
Weighs less, yes?
Correct.
And the arm weighs less. True?
Correct.
The truth is, you have absolutely no study, no
What do y'all think
paper,
about that?
no article that supports using a 9.38 arm for a 216-pound man who's 6'1". You have not one reference or study you can offer us right now, do you?
I don't agree with that, because again, if you look how Dr. Welcher did it, he used the 50th percentile in his drop test with the head, and to calculate the force, he adjusted for Mr. John O'Keefe's mass of the head. Same thing is done in this instance with the lighter arm. We adjust for that in the calculations.
You have
Boom, there it is. Don't need to hear anything else. Dr. Welcher did it and he adjusted. I did it here and I adjusted. The issue comes, is the damage going to look the same? We can see the force and what would happen to the arm itself, but is that going to change? I don't know.
one paper, one study. I know the answer to this, but let me ask. You have one paper, one study to support that it is appropriate to use the 50th percentile 9.38 arm for a person who is 6'1", 216 pounds. I won't ask you again, but if you can answer this once for me. Do you have one paper, one study?
So I'll take out the commentary. Can you answer that? Answer that
We
question?
take out the commentary. What does that
Sorry,
mean?
can you repeat the
You
question?
have one paper. Give me a name, an author. One paper, one study that supports using a 9.38 arm, 50th percentile, when you're doing a crash test for somebody who's in the 95th percentile who weighs 216 pounds and is 6'1". One paper, sir.
I don't have a paper because Dr. Rentschler is addressing the forces and the injuries to the arm.
You talked about, however, would you come up with the number 11.8? Like it was something that is curious or foreign to you, right?
Objection.
Sustained.
Are you confused how the number 11.8 would come up?
Objection.
I'm going to allow that.
I'm not confused, I don't know your source for it.
When you do studies, would you agree that the head has a similar weight to the arm and that the weight of an arm would be about 5.48% of a person's body weight?
I'm sure that there's various studies out there that talk about that could be one particular study.
Well, let's talk about one study. What do you think? You're the engineer, you're the expert. When you're weighing an arm by percent, what is the percent of the arm of the total body weight?
I don't know as I sit here today off the top of my head, no.
I'm sorry?
I don't know as I sit here today off the top of my head.
Well, if you don't know the percent of body weight of the arm compared to the whole body, how would you ever come up with a number for the arm?
Well, from the work that I've done with Dr. Rentschler in this case dating back to last year, it's my understanding that his calculation for the arm was approximately 11 pounds.
So you're relying on somebody else's study? You're doing an independent assessment of the evidence, and you're relying on other people's math? Is that what you're telling us?
I don't agree with that because, as I've mentioned numerous times, Dr. Rentschler and I worked as a team on this case. You can't separate the reconstruction part from the biomechanical part. It's an integral part that works together on it.
Would you agree that the arm is about statistically vetted, that it's 5.48% of the total body weight? Would you agree with that?
It sounds about right, but again, I
Okay.
don't have the percentage off the top
So
of
if
my
you
head.
take 5.48% of a 171-pound man, which is the crash test dummy you were using, the 50 percentile, what do you get?
You said 5.48%?
Yeah,
Just over 9 pounds,
okay. Close to 9.38?
9.37.
Okay, now when you have 216 pounds, 5.48%,
11.8.
11.8. Sound about right, doctor?
By that calculation, yes.
Okay. Now, you said you had some confusion where I'd get that number from, this 11.8. Do you remember that?
Yes.
And when I threw out that number, is that the first time you heard of that number?
The 11.8?
Yeah.
Yes.
Or 11, is that the first time you heard of it from anybody, 11 pounds?
Is that the
the
first
number
time
for
you
you?
heard of 11 pounds?
I don't understand your question.
Well, you're
What?
saying that when Attorney Jackson asked you, where did Brennan
Oh
get
my
those
God.
numbers from? You said, I don't know. Remember that on
Correct.
Friday? Do you know where I got the number 11 pounds from?
11.8
Yeah.
or 11?
11.
As I just mentioned, last
This is
year,
crazy.
I believe I testified in a previous proceeding that it was about 11 pounds.
Yes. Your testimony, 11 pounds. Your prior testimony, right?
Yes,
You testified before under oath in this case, didn't you?
correct.
And when you testified under oath and you were giving a general estimate about the pounds of Mr. O'Keefe's arm, based on your experience and your training, you said it was around 11 pounds. Those are your words, right?
Correct, yes.
Under oath,
Yes.
right? You can't delete something that's under oath, right? And so when you feigned
can laugh,
confusion on
dude.
Friday
I'm
about
with you.
this 11 pounds,
Sustained.
so when you
Hank
answered
is-
questions
he's
last
crashing out,
Friday about
guys.
wherever this 11.8 pounds came from, you weren't so confused about that because you've used 11 pounds before yourself, haven't you?
Yes, but again, I don't know where you got that 11.8 from, so.
Well, we just
but-
did the math, didn't we?
Yes,
Okay. And you used a calculator to help you, didn't you?
I did, yes.
Calculator works.
Yes.
Okay.
This
You
guy
said
is
you
looking
wouldn't
crazy.
calculate the difference, but you did. And so what you just went through this exercise is you divided that difference, that 2.48 pound difference, right?
Correct.
And then you divided it by 11.86. Divide 2.48 by, from the 9.38.
Okay,
What percentage do you get?
26.
Hank
Would
is
you
looking
agree with this
crazy.
statement about whether the arm and body weight, comparing the weight of the head to the arm, would you agree that the head and arm are actually almost identical because your arm, just one of your arms, including the hand, forearm, and upper arm, is about 5% of your total body weight? So for someone who weighs 216 pounds, that's about 10.8 pounds. Would you agree with that?
I didn't do that calculation, so I,
Didn't ask you. I'm asking if you would agree with that.
can you repeat the question, please?
So ask the question.
Does the arm weight weigh the same as the head? or the arm does weigh the same as the head, almost identical, because your arm, just one of the arms, including the hand, forearm, and upper arm, is about 5% of your total body weight. So for someone who weighs 216 pounds, that comes out to about 10.8 pounds. Would you agree with that?
I haven't done the calculation, but if the math checks, then yes.
Okay. Would you agree with this statement? The heavier the object, if it gets hit center mass, that's going to be even greater force, because that is more mass than just 11 pounds. So the acceleration is the same for each body part. It just depends on the weight of the body part and how heavy it is to determine the force that's actually exerted on the body. Do you agree with that?
Objection. Source.
I'm going to allow the question.
Do you agree with that?
Yes, and I think I described that a little bit earlier, is you would,
Yes, so what's
you
your
would
point?
increase the mass, you multiply it by the acceleration, that's going to increase your force. Force is equal to mass times acceleration.
Right. So mass has a direct correlation to force. You agree?
Correct.
So therefore, the heavier the object, if it's colliding at the same speed, will create more force than a lighter object. You'd agree
Correct.
with that, wouldn't you?
Correct. More force on the arm, yes.
Right. So weight matters, doesn't it, sir?
We're back to the weight
Yes.
matters. Oh my God.
Force is mass times acceleration. So if the arm weighs the same as the head, you're still going to get the same force. And so inevitably, you change the mass, you change the weight, same speed, it changes the amount of force.
Correct, yes.
Yeah, okay. When you did calculations in this case, you never took the estimate of 11 pounds, although it didn't exactly calculate the 5.48. You never took that 11 pounds and determined the percentage difference between the mass in that arm and the mass in a 9.38 pound arm, did you?
No, I did not.
You didn't include it in any of your PowerPoints.
No.
You didn't explain it to the jury that there's a difference in weight matters.
Again, that's something that Dr. Rentschler is going to discuss.
I'm asking you because you testified, you gave opinions, you got a PowerPoint. Did you explain to the
Hang
jury
in there, Dr. Wolfe.
about the difference in force when there's a change in weight?
Hang
You
in
did
there,
all your
buddy.
PowerPoint and calculations. Did you
Dang.
break it down for them?
Well, I think it was certainly stated. I mean, I know that we went over Newton's second law, force is equal to mass times acceleration, right? So if you increase that mass number, it will increase the force.
When you were putting up your PowerPoints with the speeds, did you explain to us that there's a difference when you change the mass so that if you used a lighter arm, there would be a difference in force? Did you explain that to us in any of your slides?
I don't know that I explicitly stated it, but again, that's why we went up to 29 miles per hour to account for that difference in weight.
Were you trying to inflate the force for the speed of test so it looked like the collision had to happen at a faster speed to cause a certain amount of damage? Were you doing that intentionally?
No.
You didn't overstate the mass. You didn't use an arm that was 14 pounds that would have created the opposite illusion, right? You used a weight that was lighter than Mr. O'Keefe's estimated arm.
Right, because again, it goes both ways. If you increase the mass of the arm, you increase the force on the arm. So there's going to be more force acting on the arm.
Let's talk about your studies with
This is not
Mr.
doing.
O'Keefe's sweatshirt and his arm, and you gave some opinions about what you would expect
Gosh.
for damage to his arm. When I asked you on Friday whether you had any support, any vetted journals, learned treatise, any support whatsoever about whether you should use a crash test dummy arm for these types of studies, you didn't have any support on Friday. Do you have any today that you can refer to?
No.
Putting aside the fact that you have absolutely no professional studies or journals to support that you should be using a crash test dummy's arm for these type of tests, are you aware of the expert literature in this case that the opposite, you specifically should not use crash test dummies when you're trying to do this type of analysis on clothing and a person's body? Are you aware whether that exists?
I'm not aware of those studies, no.
As a inquisitive engineer, wouldn't you want to know if there was legitimate
As an inquisitive
study
engineer.
in your work, in your profession, that suggests or states that you should not be using crash test dummies to determine injury to the arm as far as lacerations? Would you want to know that?
I think, again, you're getting confused between my role and Dr. Renfro. Can I finish, please?
No.
Objection.
Okay, so,
No.
no comment, Mr. Bennett. Answer the question, please.
I wasn't addressing the lacerations or the abrasions to the arm, sir.
You had photographs and you were opining that you would have expected or you would not expect there to be abrasions or cuts on that clothing in your tests A and B, didn't you?
There were no holes or cuts in the material, no.
I understand, but you offered opinions. Didn't you offer to the jury an opinion that the abrasions on Mr. O'Keefe's arm were inconsistent with your tests in A
Dang,
and B?
Hank said no. He thinks he's in charge.
The cuts and the holes
Crazy.
are inconsistent.
Oh my gosh.
Sir, when you are assessing cuts and holes on clothing, you need to make sure the predicate as a basis that you're using the right properties, right?
I would agree with that.
Right. And so if there was literature directing that you should not use a crash test dummy to assess injury on an arm, would you follow that instruction or would you do it anyways?
Again, you keep saying injury to the arm. I was looking at what happens to the material when it makes contact with the taillight.
A crash test dummy's arm is harder than a human arm, isn't it?
Yes,
You push a human arm, it's like an indent. You can push in, can't you?
yes.
And that property of pushing in, if a cloth is on it, it is easier for a cloth to tear pushing in than if it's hard. Isn't it?
I don't know that I agree with that.
Well, do you disagree with that?
Well, the hybrid arm is of vinyl flesh, so it's not rigid.
Do you disagree with what I just said?
Can you repeat your question?
Sure. Human
Dr.
arm,
Wolfe's getting
softer than the
annoyed.
hybrid, yes?
Yes.
When you push it, you can push in, much different than the hybrid arm, which is stiffer, yes?
I don't know what you mean by much different, but there will be a difference, yes.
Well, is it a noticeable difference to you if you push a hybrid arm as opposed to a human arm?
Yes,
When you push a human arm, it indents,
He
yes?
said no.
correct,
And so if you push with cloth on, the cloth indents, yes?
correct.
Which creates an easier, tear in the fabric with less force if you can push in as opposed to a hard arm. Would you agree or disagree with that?
I would agree with that.
So when you're replicating studies and giving opinions about a person's arm, a real person's arm, using a hybrid arm doesn't seem to be an appropriate standard, does it?
I don't agree with that because, again, when the taillight breaks in the test, the arm is now moving with that taillight. So it's,
Hank is
again, like we
throwing a
talked about on
temper
Friday,
tantrum.
you'd somehow have to have those fragments accelerating at a greater velocity to penetrate that.
We're going to get to that, but I'm talking about the stiffness. Let's get back to the appropriateness of using a crash test dummy. Now conceding that a human, it pushes different than the crash test dummy, would you agree that a crash test dummy is not an appropriate tool to use when determining tears in clothing on somebody's arm? Would you agree?
I don't think I would agree with that, no.
When you used the crash test dummy in test A and B, that was the 5'9" dummy?
Yes.
When you considered tears to clothing, you bought a new sweatshirt that was similar to Mr. O'Keefe's, an extra large sweatshirt?
Don't know if I recall the exact size, but I think one of them might have been extra large.
And then you bought a second one that was medium. So when you used the smaller dummy, you weren't actually using Mr. O'Keefe's size of extra large. You used a medium sweatshirt, yes?
Yes.
Does the
Because it
sweatshirt
was
size
a
matter?
smaller dummy than the size of Mr. O'Keefe. That's why you needed a smaller sweatshirt, yes?
I think it was more or less just what we could get our hands on.
Well, you had an extra large and a medium. You didn't put the extra large on in test A and B.
This is
did you?
crazy.
I don't recall off the top of my head what sizes were on each test.
Okay, could we show a picture of A to remind Dr. Wolfe?
This matters not. Does this matter to y'all?
And while she's pulling that up, is there a difference between, so it's, see that's how that's blue? You see that's medium?
Yes,
So the blue ones that
We love blue.
you use for test A and B, correct?
correct.
The smaller crash test dummy than Mr. O'Keefe, the 5'9" crash test dummy, yes?
Correct.
And then when you used Randy and brought him into the scene, you used the extra large, the gray one.
Correct.
Right, so you used a different one because it was a smaller anatomical doll than the size of Mr. O'Keefe, yes?
We used different sizes. The material blend was the same.
This was new.
Correct.
The extra large you put on Randy was new.
Correct.
Did you consider that the wear and tear on Mr. O'Keefe's sweatshirt, the extra large sweatshirt he was wearing that night?
The wear and tear?
Yes, the wear and tear.
No.
Did you ever consider the differences between a brand new sweatshirt and one that had been worn?
Oh my gosh.
Had you ever had clothing, sweatshirt you used repeatedly, maybe put in the dryer, wears it down? Sometimes you can get holes more easily. Did you do any type of analysis on that whatsoever?
No, no longer.
Any type of analysis whatsoever on the age or whether it's stretched the same, anything like that?
No.
No variables whatsoever on the sweater, did you?
No.
Okay. Does it matter whether or not the sweatshirt is tighter or looser or how it fits the body? Is that any part of your consideration?
No.
Have you ever done testing like this before for clothing?
In terms of impacting a taillight?
Yes.
No.
So this is the first time ever that you've done this type of analysis and offered an opinion in front of a jury on this?
Specific to impacting an arm with a taillight, yes.
Before you decided to come in and give an opinion, did you take any study or look at any journals on fabrics?
No.
Did you consider any of the variables that one would want to consider regarding fabrics before you came in and gave this opinion?
No.
Did it concern you when you were coming in to give a professional opinion about something you've never done before, whether or not you were studied in the area before you did it?
Well, I think I relayed my observations from the test, right? I certainly explained how we set up the arm, how the arm was closed. You all obviously saw the impact testing to the arm, so I'm relaying my observations from the test that we did.
Did it concern you that you were coming in to give an opinion on something you have never done before, and that you did absolutely no study on fabrics or any of other people's analysis on fabrics in cutting? Did that concern you?
No.
So you were comfortable just coming in with no experience in this whatsoever, without even studying or doing any research? You were comfortable to come in and just throw out an opinion?
No, again, and Dr. Rentschler is going to address part of this. Again, we worked as a team, so there's a synergy between the two of us.
Well, putting aside the synergy, you're the one on the stand under oath, yep?
Correct.
You're the one testifying, giving opinions to this jury, yes?
Yes.
You're the one asking them to rely on your experience and training, true?
Correct.
You're the one asking them to rely on your judgment and your effort to be accurate, yes?
And your data.
Yes.
So when you give the opinion, you have a personal responsibility to support that opinion, putting aside Dr. Welcher or Dr. Rentschler. You have a responsibility for your opinion, don't you?
I would generally agree with that, yes.
Generally?
Yes.
Well, when wouldn't you? When would not be general? Don't you have an obligation every single time you take the stand and give an opinion to be supported, valued, vetted?
Yes,
Every single time?
and again, Dr. Rentschler is addressing those abrasions and lacerations, which certainly correspond to the material.
Right. But you didn't wait for Dr. Rentschler. You offered a number of opinions to this jury. You personally, under your name, you came in and presented yourself as an
'Cause he's-
expert in this subject. You, didn't you?
Correct.
So putting aside Dr. Rentschler, his opinions, do you stand behind your opinions?
Yes.
Okay. And you do that despite the fact you've done no study, no research, haven't vetted, and have no authority whatsoever?
Yes.
I don't think the jury's going to see that he
You wrote a
doesn't have
report back
authority,
on
though.
February 12, 2024.
Those are Hank's words, not.
Correct.
In
It's not
February 12, 2024, do you remember talking about injuries to the arm and damage to the taillight?
Generally, yes.
Okay, that's fair. Do you remember writing in a report, it is significant to note that the injuries have been classified as abrasions and analysis of the autopsy photographs indicates minimal bleeding or lacerations of the dermis?
So the report that you're referring to is a joint report authored by myself, Dr. Rentschler, and Mr. Scott Klein. So that would have been a portion drafted by Dr. Rentschler addressing the injuries.
I see. So in this report, it has your name, Dr. Rentschler, and another person, Scott Klein, yes?
Correct.
But in the report, none of you ever differentiate which opinions you're standing behind or somebody else's, right? I'll move on.
The objection is sustained.
I'll move on.
The objection is sustained.
Did you agree with that?
Dang, Baz. I'm getting snippy, too.
Sustained.
Did you write or endorse these injuries would not result from impact with a non-damaged tail lamp cover and the amount of force required to fracture the tail light cover?
So I'm gonna see you at sidebar.
Dang, it's getting. Oh. This reeks of desperation. I have not seen a cross-examination breakdown this bad this entire trial. Hank's gotta pull it together, man, because now as a juror, I'm getting distracted by your constant disrespect, attitude. Hey, you're not even making good points at this case. That's two sidebars. Let's see if Hank can pull it together. It's looking awfully desperate. That's two sidebars. Man. Yeah, exactly. Amy said two people can't testify at the same time. If they did the report together, Dr. Wolfe knows what he's talking about. Said I took my piece of the report, put it together with my colleagues, and we came to this conclusion. Yes, I can say based
You
on
asked
that,
questions about impact with the tail light.
this is what
In
happened.
fact, in one of your answers to me today, you talked about
Hank knows it's over.
after a vehicle collides with a pedestrian, there's continued movement between the vehicle and the pedestrian, isn't there?
Correct.
And so while glass or plastic that shatters from a taillight might not impale clothes of the skin, would you agree if your dummy wasn't restrained, when the Lexus collides with the dummy, there'd be continued contact for some time, extended contact between both the dummy and the taillight?
What?
Well, the arm, as is demonstrated in the test, would be moving at roughly the same velocity as the vehicle.
Yes. And don't you think that the vehicle would continue to drag the arm until the body either was thrown or spun off? Would you agree with that?
At some point, they will separate, yes.
At some point, but before the at some point. What I'm asking is, at the collision, when you see all the taillights shatter, right, wouldn't the Lexus, if it continues at that speed, say 24 miles per hour, for example, it would continue to drag with that dummy's arm longer than is shown in those experiments because the dummy is restrained?
Sorry, can you repeat the question?
Yes. Would you agree that if a Lexus is backed up at 24 miles per hour and hits the dummy's arm and the taillight shatters?
Basically, what he's saying is if it were a real person, right, you would hit. Hank is assuming that the right arm would hit and then the body would continue to just roll like a cartoon or like we see in the movies dramatically on the car and then fly off at another point. That's what he's trying to say. I don't know why he's having such a hard time with that. But the answer is that something you can recreate without actually hitting a person at that speed? I don't know.
the dummy wasn't restrained and moved regularly. it
Should have
would
named the dummy
extend
Hank.
the
That would have been
contact
perfect.
between that shattered taillight and the dummy's arm. Do you agree with that?
It would move with the vehicle until it got pushed out of the way, just move to the side,
And
yes.
so what you're saying is it would move with the vehicle but wouldn't touch the vehicle?
Well, in the one test, if you remember, because of the restitution effects, the arm reached a speed of over what the impact speed is. So in some instances, it actually might move at a speed greater than the vehicle.
Fantastic. In some instances, would it move slower and be dragged by the vehicle's broken taillight?
Dragged?
Yeah,
I don't know
so
if
when
I
say
understand.
drag, push. How about we use the word push? Pushed by the broken taillight. Could that happen?
The arm would move with the taillight until it moves out of the way.
So you're saying it would move with or faster, but never would slow down where it gets pushed by the car?
It's moving with the vehicle, sir. I don't understand your
Well,
question.
no.
Nobody. I understand it. He's just
Sometimes moves even
really bad
faster.
at asking questions.
Space between the broken taillight and the arm. That's what you're suggesting, right?
Correct.
So it can move with, it can move faster. Can it ever move slower and the vehicle pushes and drags against the arm?
I mean, it might be able to move a few miles per hour if it doesn't have as much of a center of mass hit, but it's still going to move out of the way because it's on a joint.
I understand, but before it moves out of the way, could it be pushed by that broken taillight? That's the simple question I'm asking you. Could it be pushed by the broken taillight?
Just moving adjacent with the taillight, just moving along. Yes.
Amy said maybe the dummy was a stunt actor.
Would you agree with this?
Yeah, Hank is his.
You have an arm struck at 25 miles per hour, significant more damage to the significant more damage
It's embarrassing.
that taillight shatters, hits and moves forward into arms, parts of taillight pushed into arm as vehicle pushes forward and pushes arm out of the way. So the word push, would you agree with that general characterization that the broken taillight can, in fact, push the arm?
Sorry, guys.
Would you agree with that?
Generally, I guess, again, it would move with the vehicle, the arm together.
Not move with, I'm asking you if you would agree about pushing. Would you agree with that?
No. He already explained this. Look
As
at
long as
his
we're on the
face.
same page about it, it's pushing the arm, but it's with the vehicle. They're moving together. So, but in essence, yes, the arm is being pushed due to the fact that there's a force on it.
And the pushing could have that arm in contact with the broken pieces of a taillight if the taillight broke, correct?
Just moving at a common velocity.
No.
The operative
Hank, you're
word here
asking
is push.
you're
And
asking
so you'd
stupid
like to agree
questions,
with me, You
dude.
could disagree with me. Can the broken taillight push the arm so it contacts and provides force against it? Could that happen?
Yes.
Oh my God, this guy. What is he doing?
When you were showing those photographs today regarding Test F, now you used Randy in Test F, right?
Correct.
How tall is Randy?
He's 6 feet.
And he weighs 200 pounds?
Correct.
So still 16 pounds less than Mr. O'Keefe, yes?
Correct.
And you keep referring to Randy as a crash test dummy. Randy's no dummy, right? He's a mannequin.
He is, but he signifies basically what happens when you
You
have
know
two-
what he was thinking there? He said, "You're a dummy." We know what that smirk means, Dr. Wolfe.
Randy as a crash test dummy. Randy's no dummy, right? He's a mannequin.
He is, but he signifies
That's hilarious.
basically what happens when you have 200 pounds of mass striking the rear of that vehicle.
I don't want to misrepresent Randy. He's not a crash test dummy, is he?
Well, it wasn't used for biofidelic purposes. It was to, again, what happens when you have 200 pounds of mass strike the vehicle.
So when you've been referring to Randy as a crash test dummy, you don't mean to do that. That's a misnomer, isn't it?
I don't know that I agree with that.
So you think that
I think, oh man, I think it's a missed opportunity by the defense. Why doesn't the defense ask Hank Brennan why he didn't have Dr. Welcher get hit or Shannon Burgess get hit at 24 miles an hour to have a conclusive? Why are we're cool with the blue paint in that case? The defense, they should have doubled down on that. Oh, you just got nudged. So we're going to assume that that's how things would have happened. There's so many what ifs even in that analogy. What if John at the last minute moved his arm up a little bit? What if John turned some? What if John tried to duck down? Yeah, so Dr. Welcher, since we're having such an issue with the 16 pounds, 200 pounds, 216 pounds difference, why don't we just get a human being? We'll have someone volunteer. I mean, heck, y'all paid Aperture $300,000. That should be enough to recover in a few weeks off. Just hit them at 24 miles an hour and we can end this conversation. Because if you want to tell me someone drunk with a glass in their hand is going to see or hear or sense a car is coming, backing up at them at 24 miles an hour, and they're just going to stand there with their arm like this, boom. Dude, come on. Come on, dude. I don't know what Hank is trying to do here. We're questioning the technique when there's your own technique that you use to try and prove your theory is full of so many flaws. Come on, man.
Randy is a crash test dummy. He's a certified, approved crash test dummy.
I say we started.
No, and I think I made it very clear that there is no instrumentation on it, right? And one of the reasons why I mentioned that is those ATD dummies are $150,000, so we're not going to risk impacting it with the Lexus and destroying that.
I can understand the cost analysis for you.
Yeah, they didn't get $300,000.
He's a mannequin. It's used by firefighters and drills pulling a body, dead weight, out of a house to replicate certain scenarios. That's what Randy was made for, yes?
He can be used for those, yes.
Right. He's not a crash test dummy in the parlance of a legitimate, studied crash test dummy, is he?
He's not a human being either.
I don't agree with that because, again, we use that type of dummy in all different types of tests.
There's an H395M PED, which most closely replicates John O'Keefe's size and body, isn't there?
Correct.
You didn't have that when you did the test, did you?
No.
When you do crash tests, you can put a magnetic control on the crash test dummy, so upon impact, it releases and is thrown. You could do that, couldn't you?
That is one way, yes.
Right. So that way you don't have to put the dummy on a forklift, and then it creates a different scenario than real life, correct?
That could be one way that you could do it, yes.
It doesn't impede any roll or drag when the dummies hit.
We got to hit somebody at 24 miles an hour.
Forklift, yes?
I'll do it.
Correct.
Also, it might show some throw, which could lead to other type of damage like holes in clothes, yes?
I don't weigh 216
Correct.
though. That's going to
But
be
you
a problem.
didn't use the magnet. You used a forklift.
Because again, the purpose of the test was to evaluate, we talked a lot about those time frames, right? That 10 millisecond window. It's to look at, from the vehicle damage perspective, what happens to the taillight, right, in that interaction. And then ultimately, what is the acceleration that the arm experiences in that 10, 15 millisecond window, right? What happens 1 second after, 2 seconds after? Again, that wasn't of concern for me in my analysis.
You didn't use a magnet. You used a forklift, right?
Correct.
And when Randy went for a ride, you didn't
My
expect him
testing's
to
better
break
than
off
your
the string
testing.
and slide across the street, did you?
We didn't expect him to.
You didn't expect him to be thrown. You didn't expect the string on the forklift to break and then Randy to go flying. You didn't expect that, did you?
Oh, I certainly expected that.
So you expected a throw with that.
Yes.
Okay. And the street has hard concrete and it has a lot of irregularities to it, doesn't it?
It's asphalt, yes.
Yeah. And the photos that you were shown today on redirect examination, did the defense show them to you during your direct examination? Any of those?
No.
Jeez, this is exhausting, man.
Gilman, can you pull up that last exhibit with Randy on the ground?
Embarrassing, in my
I think it's
opinion.
exhibit 221. Okay. And so this is Randy, right, doctor?
Yes.
Zoom in a little bit, please. What's that red thing near his shoe?
Appears to be a fragment of the taillight.
can you zoom out? Could you go back an exhibit to the one before? Could you zoom in? Did you see any tail light fragments on his body or in his clothes?
I can't tell from here.
Could we have the exhibit before, please? Can you tell from here?
Yes.
In finding taillight fragments on the clothes after a collision, that's not unique, is it?
Unique? No,
Yeah.
it's possible.
Well, according to this, it's probable, yes?
In this test, that did occur, yes.
Could we have Exhibit 201D, please? Do you know what this is, doctor? Did you see this picture in your analysis?
Don't know if I recall that specific photograph.
Do you know this
messed
is
it up.
taillight shards found in Mr. O'Keefe's clothing?
Objection.
Sustained.
Did you
How would-
consider this
how would he know
photograph
that?
during your analysis before you gave your opinions regarding cuts and tears and lacerations?
No.
No, sir.
Can you take that down, please? When you did your analysis, did you know that a drinking straw was found on the concrete on the street in front of 34 Fairview?
I don't know if it was on the concrete, it might have been on the asphalt, but I do recall a drinking straw, yes.
Did you know that there was a glass found near Mr. O'Keefe? Could you put that up, please, Cindy?
Objection.
Sustained.
Did you talked about cuts and injuries. Did you,
Sustained, it sounds like it's beyond the scope.
very well.
It is. He did not talk about any bruises. You got to ask
When
his
you
colleague.
did test D, did you say the peak acceleration was 780 Gs?
Your Honor, may I refer to my notes?
Yes.
He didn't even ask Hank. He said, Your Honor.
Page 11 of your report.
I think I lost an exhibit.
This is good, though. This is a good cross-examination. Or recross. On Dr. Wolfe's part.
Okay.
Is that what you described it as?
For test D,
Yes.
the acceleration of, we talk about the hand,
Yes.
780 Gs, yes.
780 Gs. Okay. When you did your
Haven't
comparison
proven their
before you
case.
gave your opinions, you showed us a scuff on the exemplar vehicle, photo 77.
Objection.
Beyond the scope, Mr. Brennan.
Stop asking him about injuries, dude.
A few more questions, Dr. Wolfe.
Oh, thank God.
You showed us holes in Randy's sweatshirt from Test F. You remember that?
Yes.
And you talked about what you would or wouldn't expect in a collision as far as holes. And did you say something like that was inconsistent with Mr. O'Keefe?
Yes.
That's what you said on redirect, right?
Correct.
Okay. Did you consider whether there were holes in Mr. O'Keefe's sweatshirt separate from the holes in the arm?
Sorry, can you repeat the question?
Yes. When you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm?
Well, I know that there was cutting to the,
May I approach and retrieve the exhibit, Your Honor?
Yes.
Excuse me, sir. ever look at the back of the sweatshirt to see if there was any holes to the back of the sweatshirt other than the right arm when you formed your opinion?
I don't recall.
Take a look at the back. Do you see other holes on the back of Mr. O'Keefe's sweatshirt?
It appears I see one hole.
There you go. Say nope, I don't see it.
I'll direct you to here, 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 here. Do you see more than one hole in the back of Mr. O'Keefe's sweatshirt?
Yes.
I would have been like, nope. Sure don't. Sorry. Can't help you.
When you were forming your opinions that the collision would be inconsistent to damage to Mr. O'Keefe's sweatshirt, did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, in looking at those holes, they're inconsistent with road rash. And again, to get those kind of holes, you have to have prolonged sliding contact on a rough surface.
Did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, if you just fall and land on your back, you're not going to be sliding to get those abrasions and tearing. And again, those are not consistent with road rash.
Didn't ask that question. Did you consider?
Sorry, can you?
Did you consider whether Mr. O'Keefe had fallen or landed on his back?
No.
Did you know about or consider the multiple holes on the back of his sweatshirt when you came and formulated your opinions?
No.
You did no studies whatsoever about the damage to the sweatshirt if he fell or landed on the cold, hard ground and had broken taillight shards in his clothing, did you?
No.
I have no further questions.
Thank God. Goodness gracious, that was brutal, y'all. How are y'all feeling about Hank? You know how I feel about that one. Oh my goodness.
If I may, Your Honor, very briefly. You were asked by Mr. Brennan, give me
Here we
one
go.
name,
What you got,
one
AJ?
name, very dramatically, of someone,
The objection sustained.
you were asked to give me one name to support using a 50 percentile hybrid 3 in testing forces on a 216-pound man. Do you remember that question?
Yes.
How about the name Judson Welcher? How about that name?
So the objection sustained.
Did Judson Welcher use a 50 percentile hybrid in his drop test?
Objection.
So that's
Yes.
sustained as to form.
But he opened
What
the
did
door.
Judson Welcher use in his drop test?
A hybrid 3 50th percentile male, the same that we use in our testing.
Again, makes no sense. Stupid cross-examination. Terrible.
You were also asked
You don't have to be a lawyer to see that.
whether or not using
Jesus.
that hybrid 3 arm with the same speed would have an effect on the force equation, on the force calculation, correct?
Correct.
And you agreed it might have a small effect on the force calculation, correct?
So sustained as to form.
This is just foundational, Your Honor.
Sustained as to form.
How did you answer that question?
I'm sorry, can you repeat the question?
Sure. Let me ask it this way. In the 29-mile-an-hour test with the hybrid 3 arm, were you going faster than 24 miles an hour?
Yes.
And what was the calculation again on the increased force that would be exerted on the taillight, on the arm area of the taillight? 14%?
Yes.
So sustained.
How much, what was the percentage that you calculated? The increase?
14%.
And did you find damage, even with the increase of 14%? Did you find damage on that exemplar taillight consistent with the extensive damage on the subject SUV?
Objection.
I'll allow it.
No.
There you go.
Can we have 201D put up one more time? Mr. Brennan just asked you if you made note of these little red pieces, correct?
Correct.
Do you have any idea the size of those pieces? As you sit here.
Not without a scale of some sort, no.
So as you sit here, do you have any idea what the size of those pieces are?
I couldn't tell you as I sit here today, no.
No idea if they're a foot long?
Objection.
So the objection sustained.
You were asked, when shown this picture, if you accounted for this in terms of damage to the garment, the sweatshirt, right?
Correct.
What if I told you those were,
Objection.
So the objection's sustained. He said he doesn't know the sizes.
Mm-hmm.
That's the end of that, Mr. Jackson.
I realize he said he doesn't know, he was
That's
asked questions,
the
Your
end
Honor.
of that, Mr. Jackson.
Do you have the, Mr. Wolfe, do you have the picture of the tin? The TIN, tin, the little round tin?
10. He's saying 10. These accents, man.
Do you see that tin?
Yes.
Are you aware that all those pieces are inside that tin?
Objection.
Sustained. And jurors disregard that.
Did you ever see this tin in your analysis?
I do recall seeing, yes, in the evidence photographs of all the fragments, yes.
In your experience, are very large pieces or very small pieces put in little tins, about 2 inches wide?
Sustained.
You were asked a question about the arm being pushed by the taillight. Asked a bunch of questions about that, right?
Correct.
You indicated, what did you say in terms of the contact by a vehicle pushing an arm?
It's going to move with the vehicle until it separates.
In your testing, how long did it take the Hybrid 3 arm to get up to speed of the vehicle in the 24-mile-an-hour test? About.
Good question.
About 10 milliseconds.
I'm sorry.
Very
say that
quickly.
Again, louder.
10 milliseconds.
10 milliseconds, correct?
Correct.
So when you say the arm is being pushed, it's being hit, correct?
Objection.
The objection sustained and it's struck.
In every one of your tests, every single one of your tests, did any taillight fragment tear a hole in the sleeve of the shirt that you were testing?
No, there was no holes, punctures, fraying, nothing to the material.
Was there ever a defect in that garment in any of that testing other than the road rash that we saw in the 29-mile-an-hour direct impact?
That the only test that showed the holes and the abrasions was that full-on hit where the body was sliding on the ground. There was no test where the taillight caused any type of punctures, holes, or fraying to the material.
And in that test, what happened to the back of the license, the test license?
Destroyed.
Wow.
You heard I have follow-up questions.
Okay, go ahead.
Oh, wow. So we're going the sidebar already? Why? Let's skip ahead here and see what's going on.
On redirect, you again talked about the impact between an arm and the broken taillight.
Correct, yes.
And I had asked you on cross-examination or recross-examination whether that broken taillight could push the arm, which of course would create force or friction, yes?
Well, once it's moving at a common velocity, I'm just not understanding your question then.
If it's not a common velocity, if the broken taillight is,
Ask the question.
if the broken taillight is pushing the arm, which would mean the broken taillight is going at a faster speed than the arm. If it pushes the arm, the broken taillight can come in contact with the arm, can it?
It's moving with the arm, sir.
Okay, let me ask you this. Would you agree with this? If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So if you have the taillight coming in, it's hitting the arm, it's moving forward into the arm. Do you agree with that?
Objection, I'd like the source.
No,
Dr. Rentschler, do you agree with that?
Objection.
so I'm going to allow it, strike the source.
And that's the
agree
third
with
sidebar,
that?
by the way.
I'm sorry, can you repeat?
I can. If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, specifically if there's a taillight that shatters, so you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm. Would you agree with that?
Objection.
I'm going to allow it.
In reference to the greater damage, are we talking about damage to the arm?
It's a good question.
Do you
Damage to
agree with
what?
that phrase?
I don't understand the question.
The best way I can characterize is it's moving with the arm, sir.
So if that actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way.
Objection.
Do you agree with that?
I'm going to allow it.
No, we need to approach. I need to approach.
That's number 4. What tier are we at right now? Team 0 to 5, I don't think y'all are going to make it. These sidebars are going crazy because this line of questioning is insane. Just like that, we're at 4.
I'm going to read this one more time, okay?
Okay.
Would you agree? If you have an arm that's actually struck at 25 miles per hour, you're going to have significantly greater damage, especially if there's a taillight that shatters. So you have the taillight coming in, it's hitting the arm, and it's moving forward into the arm.
These questions
So
are
if that
crazy.
actually caused fracture of the taillight, then parts of the taillight are going to be pushed into the arm and likely embedded into the arm as the vehicle continues forward and pushes the arm out of the way. Would you agree with that?
Again, my area of expertise is not injuries to the arm, so whether or not those fragments would be embedded or cause any type of damage to the arm, no. But what I would say is that I would agree with the taillight being pushed into the arm. It's going to cause the taillight to fracture, and then the arm will move with the taillight.
When you do a demonstration, isn't this exactly what you see? Could you play E again for me? Isn't this exactly what you see? Play that, please.
No, that looks like it's hit.
And now,
whatever.
stop, please. If Randy is not restrained by a forklift, he is going to move with the car, correct?
If it's a side swipe, no.
Well, if it's just the arm, his arm's going to get accelerated and move, and then his body will be there still.
And that broken taillight,
Exactly.
if Randy is not restrained on a forklift, is going to be pushed, like this says, by the arm, by the broken taillight.
Not necessarily.
It's going to move with the arm.
Thank you.
All right, so jurors, we're going to take a morning recess. We'll see you in about 20 minutes.
We're gonna skip through the morning recess, but man, I gotta hear y'all's thoughts on this, man. Goodness gracious. I don't know if we're going to have redirect at this point, but Brennan, you gotta get it together, man. You're not making your points. The points aren't hitting. We've looked at it. We've used your theory, and based on your theory, based on the Commonwealth's theory, it's not adding up. And then you want to try and discredit the weight of the arm when your own witness, your own testing, your own theories was done using the same arm. I think he's just ruining his entire case, in my opinion. Y'all let me know what you think. We're going to skip through this break and go ahead and get Dr. Wolfe back up here. But first, I got to say big shout out to Amy. She's over there dropping the super stickers. She dropped the banana. Oh my goodness. Is it that time already? And then over on the Cash App, we've got Brenda in the building. Shout out to Brenda Bonamy with the 10 bomb. Says, thank you for your coverage. Thank you for being here, Brenda. Slim Life as well. Drop the super sticker. She big mad. He said, get this clown out of here. It's embarrassing. He's ruining his own case. I'm sorry, ClassE can't hear you because I gouged my ears out. Green man, just get some earplugs. All right, it's okay. It's not. You need your ears, brother, because we've got some good stuff coming up. Hank is ruining it right now. I know. You're only hurting yourself here, Pee Wee. Yeah, this is I am not. I don't get it, guys. I do not get it. I don't get where he's going. I don't get the point he's trying to make. It's embarrassing. Amy says, ugh, Brennan's voice is like fingernails on the chalkboard. That is an understatement, to say the least. And then, of course, we got 4 sidebars already. Let's go ahead and skip through it. We're going to skip through the morning break. We lose all of our delay here, but we got to figure out what's going on. Of course, we've got the voir dire that we were talking about earlier. Oh, Slim Life sent something over on PayPal. Hold on a second. Let me see. We got a PayPal. Shout out to Slim Life. There it is over on PayPal. Says handsome, beautiful tax. No taxes taken. Laugh out loud. Thank you guys for all you guys do. Thanks for all you guys do. Thank you, Slim Life, for dropping that 5 bomb over on the PayPal. I appreciate it. Yeah, a lot of y'all like to send Cash Apps and PayPals because there's no YouTube tax on that. Shout out to YouTube for the great platform, but I'm not mad if y'all decide to send Cash Apps or Super Chat and our Cash App or PayPal instead of Super Chat. So thank y'all, and I appreciate the support. Double dip in Slim Life. Thank you, thank you, thank you. All right, let's go ahead and get into this voir dire and see what's going on. I'm probably saying it wrong. Voir dire? Voir dire? Thank you, Mr. Brown.
All right, so I'm told counsel wanted to see me.
Your Honor, issues has arisen related to the cross-examination or re-cross-examination of the last witness, and Mr. Alessi would like to address in detail about that.
All right, so the last
second,
witness
guys.
was your witness? Is there a reason?
This is a separate issue.
Give me 1 second.
Okay.
Thank you,
What do
Mr.
wanna tell
Brown.
me, Mr. Leslie?
Bear with me a moment, Your Honor. I need to put on evidence gloves. Your Honor, the defense moves for a mistrial with prejudice based upon intentional misconduct that just occurred before the court and for the jury. In what I'd like to do, Your Honor, this regards the hoodie. In this regards questioning and representations in questioning by Mr. Brennan. And what I'd like to and need to do, Your Honor, is to have 2 documents marked as exhibits. and then I am going to use Exhibit 88, which is in evidence, which is the hoodie, which is why I'm putting on the evidence gloves, and it will become quite obvious very shortly what the issues are.
All right, so what are the things that you want to have marked?
What I would like to have marked the first document, and I want to get the specific title. These two documents.
Hold on
are
a second.
from
Hold on. I gotta run this back. Did I hear a motion for mistrial? Oh my goodness. Hold on a second. Of course I got up at the wrong time. Let's see what this motion for mistrial is about. Let me run this back because Alessi, he sounded like he's about to go off. I gotta rewind it a little bit, y'all. I was not expecting a motion for mistrial. Oh my goodness. What's Alessi doing? He's got OJ's glove up there? Or he's about to handle some evidence, probably.
Your Honor, the defense moves for a mistrial with prejudice based upon intentional misconduct that just occurred before the court and for the jury. And what I'd like to do, Your Honor, this regards the hoodie, and this regards questioning and representations in questioning by Mr. Brennan. And what I'd like to and need to do, Your Honor, is to have two documents marked as exhibits, and then I am going to use Exhibit 88, which is in evidence, which is the hoodie, which is why I'm putting on the evidence gloves, and it will become quite obvious very shortly what the issues are.
All right, so what are the things that you want to have marked?
What do you want to have marked?
I would like to have marked what I would like to have marked the first document, and I want to get the specific title. These two documents are from the criminalist's file, specifically Ms. Maureen Hartnett's notes regarding cuttings from the hoodie sweatshirt that's in the crime lab file folder.
Okay.
So the first is the back of the hoodie. So with Your Honor's permission, I would have that marked for identification.
He asked him about the
Exhibit
holes in the back of the hoodie.
YYY.
What's going on here?
Friday. And may I see that, please? Okay.
That is the back of the hoodie, Your Honor. And if I could please have the next marked in order exhibit for identification.
Exhibit ZZZ for the identification.
Court reporter is doing it all. Marking exhibits.
Just give me a minute to read this, Mr. Leslie.
Yes, Your Honor.
So is it that there are no holes in the back? There were no holes on the back of the sweatshirt?
That's only part of it, but that is in fact the case, Your Honor.
Okay.
Uh-oh. He messed up.
I can't tell entirely from ZZZ, but if that's your argument, why, for identification?
Why?
Appears to support that.
Your Honor, may I have the exhibits marked for identification back for my argument?
Okay.
Thank you, Your Honor. Thank you, Madam Court Reporter. Your Honor, what we just saw is Attorney Brennan question Dr. Wolfe with regard to the hoodie sweatshirt that heretofore has been in the plastic casing for trial. And this is what happened was Attorney Brennan held up the casing with a hoodie sweatshirt, went to the back of the hoodie sweatshirt. First point to note, Mr. Brennan did not show Mr. Jackson the back of the hoodie sweatshirt, didn't give Mr. Jackson an opportunity to look at it.
Can I just ask a question? I noticed that it was over here at the witness stand this morning, so I assumed everyone was aware that something was going to happen with it. Is that not the case, Mr. Jackson?
That is not the case, Your Honor. The
Okay.
first time I realized that line
Okay.
of question was going to be asked was when Mr. Brennan pulled the casing out.
Okay.
Uh-oh.
Go ahead, Mr. Leslie.
Just end it.
Thank you, Your
Just
Honor.
end it, Bev.
So, to do it in order, Mr. Brennan takes the hoodie sweatshirt in the casing, without notice, shows it to Dr. Wolfe, and shows the back of the hoodie, which has certain holes, and I'm going to limit calling them holes to do this chronologically. I'm going to refer to exactly what they are in moments.
Okay, so I need to see it. I know you've got gloves on. Where is it right now? It would help me if you held it up for me now,
Absolutely, Your
Mr.
Honor.
Leslie.
So, here is the back
Okay.
of the hoodie.
Okay. All right. Thank you.
It's very obvious that these are cutting holes cut by the criminalist. And I'm going to get back to this in a moment. But I would like to do it, and certainly entertain any of Your Honor's questions, but in a logical order.
Sure. So I'm not. What about the jurors and lunch? How long do you think this will be?
I think this will take about 10 to 15 minutes, Your Honor.
So 30.
Okay. All right. Thank you. Go ahead, Mr. Leslie.
Thank you, Your Honor. So I just want to get the flow back going here in the logic. So, and I'll do it quickly. So Mr. Brennan grabs the hoodie sweatshirt inside the casing, doesn't show it to Attorney Jackson, goes up, we have no idea that this was going to happen, goes up, confronts the witness, Dr. Wolfe, shows the back of the hoodie sweatshirt. To my knowledge, the first time the back has been referenced of the hoodie sweatshirt. Shows Dr. Wolfe, confronts him, and basically says, couldn't these holes be caused, and I'm paraphrasing, from a fall backwards? Obviously positing in the juror's mind after, remember, we just saw all kinds of videos with regard to Rescue Randy and impact at 24, 29 miles an hour, more aptly 29 miles per hour, and damage to the hoodie, etc. So what then happens is Dr. Wolfe is asked a series of questions, very much with the indication that somehow, in the clear implication, that these holes are being caused by road rash, and that the holes in the back of the hoodie sweatshirt, Exhibit 88, could have been or likely were caused with regard to some type of impact. Clearly presented to the jurors with that in mind in that questioning. Here is the basis for the mistrial with prejudice.
It's not going to happen, but whatever.
Those holes in the back of the hoodie sweatshirt are clearly, unequivocally, without doubt, caused nothing to do with any type of event on or about January 29, 2022.
So do you have something you said when you said obviously cut by the criminalist? Do you have something that shows that chart that I couldn't understand quickly? Is it on that? Does
Yes,
that do
Your
the
Honor.
back?
What
Okay.
we have is two documents to show that.
Right. So the second one, when was that provided?
These, when you say provided, you mean with regard to when did the defense get these in
Yes.
a discovery? Let me get the date, Your Honor.
Sure.
Notice of discovery, May 2023.
Okay, thank you.
And I will note, Exhibit YYY. The only, I believe, I'm holding up YYY, which is the back of the hoodie, I believe is the only one, to my knowledge, not put into evidence. Not turned into evidence. This is the one that it clearly shows the hoodie before the criminalist started her work with the cuts. There are no cuts to YYY, and if we need to, we'll bring Ms. Hartnett in to confirm.
All right, so is ZZZ in evidence?
ZZZ is not in evidence, and that is part of the basis for the mistrial. It is no coincidence that these two documents are not in evidence.
Oh, no.
Because if they were in evidence, they would clearly have prevented the stunt that we just saw occur with regard to Dr. Wolfe. So that is part of the intentional misconduct, Your Honor, is these are documents from the criminalist's file. It's the Commonwealth's documents. And it is very clear when you go to Exhibit ZZZ, the cuts that the criminalist made to the back of the hoodie are specified.
So where on that? Because when I quickly looked at it, I didn't see it. What does it say? Go ahead and read it to me, please.
It's item number 7. I'll read it from the top. LIMS 22-218.
Wow.
4.
This is
Analyst MSH.
This could be bad.
Initials for Ms. Hartnett. Dates.
If
May
it's not in
11,
evidence-
2022. May 12, 2023. And then May 18, 2023. And what she does is she's got the...
You know what? Can you bring it up to me, please?
I certainly can, Your Honor. And I can conduct my argument from right here if that helps, Your Honor.
I just want to see, point out to me where it says, where it shows the back.
This is the back. So you can see the back of the hoodie. That's the back of the hoodie head. And then you can see the various...
I want to ask y'all a question and let me know in the comments in the chat. If there were to be a mistrial, which we know there's, do you think the Commonwealth attempts to retry this a third time? I would be interested to know what you guys think about that. Let me know.
Let me just get a check on this, Your Honor. I'm not...
I don't think they would.
And I'm
So Mr. Wesley stated.
yes.
I don't think they would retry it on a third time. Yeah, with prejudice, obviously. Without prejudice. I should have been more specific. Thank you, Amy.
Can I get the check? Pardon me?
Labeled cuts.
Right, but if I can, Your Honor, I want to clarify this. Yes, are you willing just a moment? Let me just make sure I get...
Mr. Jackson, it says exterior front, what Mr. Alessi was pointing me to.
Well, just a second. It may have printed the wrong page. I can do it, but Mr. Wolfe, can you print the back? And then, Your Honor, are you comfortable using the computer at the back? Because I think we just had the wrong one.
We need to mark it, though.
Understood. We will. He's printing it right now.
This is not good at all. Not good.
We printed, we wanted to have the front and the back to show all the cuttings, but what only printed out was the front. We are now printing the back. Your Honor is correct.
Okay.
Y'all think Hank is up there shaking yet?
So go ahead with your argument.
So, Your Honor, what is being printed is which we will mark, will be the front of the hoodie. The purpose of Exhibit ZZZ and the one that is being printed is to show and to give the court, and we're going to request to give to the jury the complete picture and the complete true story about these holes in the hoodie that were presented as if they were caused in some manner by something else other than the
So
criminals.
that seems perfectly reasonable, and I'd be inclined to do that.
I appreciate that, Your Honor. And here is the reason for the motion for a mistrial with prejudice. On its own, to do this, water. And you put together all of the parts of what just occurred. You start with the fact that and if I could, Your Honor, now that I have it get marked so I can then refer to it.
All right.
Thank you.
Can you print extra copies too, so I can have my own copy?
Absolutely.
And for the Commonwealth to see?
And I'm going to show the Commonwealth what I just printed.
Exhibit A.
Thank you, Madam Court Reporter. Sure. And here's another document, chain of custody document. Welcome.
Sometimes you gotta let things play out.
Viewing that, we may head to.
And they might not have caught it then.
The chain of custody document for these, and ask that be marked as the next exhibit in order.
Okay.
And then with Your Honor's permission, I would have Madam Court Reporter hand them both up to Your Honor so
Sure.
Your Honor can see what I'm referencing.
Thank you.
Exhibit B for ID.
Thank you.
Here's, thank you, Madam Court Reporter.
These niggas lacking.
Do you need this, Mr. Lessie?
I do not need either of them, Your Honor, and I have the extra copies as well. Okay, so Your Honor, I now have enough copies for Your Honor and for the Commonwealth.
Oh, thank you. Okay.
Get it
If I could
together.
get one set, that would be great. Yeah, Your Honor. Thank you.
I still do not have ZZZ.
Yeah, y'all don't worry. We're gonna be talking about Judge Whitaker
All right.
later.
Thank you. Okay, go ahead, Mr. Lessie.
So, Your Honor, to do this quickly chronologically, so we have a hoodie sweatshirt that was brought into the criminalist, Ms. Hartnett, with the back of the hoodie with no holes on it. The criminalist makes cuts to the back of the hoodie, makes cuts to the front of the hoodie. The exhibit, Your Honor, depicts those. There's a chain of custody document that describes the chain of custody for the hoodie and the cuts in the chronology. And of course, we have Exhibit 88, which is the hoodie. So, what Mr. Brennan did, and I'm now pulling Exhibit 88, he holds up the back of the hoodie, which has cuts in the back from the criminalist, somebody from the Commonwealth, a witness in this case, Ms. Hartnett, she's testified, and Mr. Brennan has indicated he wants her to come back and testify, which we welcome. And now what we have is we have holes in the back of the sweatshirt that were dramatically held up to and confronted with Dr. Wolfe, and then the jury sees it. With the clear, unmistakable, purposeful intention of having the jury conclude that these holes could have come from events on January 29th of 2022, when in fact the Commonwealth well knows from its own documents, from its own criminalist, that those holes in the back were caused by their criminalist as part of their examination and sampling of the hoodie. What could be more
mischaracterization?
What could be more misleading
Yeah,
than that?
that's bad.
And what could be more important for a context than the alleged collision that never occurred? That's the topic before some of the most significant and probative witnesses in this trial that the Commonwealth has been attacking from the jump of pretrial. They picked the most opportune, sensitive time to pull this stuff. This is intentional. This is irremediable. This is on the key issue of this case, whether there was any collision at all. On its own, Your Honor, on its own, this is a mistrial with prejudice. But I add to that what just happened, and I'm not going to repeat or go into other than to reference. This comes on just mere days after the Commonwealth raised the specter of absence of DNA on the same hoodie sweatshirt without having the criminalist, Ms. Kuhn from UC Davis come in. I know Your Honor already ruled on that.
Right,
and
so let's move along from
right,
that.
that's what, and I'm going to come back to this. Why is this occurring, Your Honor? Why is this happening? The Commonwealth has no case. They have no collision. They are desperate and are trying to create evidence of specters of collision where the evidence doesn't support it. So what have we come to? We've come to the manufacture of evidence. We've come to, incredibly, taking a hoodie, a key piece of evidence in this case, and holding up to Dr. Wolfe, the ARCA expert, to try to make it seem like Dr. Wolfe didn't do his job. You didn't account for these holes. How could you be a credible accident reconstructionist when you talk about some holes, but you don't talk about these holes? Knowing all along the holes that Attorney Brennan is trying to impeach Dr. Wolfe on were caused by the Commonwealth's own criminalists as part of sampling. I don't believe one could come up with more misleading, misdirecting elucidation of testimony than this on the key issue in the case. We have irrefutable, objective evidence, and I will state that it's more than interesting that none of these exhibits that Your Honor now has marked for identification were put in evidence by the Commonwealth. Isn't it some coincidence that these are the one, and the only one of the, with regard to the hoodie, the back of it's not in, all of the rest of them are, but these aren't. Your Honor, I think there is one and only one conclusion, in that this is intentional, that it is a matter of such significance and of such misconduct and intentional that it merits the sanction of a mistrial with prejudice. The amount of effort, the amount of work, I can't even begin to think to remedy this in front of the jury, to go backwards on this. That should not befall the defense. That should befall the prosecution. Ms. Reed, again, is entitled, like every other defendant in this wonderful Commonwealth, to a fair trial. The prosecution is supposed to be held to a higher standard, to do justice, to create a fair trial. This is the antithesis of a fair trial. Miss Reed's rights under the Constitution and the Declaration of Rights have once again been trampled on, and it is becoming evidently clear the more desperate the prosecution gets because it can't prove its theory, including its own medical examiner can't support them, that they're now resorting to conduct like this. Your Honor, at some point, this has to come to an end. At some point, Ms. Reed's rights have to be protected. At some point, confidence in the judicial system, the public's confidence in the judicial system, that prosecutors will conduct themselves with their duty to present a fair trial. That has to be enforced at some point for Ms. Reed to receive the fair trial that she and every other defendant in this Commonwealth is entitled to.
All right, thank you. Mr. Brennan.
I can't wait to hear this. We already know what's going to happen.
Your
It's
Honor,
not
my
even
brief
real
review of the
mistrial.
review of the lab paperwork and looking at the hoodie, it appears that I made a mistake. And so I think
somebody must have chuckled. Why did he look over there like that? Why do you look over there like that? Somebody must have said. Hold on a second. Hold on. We gotta replay this. Somebody is probably said.
Your Honor, my
Yeah,
brief
okay.
review of the review of the lab paperwork and looking at the hoodie, it appears that I made a mistake.
Oh yeah, somebody, you can hear it. Someone went. Tss.
And so I think what should happen is there should be a curative instruction.
Oh
There should be
man,
a stipulation.
of course he does.
The court should instruct the jury that during Mr. Brennan's cross-examination, he asked Dr. Wolfe about holes on the sweatshirt or holes on the back of Mr. O'Keefe's sweatshirt. The parties agree the holes were made by a crime lab technician. This was done inadvertently but should not have been asked. The court
He wants
should
them to disregard
strike
it.
the questions and the answers. And you should instruct the jury they are to completely disregard any questions or answers about the holes in the back of the sweatshirt.
My favorite legal word.
And the
Disregard.
court should allow the defense to introduce the lab paperwork.
All right.
He said, "My bad."
So I'm not going to allow the mistrial motion.
What? Oh, can you guys believe it? She didn't allow a mistrial. Wow. Shocking.
Let's see. What I'm going to do is
What Brendan
instruct
said.
the jurors. I'm going to put in what's been marked for identification, Y, Z, A, and B. 4 of each letters. I'm going to put all these into evidence. They can be displayed for the jury, and I'm going to instruct the jury that during the cross-examination of Dr. Wolfe, Mr. Brennan asked him about holes in the back of the sweatshirt and whether or not they perhaps could have come from events or implying or something like this. I instruct you, you are not permitted to draw any inference that these could have come from the events of January 29th, 2022. I instruct you further that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on, I just put the dates aside. Chrissy, can I see those, please? It's unclear for me. Do you have a better idea, Mr. Leslie, what day these were done? Is it all of those 3 days? Now I see a 4th day. 5/11, no, I'm sorry, 5/11, 5/12, 5/11, 2022, 5/12, 2023, and 6/18, 2023. Those are the 3 dates?
Your Honor, on or about May 18th, when the defense filed a motion to test. So
Nasty.
That's the probative date.
So May 18th?
Yes, that's good.
Okay.
And that's 2023.
Yep. All right. That's what I'm going to do. Is there anything further you want me to include in the instruction? Your rights are saved regarding the mistrial. I disagree with you on that.
Your Honor, I'm not going to go any more into the argument, but I appreciate the opportunity to provide perhaps some further instruction for Your Honor.
So I'll hear you. Go ahead.
So the first, Your Honor, is with regard to two things. One, I would like the opportunity to have the hoodie sweatshirt held up, because that's what
Okay.
happened.
Yes. Yes.
These holes in the
Yes.
back.
Yes.
Okay, thank you. So that's number one as part of
Smart.
the stipulation. And then
I'm not wording it as a stipulation, and I'm not saying it was inadvertent. I am giving an instruction that they cannot consider it for this purpose, and I am
Disregard.
allowing these to be placed into evidence. So it's not a stipulation. It's from me, which I think is more forceful.
I misspoke, Your Honor. I agree, not a stipulation, but just as Your Honor said, with regard to the matter Your Honor said they're not to take an inference, I would respectfully request that this be handled just like Your Honor did with regard to the rock at 34 Fairview. Your Honor said that rock wasn't present, on or about the time of event.
So I do say that when I say Ms. Harnett did this. So
That's a good point, too.
rewording it just a little bit.
Yes, exactly.
Mr. Brennan asked Dr. Wolfe about holes in the back of the sweatshirt. I instruct you that you are not permitted to draw any inference that those holes were a result of the events on January 29th, So, all right, this is what I'm going to say. So if you're not going to listen to it, that's fine. I've already said it. All right, we can bring the jury in. It's what I said, Mr. Alessi.
Your Honor, I was consulting with Mr. Alessi. I'm not showing disrespect to the court.
Okay.
Of course you were listening.
All right, so it's what I said, Mr. Alessi. I instruct you that you're not permitted to draw an inference that the holes came from the events of January 29, 2025. Those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on May 18, 2023.
Is it possible, Your Honor, last comment, to instead of not drawing inference, you should conclude that these holes were not present in the hoodie sweatshirt. They were caused by the criminalist.
So I can just leave that all out then and just say, Mr. Brennan asked Dr.
to the
Wolfe
Commonwealth
about the holes in the sweatshirt. I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on May 18th. It's probably neater that way anyway. All right, let's bring him in, please.
Judge, just as a housekeeping matter, the sweatshirt's been taken out of the plastic sheet, and it might need to be remarked. The plastic sheeting was marked, but if we're going to put it into a bag or something like that, we might need to have it marked. But we don't need to do that right this second.
Okay.
Yeah, we knew there wasn't going to be a mistrial,
Yes.
but
Thank you.
and they're going to be able to show it to them as well.
All right, thank you. I'm sorry. Mr. Alessi, you're simply going to stand and hold the sweatshirt, right?
Yes, Your Honor.
Okay.
So this is Exhibit 223.
In your honor, I would hold it as your honor begins to read. Is that consistent with your honor's expectation?
No, I want you to hold it up with the back.
When would you like me to start?
You do that first, and then I'll give the instruction.
Thank you, Your Honor.
All right, so Mr. Alessi, why don't you just, where are you going to stand?
Pardon me?
Where are you going to stand?
I would suggest, Your Honor, right about here.
All right? So you can stand there, you can hold it up, then I'm going to ask you to put it down, and then I'll give the instruction.
And then I will return it to Mr. McDermott, or the court officer.
Yes,
Thank you.
court officer.
Bear with me a moment, Your Honor. I'm going to put on the...
All right, then we will take the luncheon recess. When we come back, we'll have the voir dire. Or actually, is Dr. Lapisada here?
She's here, she's on next. I'm gonna call
John Tina.
TED.
For just the measurements?
Yeah, they messed that up bad. And then they're going to bring the jury back in and talk about
Well, I
this.
say it, and I'm going to tell her what they are, so.
Here we go.
Session.
All right. Jurors, I appreciate your patience. Mr. Alessi, why don't you hold the exhibit up for the jurors, please?
And we get to see it too. Don't show the jury, cameraman, now.
All right, jurors, that's the back of the sweatshirt that was shown to Dr. Wolfe.
Get a good look at it.
Okay. Thank you. Why don't you go ahead and put it back in the bag? So, jurors, I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt back on May 18th, 2023. Okay? So, I know your lunches are here, but I think we'll, Mr. Yannetti, your next witness, please.
John Tina.
All right, there we go. So that was it. What do y'all think, man? We knew there wasn't going to be a mistrial. Here we are. Is the instruction fair? How do you think this is going to affect the Commonwealth's case? Because judge is essentially saying, hey, Commonwealth messed up here. Sorry, guys. Sorry about that. Our bad. How's the jury going to see it? Let me know what y'all think. And let's keep it moving with our next witness. We got Officer Token up there.
Case now, we hear the truth, the whole truth, and nothing but the truth, so help you God.
I do. Thank you.
All right, good afternoon. Go ahead, Ms. Giannetti, whenever you're ready.
Thank you. Good afternoon, sir. In a good loud voice, would you please state your name and spell your last name?
Sure, my name is John Tedeman. It's Tedeman.
Do you work, sir?
Tedeman,
I do.
not Tiedemann.
What do you do for work?
I am a private investigator.
Do you work for
PI,
someone else,
nice.
or do you have your own firm?
I have my own firm,
What is the name?
Forum Investigations.
And that's Forum?
Correct.
I'd like to ask you a little bit about your education and work history. You're from this area?
Yes, Boston
Where-
proper.
I'm sorry?
Yes, from Boston.
Where did you attend high school?
The Roxbury Latin School,
When did you graduate?
1996.
Where did you go to college?
I went to Princeton University,
What year did
Nice.
you graduate?
2000.
What did you do after graduation from Princeton University?
I became a federal agent.
Where?
The agency or the location?
Oh, I meant the location. Sorry.
I started out in Los Angeles, and then I was back in Boston.
Smart
And
guy
what
with
years
a lot
were
of experience.
You a federal agent in Boston and Los Angeles.
2002 through 2008.
And what agency did you work for?
I worked for the Inspector General for the Social Security Administration, Office of Investigations.
And what type of work did you do in terms of investigations?
We did fraud investigations, identity theft, credit card fraud, fugitive operations, all sorts of things, anything involving a Social Security number, basically.
And why did
Nice.
you leave in 2008?
I went to law school,
Where?
Suffolk,
What year did you graduate from Suffolk Law School?
2013.
And what did you do after graduation from Suffolk Law School?
I've had a small solo law practice and worked as a real estate broker,
And what type of law did you practice?
mostly real estate law.
When did you start Forum Investigations?
In April of 2024.
Are you still practicing as a lawyer?
Not very much, no. I still have my license, but my bar card, but I don't practice much.
All right. How did you become involved
Nice.
in this case?
I was contacted by somebody from your office last Tuesday, I believe, the 3rd.
Okay. And was it explained to you why you were brought in at this late juncture?
Yes, it was explained that there was another investigator who had a health issue and would not be able to testify. So would I be able to help out with a small assignment?
All right. And what were you asked to do?
I was asked to travel to 34 Fairview Road in Canton and take some measurements and photographs.
Did you agree to do that?
Yes.
Measurements guy.
When did you go?
On June 3rd, I believe I arrived about 5:30 at 34 Fairview.
Okay. And when you say June 3rd, we are talking about last week,
Yes,
correct?
last week, yes.
Whom
Nice.
did you see when you got there?
One of the homeowners, an older gentleman, greeted me when I pulled in the driveway.
All right. And it was not the Albert family, correct?
It was not.
Did that individual give you permission to enter onto the property?
He did.
What did you bring with you?
I brought an iPhone as a camera, and I brought a wheeled measuring device.
All right, and can you describe what a wheeled measuring device is?
Yeah, it's
a little thing that you
like a
roll.
handle with two wheels at the bottom, and in the middle there's like a little odometer that measures feet and inches.
And if we could, Mr. Wolfe, could we display the photo of the front of 34 Fairview that's already in evidence with the court's permission?
Yes.
And what exhibit number is that, Mr. Wolfe? 46? Do you see exhibit 46 on the screen, sir?
I do.
Do you recognize that?
I do.
What do you recognize that to be?
That is 34 Fairview Road in Canton.
When you got to 34 Fairview Road in Canton on June 3rd, did you make note of the various entrances to the residence on the front, from the front of the house?
I did.
Could you describe those for the jury?
Yes, on the left side center of the building, there's what I would call the front door, up those 4 steps, I guess. Then if you were to look farther to the right, there at the end of the main building, there's another door, which I guess is the second front door or side door.
And with regard to that door, is it fair to say that faces outward, faces toward the road?
It does. It faces directly towards the road.
Okay, continue, please.
And then past that to the right, there are the windows, and then if you can see the little red line, that is a side door that goes into the garage. Yes, right there.
It's been highlighted there?
Yes.
Okay. And then there are obviously the two garage doors.
And the two garage car doors, yes.
4 cars.
We keep hearing about the garage, too.
We can take that down. Mr. Wolfe, put the lights on. May I approach the witness, Your Honor?
Yes.
Sir, I've placed a photograph in front of you. Can you identify that for the jury?
Yes, that appears to be a photograph that I took of the side front door, the secondary front door, the garage door, and the two car doors to the garage.
Okay. Particularly with regard to the side pedestrian entrance into the garage, the red door that you identified in the previous exhibit. Does that photograph fairly and accurately represent the layout of the house in terms of the outside and the entrances that you've previously testified to?
Yes, it does.
I would offer that, Your Honor.
All right, can I see those, please, sir?
We got another sidebar. Y'all know what time it is. Can't even get the measurements in without a sidebar. Good Lord. Hold on a second. I'm trying to skip ahead for you. There we go.
Okay, Mr. Wolfe, whenever you're ready, if you can display that portion. Do you see what has been?
So I'm going to ask you to take that down. Folks, we're going to take the luncheon break at this point.
Uh-oh.
Okay?
Is she going to see counsel at the sidebar? Oh, we're actually going to get into the... All right, so don't know what happened there. Bev just kind of shut things down. Let me see. So during the lunch break, it looks like we're going to have some updates here about the next witness, the dog bite expert witness. Yeah, I don't know what happened.
All right, so we'll fix that during the luncheon break, Ms. Giannetti, to what I said. All right, so can we get Dr. LaPosada in here? We'll do a very brief voir dire of her.
Yeah, Dr. LaPosada. And that's 5 sidebars.
Do you solemnly swear the evidence you give to the court in the case having heard the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Good afternoon, doctor.
Good afternoon, Your Honor.
We're going to do a brief voir dire, okay?
No problem.
Thank you. All right, Mr. Jackson, foundation on just those 2 points, please. Sure.
All right, let's get to it.
Your Honor, for purposes of expediting, does the court wish for me to go through the foundation of the doctor's education, training, and background and experience, which is going to take a minute?
Yeah, no, just focus on the foundation for the dog bites and focus on the foundation for what's been termed to be perhaps biomechanical engineering evidence. Those 2 areas, and if there is support or methodology in Dr. Laposada's resume to point to exactly where that is. Okay? And I expect this whole voir dire should take no more than 15 minutes.
I'll do my best, Your Honor. Doctor, could you please state your name for the record? Spell your last name into the record, please.
Yes, Dr. Elizabeth Laposada. That's spelled Laposata.
Dr. Laposada, what do you do for a living?
I'm a medical doctor subspecializing in forensic pathology.
Dr. Laposada, I'm going to move very, very quickly past the bulk of your training and experience over decades. I'm going to ask you a couple of quick questions.
Shout out to Susan Collins.
Where did you get your medical degree?
That's dope.
University of Maryland School of Medicine.
And do you have any subordinate degrees to your medical degree?
Yes, I have board certifications in anatomic and forensic pathology.
How long have you had those board certifications?
Like 35, 40 years.
Have you ever worked as a medical examiner in any capacity?
Yes, I have.
Have you ever worked as a chief medical examiner for any agency or governmental agency or state?
Yes, I have.
Describe that for the court, please.
I was a chief medical examiner for the state of Rhode Island for 12 years.
How many autopsies would you say in general that you have conducted yourself?
Over 3,000.
How many autopsies in your experience as a supervisor in one capacity or another would you say you've supervised over your tenure?
Over 7,000.
Of those 7,000 that you have supervised, have any of those dealt with motor vehicle incidents?
Many.
Have any of those dealt with motor vehicle and pedestrian incidents?
Many.
Give me an idea, if you have a number in mind, how many motor vehicle pedestrian autopsies you have been involved with, either directly or from a supervisory standpoint.
Hundreds, over 500 at least.
Do you have a significant background and training in the cause and manner of death?
Yes, I do.
Is that the main goal or the main
experience.
job or duty performed by a medical examiner?
Yes, it is.
Is it also significant in terms of supervising other subordinate medical examiners who may work under your charge?
Yes, you have to make sure they're doing it right.
Is there a methodology that you have employed and that is standard in the industry to employ, including differential diagnoses and inferential thinking in terms of coming to conclusions related to manner and cause of death?
Wow.
Yes.
Can you explain that for the court in brief, please? I know you probably have a very lengthy explanation. Okay. Do it as briefly as you can, with being as succinct as you can.
Certainly. To determine cause of manner and death, we look at scene investigation, autopsy findings, police and witness statements, and medical history. And using that information, we come up with a differential diagnosis or a list of things that might have happened to that person to cause them to die. And from that list, then we see where all the science and all the data, which one it supports. So we've looked at several different things. I always told my staff, I said, how can we be wrong? What else could this be? So you have to make what in medicine is called a differential diagnosis and then see what the facts support.
We've heard
Did you
about that.
employ a differential diagnosis in this case?
Yes, I did.
Do you have to be at the scene in order to understand or analyze information that you get in a police report or photographs or things of that nature?
No, then we use the police investigation and scene investigation, crime lab reports, photographs taken by the crime lab, by the police at the scene.
Have you qualified as a expert forensic and anatomical pathologist in other courts in Massachusetts and other states?
Yes, I have.
Approximately how many times would you say you've qualified?
Hundreds.
I want to talk for a specific for a second about a specific area of interest for the court. Were you provided information and photographs of John O'Keefe's arm and his arm injuries included with the rest of the autopsy information that you received?
Yes.
Were you asked to make a determination about the nature of the wounds specific to his right arm? I know that there's other injuries to Mr. O'Keefe, but I'd like to relegate your attention to the right arm.
Yes, absolutely. That's what the forensic pathologist does.
Without telling me what your opinion was, were you able to come to an opinion or conclusion about the source of those injuries?
Yes, I was.
What methodology did you employ to come to that opinion or conclusion, or those opinions and conclusions?
Good question.
My experience and knowledge and training, along with the appearance of the wounds on the right arm, which fit a pattern, and then knowing that it fits a pattern, then I can try to look for, okay, what is the item that caused this pattern? And that would be part of the differential diagnosis that I've used for many, many years in making diagnoses and determinations.
Have you ever been trained in pattern recognition?
Yes.
In what capacity?
Oh, as a forensic pathologist and medical examiner, a large amount of our work has to do with recognizing pattern injuries, because that's so important, because it gives us an idea of what might have caused that injury. And then that's clearly of a lot of importance to the police and the investigators as they're trying then to say, well, what could have caused that injury? And so the forensic pathologist could say, well, I think it was X or Y. Then they can carry out their investigation armed with that information as to what might have caused the injury on the body.
Is there such a thing in the world of pathologists as medical literature or academic literature that deals with pattern recognition?
Yes.
Are you familiar with some or most of those publications?
Mm-hmm. Absolutely.
Have you ever yourself taught classes on pattern recognition?
Yes.
At what level? High school, graduate school,
At the
medical school?
medical school level.
How often have you taught courses on pattern recognition?
Oh, at least a handful.
When was the last time you taught a course in pattern recognition?
Let's see, last month.
Do any of the courses that you've either taken, well, let's take one at a time. Have any of the courses that you've ever taken dealt with wound pattern recognition as it relates to animal wounds?
Courses that I've taken?
That you have taken?
It's part of our basic training and understanding of a forensic pathologist. The board exams we take test for that. Those injuries are described in our basic forensic pathology and medicine textbooks. They appear continually in our medical and scientific journals.
Is that an important skill set to develop, wound pattern recognition as it pertains to animals as a forensic pathologist?
Absolutely.
Do any of those academic courses that you've either taken or reference works that you just referred to, do any of those deal with dog bites and claw marks specifically?
Oh, yes, they do.
In the course or courses that you have taught related to wound pattern recognition, have you ever taught on the subject of dog bite wounds and the recognition of dog bite wounds?
Yes, I have.
When was the last time you did that?
Let's see, it would be in the course in the medical school. Would have been several years ago.
Doctor, with regard to staying with dog bite wounds specifically, have you ever performed an autopsy that specifically dealt with dog bite wounds, known dog bite wounds?
Yes.
So you've seen them in person?
Yes, I have.
Okay.
Have you ever been qualified in any court in the land, state or federal court, on the issue of wound pattern recognition as it pertains to dog bites?
Appreciate you,
Yes.
Kara.
When was that?
Kara's over there
The
looking
last
out.
one I can recall was a federal case involving questions of a police dog.
Did you engage, in that case, did you engage in a differential diagnosis to determine, in your opinion and conclusion, your expert opinion and conclusion, the source of the wounds that you saw?
Yes.
Did the court qualify you to speak on that issue in court?
Yes,
Did you, in fact, testify in furtherance of your opinions and conclusions in that case?
I did.
I want to turn for a second to motor vehicle accidents or motor vehicle incidents. Do you also, some of the same questions, have you also performed autopsies on known motor vehicle pedestrian incidents?
Yes.
How many times would you say you've performed an autopsy on those issues?
Hundreds, maybe even 1,000.
Is that a relatively common occurrence, as sad as it may be, motor vehicle pedestrian incidents in the field of forensic pathology?
Yes, it is, unfortunately.
Have you performed autopsies personally as well as supervised autopsies on motor vehicle pedestrian incidents?
Yes.
And what methodology do you employ in furtherance of coming to opinions and conclusions regarding cause and manner of death specific to motor vehicle pedestrian incidents?
Well, we look at the scene investigation. We look at what the motor vehicle looked like. We look at hospital records, the autopsy, and then trying to understand how the injuries that the pedestrian sustained, what those mechanisms were, and how the injuries show that that person interacted with the motor vehicle.
In doing so, in coming up with injury mechanism analysis, is it important to look at and analyze the actual vehicle that is allegedly involved?
Yes, you want to look at
Taco
photographs
Tuesday.
of that or see it in person.
Is that part of the
That's
normal
crazy.
methodology that is employed in the field?
Yes, you must look at the photographs. You must see what the vehicle looks like.
Do you also look at the other side of that handshake? In other words, look at the body of the individual that was, in your case, killed, the decedent, in order to marry the two and determine whether or not the cause and manner of death had something to do with the motor vehicle, a motor vehicle impact?
Absolutely.
Describe that for us, please. What are some of the things that you look for that's part of the normal methodology that a forensic pathologist employs?
Well, when we examine a fatality from a motor vehicle, we want to try to understand what led up to it, how the impact occurred, and then what happened after. So we would study information about the injuries to see if we can relate them to certain pattern injuries that would be on the car. There are also evidence of transfer of energy and injuries that can result from the transfer of energy. So using the body, looking at the scene and the vehicle, understanding the motions of the vehicle and how they would have produced or would not have produced certain injuries on the body.
I'm going to take them one at a time. With regard to animal wounds or dog bites, were you able, in this case, using differential diagnoses, using inferential thinking, and using the skills that you've developed over decades of your education, training, and background, were you able to, without telling me what the conclusion is, were you able to come to a conclusion or opinion as to whether or not the wounds that you saw on John O'Keefe's right arm were consistent or inconsistent with a dog bite?
I love these
or claw
medical
marks?
witnesses.
I was able to come to a definite scientific conclusion.
And is that conclusion to a reasonable degree of medical certainty?
Yes.
Is it to a reasonable degree of scientific certainty?
Yes, it is.
Is it consistent with the training and methodology that you've employed over decades?
It is.
I'm going to ask you the same series of questions with regard to the motor vehicle incident. Did you review the autopsy report in an effort to look at John O'Keefe's entire body and all of the injuries that he sustained, not simply his right arm.
I looked at everything.
In doing so, were you able to come to an opinion or a conclusion as to the mechanism of injury and whether or not his injuries in total were consistent or inconsistent with a motor vehicle incident or impact?
I was able to come to a scientific conclusion.
And
what was the
without
conclusion?
telling me what that scientific conclusion is at this
come
point, did you employ the same methodology that you've explained to the court earlier concerning differential diagnoses, inferential thinking, and decades of training, the education, training, and background that you've described for the court in coming to your conclusions about whether or not the cause and manner of death was consistent or inconsistent with a motor vehicle impact?
Yes.
Your Honor, is there any area that I have not covered to the court's satisfaction consumption?
So I'll let Mr. Brennan ask questions. I may have a couple of questions.
Thank you.
Here we go.
Good afternoon, Dr. LaPosada.
Good afternoon.
If we could start with dog bites.
Yes.
Did you have any specific training in wound pattern recognition regarding dog bites?
Yes, it's in our literature standard textbook. It's standard information that is needed to be a forensic pathologist.
When did you receive training regarding pattern recognition of dog bites?
Beginning when I took my board, starting in 1983.
And what did that entail?
It entailed reading literature. It entailed reading the standard forensic pathology and medicine textbooks. And it is a sub-part of understanding pattern injuries. Dog bite injuries are described in all our journals and all our standard forensic textbooks.
Other than reading about it when you were studying for your boards, did you have any practical experience where you were engaging in the field in pattern recognition analysis regarding dog bites early on?
Yes, I've had many cases where there have been dog bite injuries.
When you were studying for your boards, were you doing that, or after you completed your boards?
I'm telling you that that it's such a basic part that during studying for boards, it's a section that we study. And I, of course, had many
I actually did not know
cases
that.
since then.
Did you receive any education past reading literature for the boards, where you took classes, seminars, where it taught specifically wound pattern recognition regarding dog bites?
It's all part of wound pattern recognition. It's usually included in literature. If there are lectures about patterned injuries, it's a subset of pattern injuries like hammer injuries, like gunshot wounds, like baseball bat injuries. There's a huge number of types of patterned injuries that are part and parcel of what a medical examiner has to understand and diagnose.
Do you remember taking any specific classes or any specific training about wound pattern recognition relative to specifically dog bites?
Yes, it's in all the literature that I keep up with.
Did you take any training or did you attend any classes that involved wound pattern recognition of dog bites?
Yes, it's often included in our seminars and case reports.
Do you list any of those classes or seminars on your resume?
That I took? No.
Can you identify one of those classes, where it was, when it was, who taught it, what the name of it was, regarding wound pattern recognition relative to dog bites?
I can't give you a specific time and date.
Can you remember the name of the last class or seminar that you took or completed that has to do with wound pattern recognition relative to dog bites?
I can't recall.
Is there anything in your report that identifies any of your specific education or training on wound pattern recognition as it relates to dog bites?
It's in my CV. It's basic knowledge that a forensic pathologist has to have.
I will ask you about the CV, but Dr. Laposada, I just wanted to ask you about your report first. Is there anything in your report that points to any specific training
In the report that I wrote on
in your
this
report
case,
relative to wound pattern recognition as to dog bites? Is there anything in your report that identifies that for us?
in my report, I put together the case of what happened to Mr. O'Keefe.
Okay. As far as your experience, though, do you ever make any note in your report about your specific experience and training about wound pattern recognition for dog bites in your report?
No, it's not appropriate.
In your CV, is there any way you can point to us where you had specific training for wound pattern recognition relative to dog bites, where we can see that on your CV?
No, it doesn't say dog bite training specifically, no.
Do you have anything on your CV that specifically talks about wound
Boy, somebody's
pattern
over there breathing
recognition
hard.
for animals?
Those are usually classified within other pattern recognition.
Do you have anything specific that would alert us in your CV that you've had such specific training on wound pattern recognition for animals?
Other than I've passed my board exams and have practiced for 40 years.
Have you provided a list of cases where you have testified in court specifically about wound pattern recognition of dog bites?
I don't know if I have given a list. I don't keep those kinds of lists.
You mentioned one case about law enforcement dogs in federal court. When was that case?
Several years ago.
How long would you say, if you had a guess?
How long was it ago?
Yes, please.
A couple years, around COVID time.
Did you testify in that case about law enforcement police dogs?
I testified about an individual who had injuries, and there was a question as to whether Canine Caper, who was the dog's name, inflicted any injuries on this person.
And this was in Boston federal court?
Springfield, yeah, Boston, right.
Is there a difference between law enforcement dog bites and domestic dog bites?
They have the same kind of dog jaw.
So you would say
they're
that-
taught differently, obviously.
Would the wound pattern recognition be the same or different if you were looking at it from a law enforcement dog perspective or a domestic dog perspective?
The dog would be the same.
Do you have any other cases that you've testified about wound pattern recognition relative to dog bites?
I've testified in hundreds of cases. I can't say that I remember any particular ones.
Would you be able to identify any of those for us today?
No, too many.
I'll ask you about accident reconstruction experience. And I mean this respectfully, you don't have a biomechanical or a biomedical engineering type background.
Does she need
do you?
to?
No, I'm not a mechanical engineer.
You're not certified by ACTAR or any of those type of organizations, are you, doctor?
No, I relate the injuries on the body to the motor vehicle.
Have you ever been to a car collision scene and investigated a car collision scene?
Who's that
firsthand?
over there breathing
Yes.
like that? Her
And when you've done
COPD
that,
flaring up?
do you have a chance to look at all of the physical materials, the
Over there
properties?
breathing hard.
Well, when I go to
Dang.
a scene of a motor vehicle fatality, I look at the pieces that are scattered around, I look at the body, I look at blood stain patterns, I look at damage to the car, and then the body would go back for the examination at the medical examiner's office, and there would be further examination of the scene by accident reconstructionists and examination of the automobile by specialists who could figure out what motor vehicles do. So it's a part of correlating the injuries to the vehicle.
You've never written an accident reconstruction report yourself, have you?
No, that's not what I do.
I understand. In this case, What materials did you look at? Because I don't think in your report it mentions the materials that you studied. What materials did you study as the basis for any potential opinions regarding accident reconstruction?
Well, so you would like for me to tell you everything I studied in this case?
Yes,
I have my list here. Should I read
that's fine
from
by
that?
me.
Okay. I studied the autopsy report, neuropathology report, toxicology, and associated paperwork from the medical examiner's office. I studied 104 autopsy and neuropathology photographs, 70 additional autopsy photos taken by Trooper Watson. I studied Mr. O'Keefe's medical records from the Canton Fire Department and EMS run sheet. I studied the Good Samaritan medical records that also included 35 photographs of the body. I looked at evidence of Mr. O'Keefe's clothing, blue jeans, t-shirt, sweatshirt, boxers, and sneakers. I'm sorry. I looked at photographs that were taken at the crime lab of various pieces of plastic, black, red, and clear. I studied photographs of the outside of Ms. Reed's SUV as it was parked at the police garage. I studied the Canton Police incident report, about 100 photographs taken by Canton Police of the outside scene. So that gave me a very good idea of what happened to Mr. O'Keefe.
Were you involved in the case Commonwealth versus Daniel Tompkins?
Remind me about
Daniel
that. I've
Tompkins?
been involved in hundreds of cases.
Yes, you have. This case was in Franklin County Superior Court. It was a case where you had an opportunity to present testimony and regarding blood spatter, which you have been qualified expert for. I'm sorry.
Well, that doesn't quite say what I did, but I remember the case you're talking about.
Did you attempt, or was there an attempt to have you qualified to talk about accident reconstruction in that case?
No, I'm not an accident reconstructionist.
And do you remember whether or not there was an attempt that was denied to try to have you talk about accident reconstruction in that case?
I have no idea. I'm not an accident reconstructionist.
Okay.
Fair.
Do you have anything
love
on
when he
your
says,
CV
"Okay."
specifically that
Okay.
offers any background on accident reconstruction or accident reconstruction type classes or seminars?
I don't think so.
All right, thank you, Dr. Laposada.
No, you're welcome.
Oh, is
So
that
can
it?
I just ask Dr.
I don't know. We're still going. Good Lord. They're going
about,
to use the whole
you
lunch.
said you've been involved in autopsies with dog bites.
Yes.
How many?
I've done thousands of cases, probably 50 or so. It's not always the cause of death. And then I've supervised maybe 75 more where that dog bites were involved in the case.
When was the last one?
Let's see, probably 2 years ago.
Okay. Any questions based on my questions? All right. You are all set and asked you to step down, Dr. Laposada. We'll get to you sometime this afternoon.
How many sidebars? We got 5
I do want
sidebars
to
so
give
far.
everybody a break, including counsel. Can we do less than 5-minute arguments on this?
Probably not.
Your Honor, I'll make this very brief.
Okay.
Dr. Laposada is eminently qualified to speak to both the issue of wound pattern recognition as it relates to dog bites, specifically, as well as cause and manner of death as it relates to vehicle pedestrian incidents or impacts. The doctor has an incredibly impressive resume, just a touch of which we reviewed during the course of this voir dire for her qualifications. But with regard to the dog bite specifically, she talked about the differential diagnosis that she undertakes and undertook in this case. She talks about the inferential thinking that she undertook in this case. She talks about how that is the proper methodology in the scientific community and specific to the forensic pathology community in order to come to a determination about wounds and the source of wounds, i.e., was it a dog, was it another animal, was it another source, was it lacerations versus abrasions, things of that nature. She's obviously done, as she indicated, thousands, if not climbing real close to 10,000 autopsies that she's either supervised or that she's conducted herself. She actually has, notably, as per the court's last question, she's actually undertaken personally somewhere close to, I thought it was probably 5 autopsies herself dealing with dog bites. They're not always the cause of death, but sometimes it's attendant to the injuries that led to a different cause of death. But she's undertaken at least 50, or that's what she estimates, 50 of those autopsies herself. She's seen dog bites, she's seen dog wounds, she engages in pattern recognition. She also teaches classes on pattern recognition as it pertains to dog bites, and she's eminently qualified to speak to that in this particular case. She has been able to come to an opinion and conclusion as to whether or not the injuries to John O'Keefe's arm are consistent or inconsistent with dog bites, and I expect that she would then give that opinion and conclusion to a reasonable degree of medical certainty and to a reasonable degree of scientific certainty. As it relates to her differential diagnosis and her ultimate conclusions concerning the automobile impact, obviously, many more autopsies dealing with that because it's more common. She also engaged in the exact same differential diagnosis. She has training. The subfield of, or the sub-issue of vehicle pedestrian impacts is included and subsumed within much of the medical literature that she's been taught on, going all the way back to the 1980s. Dealing with her boards, and she's consistently passed her boards. She's consistently kept up with the literature. She's consistently engaged in autopsies herself, so she has firsthand training. She also trains other medical professionals, other doctors, other medical examiners, and she supervises other medical examiners. She's been the chief medical examiner for an entire state. I cannot imagine somebody more eminently qualified to talk about
an entire
the two
state.
subjects that she's been called to talk. Well, she's called to talk about several other subjects, but these two subjects that's before the bench right now than somebody with Dr. LaPosada's qualifications. I will submit on the voir dire that we just completed.
All right, thank you. Mr. Brennan.
I do not think that Dr. LaPosada has articulated the experience the way it's been summarized. She could not provide any specific training other than her boards and her references to literature. She could not articulate one single class or seminar that she took that pertained to differential diagnosis of dog bite injuries. She has no specific memory of having any type of experience in differential diagnosis as far as being in a training, seminar, or advanced education. She has the experience of a medical examiner who has seen what she believes to be dog bites in the past. She has no publications or references that she has studied the issue of differential diagnosis or pattern wound recognition relative to dog bites. If we look at the standard Dr. Russell employed, Dr. LaPosada does not have any of the merit to be an expert in dog bites. While she has taught, we did not hear about anything in particular that she has taught about specific pattern wound recognition analysis regarding dog bites. She is an experienced medical examiner, has a wealth of experience, past experience in autopsies, but she has no experience that is a basis for her as an expert in being a dog bite expert. Particularly, she mentions one case that she's testified in federal court that we've heard of today, and she has nothing whatsoever in her report or resume to establish that she has used, studied, and knows this methodology. In fact, her CV and her report don't have any basis for one to look at and see that she has any specific experience in dog bites. And so Dr. LaPosada, from the Commonwealth's perspective, should not be able to give an opinion regarding or about whether or not the wounds on Mr. O'Keefe were caused by a dog. She simply does not have the training and experience and education and methodology to make her a so-called dog bite expert. Regarding accident reconstruction, she said it best.
Might be
She is
fair.
not an accident reconstructionist. She saw some of the materials in this case, but it is a fraction of the materials in this case. She is not in a position to give an opinion whether or not the wounds are consistent with broken taillight. There is nothing we see on her CV. There's nothing we see in her report. There's nothing we heard on direct examination that she has any experience in breaking glass, breaking plastics, and the causation of wounds. It also overlooks the fact that the opinion that would be offered would extend beyond just the wounds on the arm. It would extend to a general opinion that he was not involved in a collision, and that's improper. There's no predicate or basis for it. And so based on her testimony and absence of being able to provide any education or experience, she should not be able to testify about either of these two matters.
Okay, thank you.
If I could briefly respond.
Okay.
Very briefly. She was, Mr. Brennan suggests that, well, she's only been qualified in one court, federal court, but the federal government, the federal judge that was handling that case qualified her as a dog bite expert in that case. That is not a small thing. That, as a matter of fact, it's a very big thing for Dr. La Posada and her credentials. In addition, she indicated,
Y'all give me 1 second. I'll be right back.
contrary to what Mr. Brennan just suggested, she indicated that she has been training on wound pattern recognition as it pertains to dog bites for her entire career. Not just when she was studying for her boards, since she's been studying for her boards. And it's been constant and consistent throughout her entire career. She's made these differential diagnoses. She's seen the autopsies. She's seen the wounds during autopsies firsthand, probably 50 or more. She's supervised another 75 or more autopsies dealing with known dog bite wounds. She has the credentials. The court will recall that, for instance, Dr. Isaac Wolfe was called to testify by the Commonwealth. He had absolutely nothing, no credentials whatsoever to talk about wound pattern recognition. He was a neurosurgeon, and yet he was allowed, over Mr. Alessi's objection, to talk about and to discuss his opinions and conclusions as to the wound pattern on the back of John O'Keefe's head. Certainly, Dr. La Posada brings much, much, much more to the table than Dr. Isaac Wolfe. I'm not comparing them. They're apples and oranges. Dr. La Posada is she doesn't have to be a sole dog bite expert to be expert in dog bites. She doesn't have to be Dr. Russell. She just has to have that level of knowledge, that level of skill, that level of expertise that's beyond that of the average layperson in order to opine as an expert on a particular issue. She certainly brings that to the table as it pertains to dog bites, and I think her skill and her education, training, and background certainly speaks to the fact that she has that in spades with regard to motor vehicle pedestrian incidents.
All right.
I'll submit.
Thank you. All right, I'll get you ruling as soon as I can. So we're going to start back up at 2:20, and I expect to go straight through the rest of the afternoon.
All rise for the court, please.
All right, guys, here we go. So here's what we're going to do. I'm not going to make y'all sit here and watch the OnlyFans for 40 something minutes. So we're going to switch gears a little bit, and y'all are going to love this if you haven't heard the news yet. Well, let me see. We got a couple super chats I need to read, and then we'll keep it moving. Let me double check and make sure I didn't miss anybody. And it'll be interesting to see what happens with the, hold on a second. We good? Yeah. What happens with this witness? So let me read a couple super chats up in here. First, we've got, where'd it go? Here we go. Shout out to, oh, we got a new timer in the building. Shout out to Lady Divine 18 says, hi there, black girl from Boston. They exist. Amazing. Shout out to Lady Divine. I can't say it anymore, man. Dang. Officer Token is not the only sister in Boston. So thanks for ruining that, Lady Divine. And I appreciate the support. Thank you for stopping by. She says love the channel too. Appreciate you. Shout out to all the brothers and sisters out in Boston, man. Y'all doing it big. All 15 of y'all. We're proud of you. Hang in there. All right, we've got Kitty Cat in here with, oh my goodness, has been a member for 2 months. Says, can I get
niggas lacking
for my 2-month anniversary? Absolutely. Thank you for being a member for 2 months. I appreciate you. We've got Cynthia Hartz in here. Dropping the 10 bomb says, they do not have a case. That's a fact. There was no collision and there will be no mistrial. We gonna see it through, Cynthia. Karen Reed's getting up out of there. I cannot see how a jury in their right mind could say, yes, the Commonwealth has proven beyond a reasonable doubt that there was a collision. Karen killed John. Obviously, she was drunk. She was driving drunk. But there is nothing that the Commonwealth has shown that Karen Reed killed John O'Keefe. Not one thing. Is there like, oh, okay, maybe their story kind of makes sense in some places, possibly, but beyond a reasonable doubt, no, we're not even, this is not, no. Terrible case. We've got Josh Collins in here with the 5 bomb. Says, my mom is watching and I want her to know how much I appreciate her. Shout out to the mamas out here. I love you, Susan Collins. Shout out to Susan Collins in the building. And thank you for the super chat. Joshua, always stopping by and showing some love. Thanks, man. And then we've got Kara up here with the 10 bomb. Says, oh, how I just love the fact that ClassE is the best host there is. All right, relax. I'll take it though. And he has a beautiful wife, Amy, backing him up. Thank you for always showing up and showing out. And shout out, hey, listen, it's not just me, y'all. It's not just me. Y'all see the work that Amy puts into. I appreciate every single one of you that are in here consistently showing up, because we would not have a show, we would not have a community without you guys. So thank you so much. And of course, gotta shout out the beautiful Amy in the building as well. Shout out to Amy. Let me see what else we got here. What are y'all saying about that last witness? We said, if she doesn't let it in, I say we all start calling in complaints on her. That's not gonna do anything. That's a good thought though. We've been complaining this whole time. Nothing, it's not gonna make a difference. There's no evidence to prove Karen did anything other than she drove while under the influence. Yes, that is very much clear. And Amy brought up a great point. Amy, when did you say this? Amy said this the other day. She said it was interesting that John O'Keefe, knowing Karen had been drinking and that they had been drinking together, was like, hey, you just make sure you drive. Because he was more concerned about him risking his job and getting a DUI and being able, I guess, to get Karen out of a DUI if she for some reason got one, than he was about her safety, which is weird. And I said, dang, I was like, dang, I hadn't even thought about that before. It's very, a very interesting situation. But overall, I mean, the man didn't deserve to die, in my opinion. And it's sad to see it turned out this way. And it's even more sad that I don't think we'll ever truly know what happened to John O'Keefe, because it's clear to most of us that Karen Reed didn't do this. And the Commonwealth hasn't proved that she did either. We've got, oh, look at her. Cynthia Hart's in here again with the 5-bomb. Says, I meant no way Bev was going to call a mistrial. Yep, I figured that's what you meant. Thank you so much. And we've also got Slim Life in here. Slim Life, New Jersey with the 5-bomb says, to piggyback off of Kara, and we all have each other's backs and agree to disagree with respect. Love my chat family. Thank you for that, Slim Life. This is not an echo chamber, guys. As a matter of fact, I don't like it when everybody in here agrees. I do not like it when we all agree. I love seeing differing views, differing opinions, and I think the only way you can get another perspective and grow is to have those differing opinions and views. So if you have a differing opinion from what you're hearing me say, from what you're hearing in the chat, in the comments, we created a community and a chat to where it's a safe place for you to have differing views. So if you're watching, you're like, I don't know if I want to say anything, I disagree. Be respectful. Don't call each other names. All right. And we'll be good. So you can give your opinions, even if they're strong opinions about Karen Reed. Even if you think Karen Reed should be under the jail, that's okay. Because at the end of the day, we all have opinions about this, and it could be any one of us that would be on the jury. So you never know. Amy's in here. She's ready for lunch, man. She's got the cake. She's got the ice cream. There she is. She's always in here. Shout out to Amy. And I think I got all the super chats. I need to double check. I got Brenda over on Cash App. All right, we're good. So blue paint or Randy? Yeah, which one do you prefer? Would y'all rather have blue paint at 2 miles per hour in a little bump? Or would you prefer a Rescue Randy actually mimicking or recreating or reconstructing what the Commonwealth is alleging happened? And it's so stupid. I mean, from a defense standpoint, as a defendant, it's so dumb that they even had to spend the little $50,000 they did on ACA to recreate this whole thing, because the scenario doesn't even make sense to me. And a lot of you would think the same thing. So the fact that ACA even has to be here is kind of ridiculous at the same point. CPE says the most of us can see this one for what it is. Yep, right is right and wrong is wrong. Many of us think the same, and some who think differently. We all have to respect each other's opinions. I agree. Honestly, if I was on the jury, I would laugh at Hank. Yo, this was hilarious when Hank said he made a mistake and somebody said, "Tss." I hope y'all can hear it. Let me, here we go. I want to find out who did this, because he was not happy. Check this out. And what did Amy say? She said, come here. Oh, I see you, Amy. Thank you for the super sticker. Hold on. Relax. Here we go. Check this out.
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake.
That person sits. Yo, that killed me. Oh my God. Yo, get it together. I want to know who it was. You can see. You can see him turn his head. Oh, that's crazy. I gotta play it one more time.
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake.
Yo, get this guy out of here, man. The Commonwealth is done. He was pissed. Amy with another super sticker. She said, wait for it. Coming soon. Yeah. Yeah, shout out to Amy. It's lunchtime. Amy's ready to go. the cake and the ice cream. All right, so here's what we're gonna do. We're gonna switch gears a little bit, and y'all are gonna enjoy this. And it may be a sad day for some of you. It's kind of a bittersweet day for me because let me get this set up. Let me get this updated. We have the YSL trial. We were supposed to start the YSL trial soon, but it's looking like it's officially over. The final defendant remaining in the YSL trial, Christian Eppinger, is taking a plea today. And he actually took a plea. So what we're going to do is we're going to react to it live. I'm going to bring Judge Whitaker up here for what may be the last time we've seen her until she makes it to the Supreme Court. I'm going to support her, and hopefully she does. Let's go ahead and get into it. Oh, man. I can't believe it. I can't believe that after all this time, we made it here. And of course, it's going to be hard to hear. There's Christian Eppinger himself. This dude's a menace. It might be panned a little bit. Let me see. I just want to make sure it doesn't get loud. So, let me see. Yeah, it's super quiet. Hold on, y'all. I'm going to turn it up for you.
Come to the podium. Can one of y'all come up and swear in, please?
Tell me if the volume's good. Yeah, it still looks like it's quiet.
All right. Who's going to be handling this for the state? All right.
Is that better? All right, the sound should be good. It's still low. All right, I'm just gonna crank it then. Oh, you know why? This isn't even on. I did all that and this isn't even on. Here we go. Now y'all should be able to hear.
Following charges in this indictment. Count 1, conspiracy to violate the RICO Act, which carries a sentence of 5 to 20 years.
That should be a lot better.
7, armed robbery, which carries a sentence of 10 to 20 years or life. Count 28 of this indictment, hijacking a motor vehicle in the first degree, which carries a sentence of 10
Should be good now. Is it good?
and a $10,000 to $100,000 fine. Count 29, possession of firearm by first offender probationer, which carries a sentence of 1 to 10 years. Count 31, theft by taking.
Let me do a little bit more.
Minimum and maximum sentence of 1 to 5 years.
Good. Perfect. All right, y'all give me 1 second. I gotta handle something real quick.
Count 33, attempted murder, which carries a sentence of 1 to 3 years. Count 34, possession of firearm by first offender probationer, which carries a sentence of 1 to 10 years. Count 35, possession of firearm by first offender probationer, which carries a sentence of 1 to 10 years. This is what you're charged with. Count 36, possession of firearm during the commission of felony, which carries a sentence of 5 years to serve consecutive to any other count of indictment. And possession of firearm during the commission. Count 37, possession of firearm during the commission of felony, which also carries a sentence of 5 years to serve consecutive. Count 38, participation in criminal street gang activity, which carries a sentence of 5 to 20 years. In count 38, another count of participation in criminal street gang activity, which carries a sentence of 5 to 20 years. And count 47, conspiracy to commit a crime, which carries a sentence of 1 to 10 years. Do you understand that you have the right?
Hang on, isn't there a 48 also?
And count 48, criminal street gang activity, which carries a sentence of 5 to 20 years. Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial. Have you had enough time to speak to your lawyer, Mr. Johnson, about all the facts and circumstances known to you regarding the charge of this indictment? Have you spoken to him regarding any potential defenses? Do you need any more time to discuss this case with your attorney? Are you satisfied with his counsel and representation? Do you waive formal reading of the indictment? And do you waive any defense? if any, with respect to the indictment. So your knowledge, have you been arrested?
Hang on, Mr. Johnson, that's normally addressed to the attorney. Do you waive that?
Yes, Your Honor.
All right.
Do you waive, have you been arrested on these charges, Mr. Eppinger? And Your Honor, the state is unaware of any outstanding warrants related to these charges. Mr. Johnson, do you know of any outstanding warrants related to these charges?
Related to these charges,
And Mr. Eppinger, I just advised you of the minimum and maximum for these sentences. Are you aware of them? Do you understand that in pleading guilty for armed robbery, you are pleading guilty to a serious violent felony? Do you understand that you will serve the entire prison portion of the sentence imposed for a serious violent felony without the possibility of parole? Do you understand that while you would be eligible to be considered for participation in the Department of Corrections Administered Transitional Center or work release program in the final year of your incarceration, you will not be eligible for any other sentence reducing program of the Department of Corrections or Board of Pardons and Parole? Do you understand that neither the court nor the district attorney's office has anything to do with parole or the Department of Corrections? Do you understand that this plea is a blind plea, also called a non-negotiated plea? And the state will recommend it. Your Honor, can we do what our recommendation is?
That's fine.
Okay. Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that which is recommended by the state?
Yes.
Do you understand that if you enter a non-negotiated plea, you do not have a right to withdraw your plea once the sentence has been announced? Do you understand that this is a guilty plea, which is permanently recorded on your criminal history? Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal court?
Yes.
Do you understand if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws in any governmental units or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm on probation? Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial, and that this is true regardless of the advice by your attorney or anyone else?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison? Do you understand you waive any and all defenses, including any mental health offenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? And Mr. Eppinger, I'm going to ask you to say yes, ask each right that I will.
Well, say yes if you understand that that's the right that you're giving up and you want to give that up. Say no if that's not the right answer. Say I don't understand if you don't understand. Okay?
The right to a trial by jury.
Yes.
The right to remain silent and not incriminate yourself.
Yes.
The right to confront witnesses and
Yes.
your right to assist with counsel hired by you or to court-appointed counsel seeking out for an attorney in a trial of your case.
Yes.
The right to the presumption of innocence.
Yes.
The right to testify on your own behalf and to present other evidence. The right to subpoena witnesses and compel the production of evidence.
Yes.
The right to have a charge against you proved beyond a reasonable doubt.
Yes.
The right to appeal if convicted of these charges after a trial. Has anyone forced, threatened, or prompted you anything to get you to enter a plea of guilty?
No.
It is my understanding that you're asking the court to consider this plea under North Carolina versus Alford.
Yes.
And is that every count that he's going to be pleading to?
Yes, Your Honor.
All right, well, I'll have to hear why.
Is it your decision to waive these rights and enter a guilty plea because you are a felon? Guilty, or are you pleading under, or asking the court to plead under North Carolina v. Alford? Are you pleading guilty because you have decided it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and puts you in the same position as if you were convicted by a jury at a trial?
Yes.
Now, Mr. Eppinger, based on the negotiations, do you understand that you are pleading to the following counts?
That the state's going to move, you're, as a part of this plea, going to be null crossing certain counts?
Yes, sir.
All right, what is the state moving forward on?
Your Honor, the state is moving forward on count 1, conspiracy to violate the RICO Act. Count 27, armed robbery. We are going to null cross count 28, hijacking the motor vehicle in the first degree. We're moving forward with count 29, possession of a firearm by first offender probationer. We're moving forward with count 31, theft by taking. Count 32, attempted murder. Count 33, attempted murder. Count 34, possession of a firearm by first offender probationer. We have null crossing count 35, possession of a firearm by first offender probationer.
Count 35 was dismissed, so that's not null crossing.
Excuse me, Your Honor, during the first charge. Count 36.
Wait, back up. What do you mean by the first charge?
During the first series of the case, Your Honor, that case. Count
35 was?
Yes, Your Honor, the defense, we filed a motion to have that count dismissed.
All right. All right.
34.
Okay.
Count 36, possession of a firearm during the commission of a felony. We are null crossing count 37, possession of a firearm during the commission of a felony. We're null crossing count 38, participation in criminal street gang activity. He's pleading to count 39, participation in criminal street gang activity. Count 47, conspiracy to commit a crime. And count 48, participation in criminal street gang activity. Mr. Evinger, with respect to those charges, if I need to read them again, how do you plead to those charges to which you're pleading to?
Yes.
Is this guilty plea freely and voluntarily given with a full knowledge of the charges against you?
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have 4 years from today's date for all the felonies, to file a habeas corpus petition challenging the constitutionality of the guilty plea?
Yes.
Do you also understand you have 30 days from today's date to file a direct appeal from this guilty plea, and until the end of this term of court to file a motion to withdraw this guilty plea, which does not mean it will be granted? That's just the time period that you can file. Do you understand that?
Yes.
And Your Honor, in this case, we're going to go to trial.
Is this something that's on Zoom?
Yes, Your Honor. The state would expect to show a number of different things as we move forward with this indictment, Your Honor. As you have heard, this is the YSL RICO indictment, in which the YSL gang is an enterprise consisting of a group of individuals associated with that. Although not a legal entity, they were started in 2012 in the Cleveland Avenue area of Atlanta, Georgia, and they claim affiliation with the National Blood Gang. The founders were Jeffrey Williams, aka Young Thug, also known as Slime, Walter Murphy, also known as DK, and Chartavius Stephens, also known as Blood. They identify with a variety of identifiers, including colors, clothing, tattoos, and hand signs, as well as verbal and written identifiers. They often wear clothes with the word Slime and YSL, and also have tattoos with the name YSL. Specifically for Mr. Eppinger, Your Honor, he has several cases in this indictment. Your Honor, under count 1, the RICO conspiracy, Mr. Eppinger had an armed robbery in May of 2016 with the victim, Tivia Hill. He was convicted of that crime, spent 4 years in prison, and was released in May of 2021. In October of 2021, Your Honor, he did the armed robbery of Mr. Darius Smith.
All right, so did that May 11th armed robbery, did he, was that a first offender conviction?
It was a first offender conviction. It was reduced from armed robbery to robbery. And I'm going to go into more detail, Your Honor. I'm just going to give an overall timeline. In January of 2022, there was a theft by taking. About 3 weeks later, in February 7th of 2022, was the attempted murder of Officer Rogers and Sergeant William Johnson. And then in February of 2022 was a conspiracy to stab and kill Mr. Ray Sean Bennett. Your Honor, we went over the crimes that were charged in this indictment. So again, on May 11, 2016, which is Act 61 of Count 1, the RICO conspiracy, this happened at 245 Mall Drive Southwest, which is in Atlanta, Georgia, in Fulton County. The victim, Ms. Tivia Hill, was coming home that day with her daughter Mr. Eppinger arrived in the subdivision with 3 other males in a vehicle. He got out of the car, held Ms. Taravia Hill at gunpoint in front of her daughter, robbed her, took her vehicle, and went and fled the area, Your Honor. He was picked up about an hour later off of Cleveland Avenue, where he actually got into a car crash off of Cleveland Avenue. This is some of his the middle picture, the picture of him on social media in and around the time of this armed robbery, Your Honor. That is, the picture on our left is the area where Miss Taravia Hill was robbed, and then that is the car that he stole from her, and then ultimately got to a car crash. And at this time, Your Honor, Mr. Eppinger was going by the moniker on his Facebook page, YSL. His name is Christian, but he changed the B to C with the same moniker that the blood they used back in the day. As I mentioned, Your Honor, he was convicted of this crime in December 2016 with a negotiated plea. The victim, Ms. Hill, came in, understanding he was 16 years old at the time, asked for leniency for him, in which his armed robbery was reduced to robbery, and he received a sentence of 10 years instead of 4 years balanced on probation. Mr. Eppinger got out of custody in May of 2021. Within 5 months of that time, he was back on the block of Cleveland Avenue with his YSL associates. In this picture specifically is Durante Beebe, and Mr. Eppinger is in the middle, wearing Keep America Slime Against flat clothing and all of those same monikers that came with YSL in the game. And this is on September 29th, 2021.
And was there a probationary condition that he not be connected with non-gang members?
Yes, Your Honor. Within 3 weeks of that picture, Your Honor, we had the armed robbery of Darius Smith on October 12th, 2021 at 47 Cleveland Avenue, which is also known as the Cleveland Avenue Park. This is where a number of YSL gang members hung out. And
this is going to be counts 27, 28, and 27 and 29
yes,
of our indictment. Okay.
Yes, and while Mr. Darius Smith was at the park that morning, hanging out with a friend because he was waiting for his brother, the defendant, along with Durante Beebe, approached Mr. Darius Smith, holding a gun to his head and to his side. They stole his watch, his chain, his earrings, his wallet, and ultimately they also stole his white beard. This happened about 4:15 or 4:45 p.m. That afternoon. While there are kids, this is a library, Your Honor, so in the front of the park is a library, and in the back is a playground area. This is just some of the surveillance video, Your Honor. So what you're going to see in this surveillance video in a few moments, we believe that the robbery happens to the left of the screen, to where the cars are coming from. And so you can't see the robbery off camera, but what you're going to see, and I want you to notice, the adult woman, they keep looking in that direction. We believe this is where the robbery is taking place. You see them rushing to get into the car, and then you're going to see another young man come down the steps, and she kind of flags him, tells him to hurry. So we believe this is the point in time the robbery is ending, and the vehicle that's stolen is in the background of this video. For this case, Your Honor, the state had phone records. We were able to get the phone records for Durante Beebe. He was using his phone at the time, or in and around the time of our robbery. Mr. Eppinger was not. What we have is, at the bottom of the screen, Mr. Beebe's phone pings in the location of the robbery, and then we see his phone pinging later on in the afternoon to where the car was recovered, which was not in the same location. The car was actually recovered at the village at Castleberry Hill, which is about 10 minutes or so from this location. This is the victim, Mr. Darius Smith. You see him wearing his chain prior to the armed robbery, which was one of the most significant pieces that they stole because his chain was very distinctive. At the time, he was a rapper. He went by the name of Trap Commander, and the chain says Trap Commander on it. After the robbery, we had Sergeant Pierre, who was the lead detective on this case, was able to get Instagram records of both Durante Beebe and Christian Eppinger. And what we found after the robbery, Durante Beebe is holding the chain, so that's him on the end. And then we found that Mr. Christian Eppinger we believe actually bragged about the robbery, and that's the video that's going to come next.
How much I can get from about that. So you can put 1,090 per. You got that motherfucker back. I ain't gonna wait. Might well say, you know what I mean? You got flat. So go. I'll take that. I'll take that. You see that bitch busting outside? Put it down, man. Huh? You can tell that to everyone. Why you here? Oh, no. Catch it again, take your time again, buy it back again. It's the same way you did when I took the gun off. You can have it. You can have it. I got it. Huh? I made it sit down on the curb. They thought you were going to get in the car, but I made it sit down on the curb. I seen the earrings in the ear. Oh, take the earrings out too. You gonna do it like that? Yeah. Need everything, boy.
Your Honor, so in that clip, he's talking about taking the chain and he's trying to sell it back to the victim. He also talks about the watch, the earrings, and all the items that were taken from Mr. Smith. And then he talks about the fact that he put the gun to him and put him on the ground. When we met with Mr. Smith, just to understand what happened to the case, I asked him, what happened to you? He said, the defendant put me on the ground, he made me sit on the ground before taking the items. And so we believe that this is him bragging about that armed robbery, and this was posted about 4 days after the armed robbery. The next, Your Honor, we have overt act number 149. Again, Mr. Eppinger is with 3 other YSL associates, Durante, BB, as well as Mr. Mooney Lee, also known as Slime White Shorty. So again, posting pictures in the same clothing, OTS, only the slime clothing. Then he's posting on social media, Cleveland gave me the game, YSL gave me my name. We were studying back then, we wasn't studying the thing. Free ESPN, which we believe every slime plays nasty. The real ones, not the play plays. So again, him posting about the game, and then him with guns and things of that nature, this is all on his social media. Then we have January 22nd, 2022, Your Honor, which is count 31 of the indictment of theft by taking. This is at the Zaxby's on Northside Drive. The victim in this case, Mr. Willie Moore, was a Uber Grubhub driver. He was picking up an order for a customer. He walked inside of the Zaxby's, and this is the surveillance video from that incident, Your Honor. That's Mr. Eppinger in the black hoodie. That's Mr. Moore walking into the Zaxby's. You see that Mr. Eppinger turns back around, leaves his friends, gets into the vehicle, and then drives off with the vehicle. Mr. Moore did not give him permission to drive that vehicle. After this incident, a bolo was put out. Members of APD gang unit, Sergeant Johnson, they were able to immediately identify him as Christian Eppinger. The car was later recovered 3 days later by Officer Cogdale at 340 Thomasville Boulevard, which is in southeast Atlanta, with now bullet holes in the car that weren't in there previously. And then next, Your Honor, we have February 7, 2022, in which officers were doing an operation to arrest Mr. Eppinger on the armed robbery warrants from October 12, 2021. They had plans, an operation in order to get Mr. Eppinger arrested. It started off with some surveillance at a house off of Clear Drive. They saw Mr. Eppinger leaving that house. There was one officer, Storno, or Investigator Storno from the gang unit, who gave information to some of the other officers that were helping with this detail. Those officers included Officer Rogers, Officer Teasley, and a number of other individuals who were preparing to participate in assisting with this incident. And what essentially happened, Your Honor, is Officer Sergeant Johnson was able to, he was doing something else, but he was able to get to the Cleveland Avenue area within moments of this occurring. As I said earlier, Officer Storno was following Mr. Eppinger, giving updates on his whereabouts. They eventually ended up at 221 Cleveland Avenue, which is the Chevron gas station, which sits at the corner of I-75, 85 and Cleveland Avenue. Mr. Eppinger walks into that store. Sergeant Johnson's able to have eyes on him to update what his movements are.
Sergeant Johnson?
We have Sergeant Johnson, Officer Rogers. So Sergeant Johnson first gets on the scene. He's able to update the other officers about Mr. Eppinger's movements. Mr. Eppinger leaves that location and begins walking towards the apartment complex, which is Colonial Drive. At that time, Officer Rogers, who's in his marked police car, is following behind. He sees Mr. Eppinger walking in. Officer Rogers then, in his patrol car, begins to follow behind, entering into the apartment complex, Your Honor. At that point in time, this is where the video picks up, Your Honor.
Right, and this is Officer Rogers' video.
Yes.
61, 70, 61, 61,
Your Honor, what you see happens is Officer Rogers in his marked uniform, Your Honor. He is in the marked uniform. He sees Mr. Eppinger. He tells him to get down, get out. He's in his marked patrol car, in his marked gear, similar to something when he has on today. He is in the courtroom today, Your Honor. When he gets out, Mr. Eppinger does not follow or comply with any instructions, Your Honor. He asks to put the gun down, get out the car. Mr. Officer Rogers actually, and what you can't see, is actually trying to go from his firearm to his taser in order to reduce force. When Mr. Eppinger takes out a gun from right underneath his arm, this is where he's holding it, turns around and begins shooting. At that time, Sergeant Johnson had came in right behind him, and so I'm going to show you this angle, Your Honor, so that you can see what actually transpires in another angle. and you see Sergeant Johnson next to him on the left-hand side duck. Mr. Eppinger returns fire back towards him as Sergeant Johnson is trying to protect Officer Rogers because he has now shot Officer Rogers 6 times. Officer Rogers has 6 gunshot wounds, 4 to the right shoulder, to the posterior thigh, and 1 right and posterior scalp. I mean, it almost grazed his head, Your Honor. Only by the grace of God that Officer Rogers is still here with us today. At that moment, officers did not wait for ambulance. They actually put Officer Rogers in the Investigator Soren's vehicle, who arrived shortly thereafter, and then transported him to Freedom Hospital. Now, this is Mr. Eppinger and phone call from after.
What is you think? I don't give a fuck about loot work. I really want thinking, bro. That shit happened so bad, bro. That shit happened so bad, man. I'm so hot, man. I be ran out on this bitch. I can see that shit. I was seeing that shit like, yeah, I'm like, that nigga big pretty shit. Nah, bro. That wasn't bad. Everybody keep talking about, I'm tripping. Hell nah, they can run out on you. Could have kicked on you, but then you gonna you gonna vote? So what you gonna tell them folks? I ain't gonna tell folks shit. Man, niggas. And then you start, and then you gonna tell them folks. You know what happened to them? Hell nah, boy, you funny ass. I'm like, what you gonna tell them folks, bro? I'm gonna hear you gonna say, cause you ain't got no explanation, boy. Like, what they mean, listen. They had no being to run up on me, point they gun at me, man. I'm like, get out. I'm getting out, boy. I ain't getting out. Somebody told me they call it 12 when you went up there. Yeah, somebody, I don't know who it was, though. Who was all up there? They said it was an informant. I don't know. Somebody wasn't gonna vote, though, son. It was a fault. Somebody wasn't gonna vote. Oh, dang. Breathe. Yo. The police, they ain't done ever. You know what? And the police, they hate you. Man, listen, you might not know my name, bro. Hey, I'm calling you like going for that shit, bro. I ain't just talking, bro. I just want to ask you just to tell you really make all this type of shit. I just want to make sure that shit ain't, you know. Man, this all snake, nigga. They ain't touch me. What the fuck, man? Y'all know me, bro. Come on, bro. Y'all know me, bro. I'm not going out there in or out there, bro. That's it. I said that shit too. I said, they might be pretty not to go off that. What? They give me talking shit like, oh, you ain't never going home. So, where your pocket shot? What? What they say you never going home? Yeah, you know they trying to get like it, bro. Yeah, I know. Man, you know what it is, man. Free BBT, free. I ain't even trying. I ain't trying to be in my for my life. I damn sure what time we dead. But if you would have to call me page, it would have been different, bro. I thought we just ran. You mean? Yeah. Man, I got scared. You get that blick on me. I popped out with a gun, not so I lay down. Yeah, with a gun? Yeah. People pop. Yeah. Yeah, I ain't gonna keep talking about that shit on the phone, though. I'll just call it. Yeah, I'll just speak. Hey, free. Yeah, I miss y'all hearing me, though, but y'all, my favorite youngest, bro. Man, look, so y'all is stupid here, man. First, you don't got all like the phone and shit, bro. I'm like, bro, it's flags off his phone. I know. He's talking about whoever caught my phone in round one, y'all count our days. I think that shit before I got up. I need y'all to do me a favor, though. What's up? I need y'all to drop one of the phones right quick, bro. My shit is going up, bro. Yeah, let me go look at your face. Nah, we go look at my views on YouTube. You got a phone down there yet? No, man, I got no phones in my shit. I'm on my tablet.
So, Your Honor, while on the phone,
What's the worst nightmare, friend?
you heard him laughing about the fact that he shot Officer Rogers, and then it's callous enough at the end.
I'm gonna tell y'all right now, those police officers are not happy about this. Y'all holding up over there?
Injuring an officer while he was trying to do his duty.
They're not happy about this.
Because
There's no way you shoot a cop and
Yeah, man. Free my nigga Big Breach, man. Yeah, man. Last boy, yeah. Fuck that boy. Fuck that boy. Strike that baby. Yeah, man. Free my nigga Big Breach, man. Fuck the DA. Yeah, we catch some fun on this shit. Yeah, we about to get that fun for it. We come to catch. You know what it is. Yes, sir. That shit is free game. Yeah, YSL shit. Yeah. Slack game.
stupid, man.
Yeah, man. Slack, man. Free game. That nigga boy fun though, so that nigga boy fun. Okay. Bro, it's on the young boy. Yeah, man. Come on, nigga Big Breach, man. By the way, the game way. Big Breach was a big hit, man. They gave my nigga a bun today, man. You smell me? What is that? They gave my nigga a bun today, y'all. Shit crazy.
They don't care.
And that was Rodalius Ryan, while he was in prison, posting YSL the gang way because he was receiving bond for this horrible thing.
All right, well, let's see if we can skip forward to the sentencing, because I know y'all seen most of this.
While Mr. Eppinger is in custody at the Fulton County Jail, which is now count 47, count 48 of the indictment, Your Honor, conspiracy to commit murder. On February 2022, Jada Myrick had stabbed Rayshawn YSL Lucy Bennett while in custody, Your Honor. And that is Mr. Bennett.
Oh, I want to hear what this officer has to say. Hold on.
Of that stabbing that occurred on
Again, I told y'all this dude was a menace. The Kristen Eppinger was a menace and is a menace. Yeah, this guy was I'm glad he's off the streets. I live here in Fulton County too, and get this dude and anyone like him out of here. Shout out to Amy. Excuse me. Shout out to Amy, said yum. Absolutely. Thank you, Amy, for the super sticker. We got Karen here, gifted 5 memberships. If you got a membership from Karen, say thank you, y'all. Show her some love and say thank you. And then also, let me see. Love must be in hiding. Oh, they about to get rid of her. Y'all think Miss Love's gonna make it? I don't know. She's probably on the chopping block, to be honest. But let's go ahead. I want to get into this officer's testimony real quick. And then Karen Reed should be back here shortly. But we gotta get through this because I want to hear what this officer has to say.
Thanks for that clarification.
And are we giving a recommendation now or a recommendation?
Yeah, I'd like to hear your recommendation. I'd also like to hear what his criminal
Truly
history
blessed. He was bad.
now, other than what we've already discussed, because I believe
He was already a felon.
convictions.
No, Your Honor. So his only criminal conviction now is the robbery. He was revoked. His first offender was revoked, Your Honor, and he was resentenced on April 22nd, 2022.
Dummy.
And he received 45 years to serve on the resentence, Your Honor. And he had
Terrible.
juvenile history, Your Honor.
What's his juvenile history?
We do not have the juvenile charges.
Okay, what's the state's recommendation?
Your Honor, the state's recommendation is to ask count 1, conspiracy to violate the RICO Act, 20 years to serve. As to count 27, armed robbery.
They'll get him for RICO.
20 years to serve, concurrent.
Everybody got RICO charges.
Count 29, possession of a firearm by first offender probationer, 10 years to serve, concurrent with counts 1 and 27. Theft by taking, 5 years to serve, concurrent with count 1, 27, and 29. Attempted murder, count 32, 20 years to serve consecutive to count 1, 27, 39, and 31.
And shout out to Simone Hilton over there, by the way.
Attempted murder, 20 years to serve consecutive to count 32.
No, Kristen Eppinger has been in jail since they picked him up.
10 years to serve concurrent with count 33.
A couple of years now. Ooh, Lord, y'all look at this. Possession of a firearm by a first offender. We got 10 years to serve concurrent with count 33. No pros, the firearm by a first offender, probationer, it doesn't matter. Possession of firearm during commission of a felony, 5 years consecutive to count 33. 33 is the RICO. No. That's not count 33. What is count 33? I should have had the indictment ready. Either way, but it doesn't matter. He's going to jail for a while. We've got possession of a firearm during commission of a felony. No. We've got participation in criminal street gang activity. We've got 20 years to serve concurrent with count 33. Conspiracy to commit a crime, murder, 10 years. And then we've got criminal street gang activity, 20 years to serve concurrent with count 39. Jesus, man.
Possession of a firearm during the commission of a felony, 5 years to serve.
This guy should not be on the streets.
To count 33. Count 39, participation in criminal street gang activity, 20 years to serve concurrent with count 33. Count 47, conspiracy to commit a crime, 10 years to serve concurrent with count 39. And count 48, participation in criminal street gang activity, 20 years to serve concurrent with count 39. So that means 65 years to serve. We're asking
65
consecutive to his probation violation, which is 16 SC 143618.
They're trying to give the two 75 years.
Yes, Your Honor. And Sergeant Johnson would like to address the court at the appropriate time. I'm sorry, Your Honor.
Yeah, and those of y'all asking, he was already a convicted felon. So, this guy's no good. Attempted murder. In 2016, an armed robbery that we just heard about, and aggravated assault. He was 16 years old and was convicted to multiple felony charges and given first offender deal, originally 10 years with 4 years served, already amended to a 64-year total sentence related to 2016. So this dude, he couldn't even make it that time because then he got a probation violation in 2022. While under the first offender probation for those felonies, he was later accused and arrested for armed robbery in October 2021 that violated his probation status. And then he got arrested a year later for shooting a police officer.
I'm Sergeant with the Atlanta Police Department.
Get this guy out of here.
At the time of this event, I was a detective with the AP gang unit. I was operating undercover capacity. Just kind of laid out the event. I mean, you've seen the video. And just my background, I've been in the department for 18 years. Prior to being in APD, I was in the Army. I was in the 75th Ranger Regiment. I have 4 combat deployments.
Thank you for your service.
Been in firefights, gunfights, grenade fights, rocket attacks, IEDs, car bombs. I've had a lot of experience with trauma. I think this is the most traumatic event that I've ever experienced in my life. And I think and it's not because of a gunshot, somebody getting shot, or you see this all the time. It was just the intent and the act. It was an execution. It wasn't an attempt to get away.
Hostile territory.
It wasn't a fight or flight type, or it wasn't a flight in the fight, right? He was trying to fight. He wanted to kill this officer, and he made every attempt to do it. He didn't take a shot and run. He stood there and fired round after round after round into Officer Rogers. And it was probably one of the most helpless events that I've ever experienced.
It'll mess you up.
And he didn't even run until he started getting shot at, and then he fled like a coward. And so I think about this day all the time. It comes back and forth in my brain all the time. I know with Officer Rogers, he does the same, and it's probably not going to change. I think back to like when I approached him. I remember like the look on his face, and I've seen that look so many times, and it always ends in death. And so when I looked at David, I thought, there's no way he's gonna live. There's no way. He had that glassy look, that stare that was just gone. The light was out. And we tried everything we could on scene. He was shot so many times, so there was so much blood. I remember there was just so much blood, I could taste the blood, the iron in the blood, like I tasted it for like 2 days.
Dang.
And so I remember my clothes, I was just like, that was the other thing. I remember I was just covered in blood, like from chest down. I'm sitting here covered in blood, and I'm sitting here for like hours afterwards, covered in this blood, smelling this blood, and waiting to make statements and everything, and not even knowing how he was doing. I'm thinking he's dead, and this guy just got away with it. And so, I guess I'm just here to ask you. I mean, so like our ability to do this job. And when I go to work every day and put on this uniform and kiss my kids goodbye, we don't know if we're coming home. And we
he shot at this officer.
Kind of part of our job to just be prepared for that.
And he shot.
But our ability to do that is backstopped in the belief that you, Judge, and the courts are going to show up for us the way we show up for you. And so that's basically what I'm here asking, is for you to show up for us and to provide whatever, I didn't even catch what the max was, but whatever the maximum sentence that you could provide would be appropriate in this offense.
All right, I appreciate you sharing that.
Thank you.
Officer Rogers was present for when he did that.
Yeah, and I actually recall Officer Rogers' testimony from the prior trial. All right, Mr. Johnson.
Yes, Your Honor. Before you stand against the person that was there, said before the 25-year-old lifetime amount of resident, Your Honor. And as an attorney, I want to thank you for the opportunity to provide this plea today. Please represent Mr. Effinger.
You're not welcome. Get this guy out of here.
From the beginning of the first trial, I have a unique perspective of this entire case, Your Honor. And I just want to extend my appreciation to all the members of the state and their tireless work in this particular matter. Your Honor, however, we must say, this entire case, as evidenced by the state's recommendation and evidenced by the officer who just testified, this entire case has been a witch hunt against Mr. Effinger solely because he was involved in a situation with an officer. The reason I say that is the state just presented to you a timeline of events. If we go back to the first event in 2016, Your Honor, Mr. Robbie Hill testified at the original trial. In that case, and nowhere in the discovery is there any mention that the other individuals that were with Mr. Effinger, that they were affiliated with YSL, that Mr. Effinger was wearing any red clothing or anything else, that Mr. Effinger had the YSL tattoo on his face. The car was recovered shortly thereafter, so there is no showing that this automobile was stolen to benefit, profit, or to help YSL in any way.
All right, now that's the 16 SC case.
Yes, Your Honor.
That's already been taken care of.
What I'm saying is, Your Honor, that is alleged in this case as Act number 61 for the RICO count. So what I'm saying is, they are alleging that that is part of the RICO, and there is no allegation whatsoever, any facts that my client was affiliated with YSL at that particular time. So moving forward to the other incidents on this case, Your Honor, there's a situation involved the October 12th armed robbery in this case. And we'd like to point out that my client is charged with these particular offenses. And it also is evident that, as I said, the state is attempting to get Mr. Effinger because there was a co-defendant on these charges as well, Your Honor, Mr. Durante Beebe. And the state recommended a sentence of 10 certified for Mr. Durante Beebe for these charges. And I think that is very important because Mr. Durante Beebe was the individual who was immediately identified by the victim in this case. He was identified some by his facial features, but also by physical disfigurement on his hand. And it's important to point out that the victim in this case, Mr. Darius Hill, who would have testified in this case, additional evidence would have come out. That his initial report to the police officers, he gave a description of an individual.
Too bad. Get him off the streets.
In his first conversation with the officers, when he went to the police officer, he identified another individual as being the person who perpetuated the crime. He stated that he was given that information because this was word on the street. So there was no viable information to identify Mr. Effinger as a participant in this crime. Later, the officer who would have testified as Matthew John Pierre, who was the lead investigator on this case, Your Honor, he would have testified that they received an anonymous tip telling them that Mr. Effinger had been involved in this situation from a person who alleged to have viewed the robbery. Your Honor, the witness in this case testified that the individuals who perpetrated the robbery were wearing masks and he could not identify them. So it's very hard to say that an anonymous tip who says that they saw this in masks would have been able to identify Mr. Effinger. That is why Mr. Effinger's name was involved in this particular case. And subsequent to that, the witness went in to meet with the police officer to identify a photo lineup. Mr. Effinger was identified in that photo lineup. However, Your Honor, the video, if this matter went to trial, the video of that interview would have shown irregularities by Mr. Matthew John St. Pierre in conducting this lineup, where when presenting the information to the victim, he took Mr. Effinger's picture from the bottom of the stack, placed it on the top out of order, and then shoved it in his face for him to make a selection, at which time he picked Mr. Effinger. He had no prior information regarding Mr. Effinger. He did not know Mr. Effinger or anything else like that. And that is very important, Your Honor, because the state in this matter is alleging that a video that you heard Mr. Everett that was made on October 16th is him bragging about this robbery. In that video, you hear him saying that, you hear Mr. Everett saying that he has contacted the person attempting to sell something or whatever. That is important because that video was made on October 16th. The identification of Mr. Everett was not made by Mr. Hill until October 20th, Your Honor. And at no point in his conversations with him had he mentioned that he had been contacted by the person who tried to who had robbed him, that there was an attempt to sell back anything. And also, Mr. Everett on the video stated that the person he was attempting to sell the change was coming from Henry County, and Mr. Smith states that he lives in Forest Park. So he would not have been coming from Clayton County, Your Honor. So there are numerous inconsistencies. Nowhere in that video is Mr. Everett being involved with a co-defendant in conducting this robbery. As Mr. We know Mr. Everett is present. Nowhere does he mention conducting a robbery with another individual, and nowhere does he mention taking a van or anything. And also, Your Honor, in that armed robbery, that van was recovered shortly thereafter too, so there is no showing that the van was taken
Well, there's
to be
that
sold
part.
for YSL benefit, to be sold for YSL transportation, or to benefit anything other than possibly the individuals who took that car, taking it for a joyride at that particular time. Mr. Smith testified that his car was ransacked, but it was not damaged, so there was no items stolen off of his car or out of his vehicle.
And that's the count, one of the counts that's being null crossed, right? The hijacking motor vehicle?
Yes, Your Honor.
But it goes to the armed robbery, Your Honor. It's very important.
I understand, I'm just trying to make sure I got it all.
Because, Your Honor, why that's very important is because, as I stated before, Mr. Beebe, the co-defendant of the charges, was allowed to plead to a reduced charge of robbery and given a 10-5 sentence in this case. The fact that the state is unwilling to do the same with the co-defendant in this matter, Mr. Everett shows their intent toward Mr. Everett wanting him to serve the mandatory minimum on the armed robbery sentence, which, given in light of the probated sentence that he has right now, is a mere formality unless it's wrong consecutive, Your Honor, I'd like to point out. And Mr. Evanger's probation was revoked, as the state stated correctly. He did not have any provision that he was supposed to stay away from the gang members because there were no gang charges in his first crime. And the allegation that he was supposed to stay away from individuals ill repute or harmful.
We don't care. He's shot at cop. This attorney's doing his job. We don't care, man. I don't want to hear this. Let's get to the sentencing.
Criminal records of everyone, of all the children and teenagers in this community, concurrent with count 32, that reflects the fact that the other officer in this matter did not receive any injuries, and there is no showing on the video.
Hold on, let me skip back. Skip back. Let me rewind this.
All right, well, I hadn't been privy to all of that. The last one I heard was, okay, 1 and not 2 life consecutives, but it sounds like they've been coming down the whole time. All right.
Let's see what Judge Whitaker decides with Christian Eppinger.
Yes.
As it relates to count 1,
Here we go.
we would ask that my client be sentenced to 15 years to serve concurrent to count number 32. As it
They want
relates to count
15 years on the
27,
RICO.
Your Honor, we would ask that my client be sentenced to serve 10 years to serve concurrent with count 1. The hijacking charge count 20 years being no cross. As it relates to count 29, possession of firearm by first offender, we would ask that he be sentenced to 5 years to serve consecutive with count 27.
That brother's sweating. He's sweating.
If I take the charge, Your Honor, we ask that my client be sentenced to serve a 10-year maximum, be sentenced to 5 years to serve concurrent with count 1.
So that's 15 still.
Your Honor, as it relates to count 32, the attempted murder, Your Honor, we would ask that my client be sentenced to serve 20 years to serve 15. We do not believe that there was an intent to murder the officer, Your Honor, so we believe that this is more in line with the factual basis of that murder assault in this case. So we ask him to serve 20 to serve 15 on that particular matter.
He said he wasn't intending to murder the officer. Boy, if you don't get your
Count 33, the attempted murder, Your Honor, we would ask that he be sentenced to 10 years to serve 5 concurrent with count 32. That reflects the fact that the other officer in this matter did not receive any injuries, and there is no showing on the video that he was ever in danger of receiving it. Mr. Evanger shot at this officer, however, Your Honor, is not apparently clearly from the video that he did so, and we did not receive any information that the car that he was at the time was struck by any bullets or any projectile was found from the car, so we do not believe that the 2 counts and counts 32 and 33 are factually the same. That is why we made a difference in the resolution of those charges.
He's trying to get him 15 years.
First offender at count 34, Your Honor, we ask that he sentenced to 5 years probation on second count number 32. For count number 36, possession of firearm by convicted felony, that's the client sentenced to 5 years to serve concurrent with count number 27. For count 37, being no cross, being no cross.
So 15.
Count 39, Your Honor, we ask that my client be sentenced for violation of gang law, Your Honor. We ask that he sentenced to serve 20 to serve 15. Concurrent with count number 32.
So they're asking for 15 and 10.
Count 47, Your Honor, we ask that my client be sentenced to serve 15 probation concurrent to count number 1, and for violation of the gang.
Nice try. There's no way he gets that.
48, my client is sentenced to serve 15 years probation concurrent to count 1, which based on the estimation you believe.
Okay, so now it's 15 and 15.
I think 25 to be 15.
Sure.
And I think that this is.
She said 25, serve 15.
Resolution of this matter, Your Honor, consistent with, as I stated before, on counts 27 and 28, the code of criminal procedure was 15 to 5, and 5 was consideration because the matter was reduced from armed robbery to robbery. As it relates to counts number 47 and 48, the code of criminal on those matters.
This is a negotiated plea.
On those counts, Your Honor. So as far as anything that will be varying from those charges as it relates to the charges of the shooting of the officer, as I said before, we asked that my client be served 20 to serve 15, and that this matter run concurrent with his probated sentence right now, Your Honor. Would you believe that it's fair and consistent with what's happened in the other matters in this case, Your Honor? But at no point in time has there been any allegation that Mr. Evander was the organizer or leader of this situation. No other defendant in this matter received more than 20 years to serve, and includes individuals that were charged with murder in this case. All the murder charges will be reduced to aggravated assault and double cross. And all of the armed robbery charges in this case, Your Honor, will reduce the robbery for the individual who received the hardest sentence on those of Mr. Huey, who had 3 armed robberies that were reduced down to robbery. He received a sentence of 20 to serve 9, Your Honor. I would like to point out that in none of these situations, there is no one who has lost their life in any of these situations that this matter has been involved in, Your Honor. And so we do not believe that if Mr. Evans is not taking anyone's life, we do not believe that there should be a second sentencing in this matter, which is effectively taking Mr. Evans' life away from him, as he currently has a 45-year sentence, and a second sentence would basically effectively almost be a death sentence in this matter. Your Honor, would you put any further? The state's recommendation would give him 110 years to serve, Your Honor, which is effectively a death sentence for an individual who did not kill anyone. And so therefore, while we can sit and say that individuals maintain and say that, oh, well, Officer definitely has his right to say that he felt that Officer Rogers was going to expire based on his injuries. The facts are none of the injuries that he sustained were life-threatening. He was back in service. Sometime after he was able to come to court to testify, Your Honor, I believe he's on the force now, so he's resuming his activity, Your Honor. So Mr. Evans has not killed anyone. And it's not be standing for me today accepting the responsibility of the situation. You understand, as I said before, there is a factual basis that the fact is presented by the state may present it up for a jury to convict it. We do believe that we have facts that could possibly go the other way as well, Your Honor. It is the uncertainty of that matter in which Mr. Evans seeks to avoid. And he's under the understanding that if he was found guilty at trial, his fate would be in your hands, Your Honor. We stand in that position as we are today.
No.
Thank you.
No, don't let him out, Judge Whitaker.
So I'm going to show Your Honor, State Exhibit.
You may. Have you shown it to opposing counsel?
Your Honor, showing State Exhibit number 1, Your Honor, which is Officer Rogers' vest. The video that Mr. Johnson showed you was after they took the vest off of him to perform life-saving services on Mr. Rogers. So you can see on that picture some blood markings on Mr. Rogers' front of his badge. And we also have some pictures that we can show, well, they were checked out on the Zoom, but shown on the Zoom that has blood on the back of his vest, Your Honor. So when he got out of the car, his vest was on. He shot him in the vest, and so they took it off to help perform the measures, Your Honor. So that is an incorrect statement that Mr. Officer Rogers did not have or was not in uniform because he was in his vest that says
it had the seal and his name.
His name on it, Your Honor. Going to
Defense Exhibit 1 and State's Exhibit 1 are admitted.
Going briefly to the armed robbery, Your Honor, regarding Mr. Eppinger and this comparison of Mr. Beebe and Mr. Eppinger. When we spoke with Mr. Smith, Darius Smith, in preparation for this case, what he advised is that Mr. Eppinger was the individual informing or controlling the armed robbery. He was the one telling Beebe what to do, that Beebe seemed afraid or scared. And so when we made the decision for Mr. Beebe, we took that into consideration because that is what the victim told us, that it seemed as though Mr. Beebe was afraid to do it, but he was following the demands and the controls of Mr. Eppinger, which you can hear when he's bragging about it, what he said he did and how he spoke to the victim, Your Honor. So we took that into consideration when looking at Mr. Beebe's resolution, and Mr. Beebe did not have a prior armed robbery, reduced to robbery, when we decided to make that recommendation. And then, as it relates to the stabbing of Mr. Bennett, the reason why Mr. Bennett was stabbed is not because he didn't have the opportunity, but because one of the law enforcement in our office heard the jail calls. They called the jail to have Mr. Bennett moved so he wouldn't be stabbed again. So it's not for the fact that he didn't do it, it's the fact that we were able to move Mr. Bennett to safety so that he did not get harmed again. So this notion that he didn't do it is because he didn't have the opportunity. Your Honor, we were able to get Mr. Epinger's juvenile history, Your Honor. So he had 2 burglaries, one from June 4th,
So there's his juvenile history y'all were talking
was
about.
almost a year prior to the armed robbery. And then he had another burglary on February 11th, 2016, so a few months before the armed robbery. He was adjudicated, it looks like the date is May 11, 2016, so we're not sure. Once he was taken into custody, they adjudicated it, but they were joined for purposes of juvenile adjudication, Your Honor. Your Honor, my closing remarks here is that Mr. Eppinger is not similarly situated to many of the other defendants in this indictment. Mr. Eppinger received an opportunity to change his life when he got an armed robbery that he did at 16 reduced to robbery. He served 4 years in custody, and within 4 months, not a year, within 4 months, he was back to the same criminal behavior that they tried to save him from 4 years prior to that. He never learned his lesson, not once. And what does he do? He robs somebody. Then when police are just trying to do their job, he takes a gun and he's not carrying his waistband. He's not carrying where he has to pull. It's literally tucked under his arm with easy access and begins firing off rounds over and over and over again. Like you said, Judge, he's not a good shot. But bullets have no names. You know, Mr. Johnson just said, well, the bullet that went to Mr. Johnson didn't hit him. That's not, they don't have any names. And for that reason, Your Honor, the state, we believe, has been gracious in our offer. Mr. Eppinger, looking at what he's charged with, he's looking at life plus 150 years. That is what the maximum sentence is for the charge that he's pleading to. The state, understanding that he already has 43 years, which most of that will be door to door, consider that 60 years consecutive is about 103 years. And that is why we made that recommendation, Your Honor, given that we believe that is substantial time in this case. So, Your Honor, the state
Whitaker's not going to give him that much time.
Mr. Eppinger had an opportunity to change his life around, had an opportunity to go to the next level Boys Academy, had an opportunity to do all these different things, but he chose not to do that. He chose to go back into the streets, to live this life again. And here's where we are, and this is what it brought him to. And he had no remorse about it. On the jail calls, he's bragging about it. That's what he's doing. He wants to be this person in the streets. So we're asking you to hold him accountable to be that person in the streets.
All right.
Yeah, go ahead. Yes, Your Honor. First off, as far as the allegation regarding the differences in Mr. Beebe, Your Honor, they showed you the photograph of Mr. Beebe wearing the chain. Mr. Beebe, there's no photograph of Mr. Eppinger wearing the chain. And so therefore, the fact that they say that the witness told him that the one person was running it, we do believe that the evidence that he's giving in the interview, we don't have a recording of what he said when he was in their office. However, the recordings that he gave to the police officer at the scene of the crime, the recording that he had with the officers later on, and the recording with the officers at the time that he made the identification says none of that, Your Honor. So therefore, that evidence in and of itself should not be taken as 100% credible. It's something to cross-examination and discrediting as well, Your Honor. So therefore, the state is not showing a significant difference between this situation, as Mr. Beebe is the individual that photographs wearing the chain after the incident, which would show that he's much more involved in just being a scared person.
Respectfully, brother, we don't care.
Your Honor, and the state has evidence of that they knew at the time they gave his plea.
Yeah, respectfully, we don't care. And by we, I mean Fulton County. I speak for all of Fulton County when I say I do not care if it was a juvenile. He broke the rules not once, not twice, but 3 times. And then he went out and shot a cop. If he's going to go out and shoot a cop, he doesn't care about any of us. I don't want this man a part of my society. Get him out. What are we talking about here?
Also, Your Honor,
bye.
As they mentioned about the fact that Mr. Bennett was moved, the state still has.
He's going to be a king in jail. He shot a cop. Go ahead and have fun in there.
There's no showing that Mr. Eppinger had received an order or any kind of compensation to do this. So the fact that they moved him is irrelevant, Your Honor, because there's no showing that the crime of the conspiracy was actually completed in this particular situation. Your Honor. So the fact that they may have moved Mr. Bennett and Mr. Evans did not complete the crime is irrelevant, Your Honor. The issue in fact of the matter is not whether they actually did it, whether or not there was an agreement prior to that for them to do that sufficient for the charge of conspiracy, in which they had not done so.
He's going to be in jail the rest of his life.
All right, thank you. I found there to be a factual basis for this plea, and I will accept the plea as freely, knowingly, intelligently, and voluntarily entered with an understanding of the consequences and the sentence. And let me say a couple of things. Only one overt act, as we all know, needs to be proven to establish RICO. On counts 27 and 29, I believe that the defendant's own words inculpate him in the crimes, and I note that he talked about telling the victim to take off the earrings too, which was a part of what was stolen in the case. That certainly seems to, in the court's estimation, inculpate him in those crimes as an absolute willing participant. 31, understandably, considering what we see on video, the defense has really not argued anything at all. Appreciate that, that y'all acknowledge that at least that is pretty clear. In counts 32 through 39, the video, in addition to State's Exhibit Number 1, shows the officer to be in uniform, and I do not think that charging attempted murder is an overcharge, considering that
look at all those officers there.
and he hears 6 shots on the video, pumps 6 shots at close range into a uniformed officer, and then laughs about it afterwards, including saying something to the effect of, yeah, he's telling me to get down, I ain't getting down.
Yeah, and this is the officer he shot. Thank God he's still with us. There's no excuses for Christian Eppinger. Thank God the officer made it through. Y'all saw the pictures.
Something to the effect of, yeah, he's telling me to get down, I ain't getting down.
Just what he says.
I think that considering the prior history, the number of different incidents, honestly, almost back to back to back to back, from him getting out on first offender probation and deciding he's not going to change his life, he's not going to take the opportunity he's been given. And many of these incidents wouldn't have occurred, or wouldn't have occurred with the seriousness that they did if he had abided by his first offender probationary condition of not having a firearm in his possession. He couldn't have shot an officer because he wouldn't have had a gun to shoot an officer if he had abided by his conditions of probation.
Correct.
So the number of the separate incidents, the apparent lack of remorse for any of this, the seriousness of the crimes, and the strength of the state's evidence on these particular charges, and the demonstrated determination to continue a criminal lifestyle all go into the court's sentence determination in this case. So the sentence on count 1 is 20 years to serve 10. On count 27, it is 20 years to serve 10 concurrent. 29 is 10 years concurrent. 31, 5 years concurrent with count 1. The sentence on count 32 is 30 years to serve consecutive to count 1.
That's 50
33,
years.
20 years to serve concurrent with count 32. 34 is 10 years to serve concurrent with count 32. I'm going to come back to 36 because that is required by statute to be run consecutively to anything else that's being sentenced. That's the only one that's that way, right, Ms. Hilton? Yes, ma'am. All right, count 39, the sentence is 20 years to serve 15 concurrent with count 32. 47, the sentence is 10 years consecutive to count 32 but probated. 48, 10 years
60.
Concurrent with count 47 probated, and then 36 is going to be 5 years consecutive to count 47
so 65.
and probated. I believe that is, honestly, I'm going to have to do a little bit of math right here.
I didn't do the time to serve though. He sentenced to 65 years so far. Good.
I think that's 75 years
to
serve.
75? I thought it was 65. No?
To serve 40 followed by 15, no, but I don't know what the math comes out to be, but.
Long time.
20 to serve 10.
Rescue, love you a long time.
10 to serve concurrent, 5 to serve concurrent with count 1. So that's a total of 20 serve 10 right there.
2010.
All right. Count 32 is 30 years to serve consecutive to count 1. So that's another 30 to serve. Count 33, 20 to serve concurrent with count 32. 34, 10 concurrent with count 32. So right now we're at 50, serve 30. Yes. If there's 30 to serve.
To serve 40. Because 20 serve 10.
Clearly this is why lawyers end up lawyers and not scientists or mathematicians, although that's the yes, consecutive to count 1, which is 10 to serve. So that's 50 serve 40 at this point. Count 39 is 20 serve 15 concurrent with 32. So that's not any additional time to serve. So, and then 47 is 10 probated consecutive to 32. 48 is 10 probated concurrent with 47. And 36 is 5 consecutive to 37 probated. So that's
Consecutive to 47?
yes.
I thought it was 65, but my...
It's at least 65.
Yeah, thank you. Come on, Judge Whitaker. Let me see if somebody probably already has it. Let me see.
How long is he going to actually serve on that sentence?
Probably 40 something.
I understand it would take 40 days. 45.
I'm running currently with his sentence he is currently serving. All right, that is the ruling of the court. And we are adjourned. He may be taken into custody.
Get your ass up out of here. Shout out to Judge Whitaker. I'm gonna miss her, man.
These niggas lacking.
I'm gonna miss Judge Whitaker. I'm not gonna lie. But this was, I think, well deserved. This guy really had no case. He had chance after chance after chance after chance. And then he did one of the most despicable things that you can do on this plan. That was attempt to, from what it looked like to me, a lot of other people who saw the video, take the life of someone who was just doing their job. Disgusting, man. And it's looking like what I'm seeing is he was sentenced officially 75 years to serve 40 concurrent with his previous 45-year sentence. He ain't getting out. Happy to see that, man. Happy this guy isn't on the streets. Thank God he didn't take the life of that police officer. And he's going to be right where he belongs. Let me know what y'all think about this in the comments and in the chat. How y'all feeling, man? Who was the young one again that was doing life? Rodelius Ron, is that who you're talking about? Lil Rod? Yeah. Some people are just prison people. Well, I think I personally don't think we should waste air on them, but hey, you guys interpret that however you want to. I think a dude like Christian Eppinger is a complete and total waste of air and taxpayers' dollars. But hey, you know, it is what it is. Let me see if I can figure this out and get this back, because we're about to get back into the Karen Reed trial. I think it's 65-year sentence, but you only have to serve 40. The rest probated or suspended. I don't dispute that at all. They beating him up right now. No, they're not. He shot a cop. They'll be like, hey, man, what happened? They're going to be clowning him because he didn't finish the job. But no, he's not. He's doing just fine. Some people are just institutionalized, and some people are just a waste of air. Christian Eppinger is one of them, in my opinion. He had a smirk on his face, and I hope he learns someday. So, all right, let's go ahead and get back into Karen Reed, y'all. Oh, wow, it skipped us way ahead. Hold on a second, because we missed a little bit of this testimony. Here we go. Hopefully we'll get to hear Bev's ruling. He's never getting out of prison. He's done. Yeah, he's not.
All right, I appreciate the court personnel waiting so that we could have that voir dire. It was helpful. All right, so my rulings are very similar than they were this morning. So first of all, on the Darbert analysis regarding Dr. LaPosada being able to testify as to the dog bite wounds, I find that she is not qualified. I'm not satisfied that the Darbert requirements have been made. Specifically, not just the experience, but the reliability of the methodology she used and how it was applied. So, based on that, she cannot testify to the dog wounds. And I want to take a minute to differentiate this testimony with Dr. Russell's. I found that Dr. Russell was an expert, qualified to testify as to dog bite wounds, mainly from her experience in the ER, coupled with her being an ME. Dr. LaPosada does not have that experience. I found that Dr. Russell's methodology was reasonable and was sufficient, and I found that it was appropriately applied. Remember that Dr. Russell was published in the area here. So regarding pages 10 and 11, all of the text on Dr. LaPosada's report on pages 10 and 11 that start with the injuries on Mr. O'Keefe's right arm are excluded.
Dang.
Now moving on to the testimony regarding not being consistent with a motor vehicle strike, I find that Dr. LaPosada's opinion on these not being the result of a motor vehicle collision exceed what is within her scope of expertise in some regards, not in all. In some regards, significantly, like I said this morning. So on page 17,
that's amazing. I mean,
the
I'm not
first
shocked
sentence
at
is
that.
in.
I can
The
see
second sentence, tail lights are typically made of durable polycarbonate or acrylic plastic. That is out. I know the Commonwealth objected to, but I'm letting in. Mr. O'Keefe's patterned injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting the arm. She cannot say tail light, but she can say that based on her experience. His arm had no tissue bruising from impact. That also comes in. In the next sentence, neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes at various angles and depths. That's within her realm of expertise as a medical examiner. The next page, though, I may have said this morning that first sentence, importantly,
it was a toss-up.
in review of that, in review of the Tompkins case, that first sentence stays out because to me it seems like that sentence depends on a biomechanical analysis, factors such as speed and force and the position of Mr. O'Keefe. So that's, oh, I'm sorry, page 18, the next page regarding the same subject matter. And portion of the next sentence is also out. This results in bruising or bleeding under the skin. That's out. But Dr. LaPosada can testify that Mr. O'Keefe had no bruising on his arms or torso. And that's it for that sentence. In particular, Mr. O'Keefe did not have bruises on his legs as shown by dissection of leg tissue and muscle at autopsy. That's it for that. And the conclusions
That's it for that.
Are problematic to the extent that is consistent with this ruling and what we discussed on Friday. So that's it. That was just the text of her report. I have not begun to go through all of the, there's no PowerPoint with this, Mr. Jackson, right?
There
There's no PowerPoint.
All right, do you intend on displaying any of these photographs?
I'm sorry.
Do you intend on displaying any of the photographs that are in her report?
Yes. I have to go through it now with the courtroom and
All right, so you likely not get to that today. We've done important work, but we've wasted an awful lot of the jurors' time today. So I want to bring them in. And
my suggestion, we have to finish with that anyways.
right, we're going to do that now. So that'll give you an opportunity to pull your thoughts together.
Right, and I expect what I will do is sort of has to appreciate my intention. I will go through her position. That will take me a good amount of time. I will go through the part of her initial analysis that will not include any of the photos, but I may need overnight to actually go through the court's rulings.
Sorry about that, yeah.
Specific, and I want to be as
Okay, so
that as possible.
let me know what you intend to put in. All right, and there's a lot of text describing the photos that is out, right? It's just hearsay.
I mean, we've had Dr. Welch's PowerPoint.
That was not objected to. There's a big difference.
Yes, it was objected to.
So we'll deal with this tomorrow, with the photographs tomorrow.
I just want to let the court know, I'm not wasting the court's time.
Okay, thank you. And we're bringing the jurors in. Did the Commonwealth want to respond in any way?
No, thank you.
Okay.
Yeah, Hank is still
And
hurting from that
there's a
beating he
motion on
took.
Dr. Rentschler. We will give that.
At
I haven't
lunchtime.
read it yet. We'll give that no more than 5 minutes tomorrow morning each side. This jury, you can tell just by looking at this jury, they're fed up. So
With you, lady. No, shout out to Judge Bev. I ain't mad at her. Y'all don't like her. She's all right.
Obviously, it's over the defense objection.
Sure.
And I just want to make for the record a quick comment. The Commonwealth waited until June 5th to even bring this up, to file a motion regarding Dr. Laposada. They had a report, and all reciprocal discovery was done in March 6th, 2025. That's document number 485.
Yeah.
And the Commonwealth was ordered to file whatever motions they wanted to, whatever motions in limine they thought were appropriate by March 7th. And they did not do that. They were supposed to be heard on March 18th.
okay, so the jurors are coming in. We're going to mark the report and the
Mark it.
CV for
Mark it.
identification.
I just need to know when I can make it.
You just made it.
I made it ish. I wasn't
Okay.
recording myself,
Okay.
but the point is,
Go ahead, real quick.
the point is, the Commonwealth has not explained the delay.
So-
This is just beverage.
They have, and we're playing by the same rules, Judge.
So the basis of my ruling was not late disclosure. Okay? Late disclosure. Commonwealth says they're part.
That's not the court's missing the point. It's the opposite. We got late disclosure. We got late disclosure that they were objecting. They've had since March to object. They blew the motion in limited time, and then they come in just before Dr.
All right.
Laposada testifies, and now they're sort of
AJ's trying.
this and then the court moves against us. So I want to make sure that the record is imminently clear about
Very clear. Mr. Brennan, do you want to respond real quickly?
Your Honor, we can always object even during the proffering of testimony. There's no foundation. It's a foundational issue.
And that's consistent with what my rulings were when I allowed other witnesses to testify that the defense could object if the foundation weren't properly laid. So bring them in, please.
All right, here comes the jury. I think we're gonna get the measurement guy up here.
Really patient with us today. We're going to go straight through until 4 o'clock, and we're going to make every effort to not leave you waiting out there as long as you have, as long as we did today. All right, Ms. Giannetti, is your witness ready? All right, Mr. Tedman, whenever you're ready, sir.
Thank you. Thank you, Your Honor. Sir, before the lunch break,
Here's
you had
our measurements
identified 3 entrances to the front of 34 Fairview, leaving aside the 2 garage car doors. Do you recall that?
Yes.
May I have that?
This is the private
last
investigator,
exhibit displayed,
by the
please?
way.
not that one, the one that we discussed right before court. There it is. Maybe zoom in on that a little. Okay. What do you see on the screen at this point, sir?
I see the two rightmost entrances to the house, excluding the main front door.
Okay, which would be obviously to the left of this photo, particularly with regard to the third entrance, the one in red. Could you describe that?
Yes. So it's if you're facing the house from the street, you're looking towards the west. So that door goes directly into the garage, facing north.
Okay. So basically, from the street, you don't have to enter the house. You can go into the garage directly.
That is directly into the garage. Yes.
All right. And as we're looking at the house from this point, are we looking at it from the vantage point of Fairview Road?
Yes.
And that is a westerly direction toward the house, sir?
Correct.
In the course of doing your further work that you were asked to do in this case, did you peer inside the garage?
Yes, I did.
Did you see concrete steps and a ridge there?
Wow,
and
they
a
really
hard
updated this
concrete
house.
floor?
It's nice.
Yes.
Sustain. Jurors disregard that answer.
You mentioned that you were asked to do some measurements. Can you describe what you were asked to do for the jury?
Yes, I was asked to measure from basically the mailbox area of the driveway to the various entrances to the house.
Did you take those measurements?
I did.
Okay, if I'd like to take them one at a time. First, did you measure from the end of the driveway next to the mailbox all the way to the main front door, which is not depicted on this photo?
Yes, I did.
How did you measure it?
I used my wheeled measuring device, and I walked directly across the lawn to the front door, well, to the bottom of the front steps, and then used it to go up the front steps straight to the door.
And what was the measurement, if you recall, from the mailbox area near the end of the driveway to the main front door on the left?
I believe it was 65 feet 9 inches, but I have notes if I
think you got it right, sir.
Okay.
Next, did you measure from
It's got a
that
good memory.
same location near the street, the end of the driveway next to the mailbox, to the second front door, which is actually depicted in the exhibit that's on the screen?
I did.
And how did you measure that?
I walked along the edge of the driveway on the asphalt, right next to the grass, towards the house from the mailbox and the edge of the street, towards the house. I took a left onto the brick walkway, proceeded along that walkway, then took a right to the walkway that you can see right there, heading directly to the door, and went up onto the little decking area, and then those 2 steps directly to the doorstep.
Okay, so you walked essentially almost the whole length of the driveway?
Yes.
Before you took the left to get to where the steps start, going to that second front door?
Yes.
And then went up to the door
all the
itself?
trolls are coming out today.
Do you recall from your memory what the measurement was?
I believe it was 70 feet 1 inch.
And finally, did you measure from that same end of the driveway near the street next to the mailbox to the red side door, which is the pedestrian entrance into the garage directly?
I did.
How did you measure that?
I did the same thing, walking directly from where the mailbox and the driveway intersect, basically, all the way up the driveway, took the same left onto the red brick pathway, took a right to go towards the front door, went up the 1 step that you can see, and then instead of going up the next 2 steps, I took a right directly towards the garage entry door.
So essentially the same path of travel, it's just you didn't go straight into the second front door. You took a right to go into the pedestrian entrance to the garage.
Correct.
And what was the measurement that you discovered having done that?
I believe it was 78 feet 3 inches.
Now, finally, could we have displayed the map of Cedar Crest, Fairview, and Chapman? There it is. Sir, are you able to see the street names from where you are? And if
Yes.
not, could we have the top street magnified so that the witness can see it? Okay, you see that?
I do.
What do you see that to be?
Cedar Crest Road.
Okay, if we could have the connecting street where the, that's it.
Fairview Road.
All right, and finally, the one down the bottom?
Chapman Street.
Okay, if we can get the whole map back up. Having seen those three street names, does that orient you as to what this is a map of?
It does.
And what is that?
This is the surrounding area of 34 Fairview Road, the neighborhood, basically.
Okay, and it includes the two connecting streets on either end?
Correct.
Does the red dot symbolize anything for you?
It looks to be where 34 Fairview Road is located.
Okay. And if you're on Fairview Road to the right of that red dot as it exists on that exhibit, and you're looking toward Fairview Road, what direction would you be facing?
It would be facing west.
If I may have a moment, Judge?
Okay.
Take your time, Yannetti. We're going to be here for a minute.
Further questions? Thank you very much, sir.
Thank you.
Any questions?
Yes.
Well, that was a quick witness.
Good afternoon, sir.
Good afternoon.
You had a wheel to measure,
Correct.
and so there's like a tape measure, and when you wheel it out, it gives a straight line?
No, it's two wheels with a meter in between them, and you roll it out in front of you.
I see. Your first measurement was from the driveway to the front
Arguing
door,
about a meter.
To the
crazy.
main front door to the far left, yes.
and that was about 63 feet?
I believe it was 65 feet, something like that. I have
65?
my notes. Yes.
So suffice to say, if you were to leave the front door and come back to that spot, it would be an additional 65 feet back, right?
Yes.
The second measurement was from the bottom of the driveway to the middle door on the side?
Yeah, the second front door, yes.
Did you say that was about 70 feet?
It was, yes.
Okay. And again, if you were to come back, that would be an additional 70 feet?
It would.
And the last one was the door near the garage. Did you say that was further, around 80 feet?
78 feet, 3 inches, I believe.
Except one way.
Correct.
And back is another 78 feet.
Correct.
When you measured these, was it from the asphalt of the driveway or to the left of the mailbox as you're looking at Fairview?
It was to the right of the mailbox on the asphalt, as close to the mailbox as I could get.
Did you happen to take any measurements from the flagpole to the front door as far as distance?
I did.
And what was that?
Oh, good.
I
Thank
do
goodness.
not have the exact measurement. I'm not sure.
Do you have it in a report that you could look at?
I don't. No, not with me.
How about the flagpole to the middle door on the side? Did you take any measurements of that?
What about
I'm not
the
sure I
rock?
took that one.
How about the flagpole to the furthest away door, which would be the door next to the garage?
We're still not talking about the
I think
rock.
I took a
apparently.
direct measurement to that, yes.
Right. And what was that number?
I don't know.
Do you have a report you can share with us?
I don't. No, I'm sorry.
It's okay. Did you ever measure if you were at the flagpole area, how long it would take to walk up the street? Or how far it would be to walk up the street, up the driveway to any of those doors? Did you ever measure it that way?
I did.
And what was the distance if you were going to start at the flagpole, walk up the street, up the driveway, down the walkway to the front door?
I'm not sure that distance. Not positive the distance.
Was it over 80 feet?
It was.
And if you did the same route up the street, up the driveway, to the middle door, would you agree that would be well over 80 feet as well?
Can you repeat the question? How?
Sure. If you were to measure from the flagpole, up the street, up the driveway, to the middle door, that would be well over 80 feet?
Yes.
Same to the door next to the garage?
Yes.
Thank you for your time.
Thank you.
All right, you are all set, sir. Thank you very much. Thank you.
Right there it is. Shout out to our tape measuring guy. We learned so much there, right? Measurements. Maybe the Commonwealth will use it in closing arguments. I have no idea. I think what we're going to do is we've got Dr. La Posada is up next, but she's going to be up there for a minute. And I don't think there's any point in just bringing her up here to then end halfway. So what we're going to do is we are going to save her testimony for tomorrow morning. So we'll start early tomorrow morning. Or actually, should we start early? We'll see. We'll review her testimony tomorrow morning. We'll get started with that as soon as we start tomorrow morning, and then we'll roll right into the rest of her testimony starting tomorrow. All right. So let me read a couple more super chats, and then I'm going to get y'all up out of here. Shout out to the gang in the building. Thank you to the nearly 2,000 of you that liked the video. Oh my goodness. Y'all are amazing. Kara also in here gifted 5 memberships. If you got a membership from Kara, make sure you say thank you. And I also want to shout out and show appreciation to everybody who went the extra mile and supported. Brenda over on Cash App, thank you. Slim Life over on the super chats and over on PayPal. Wendy W. We had Kara, of course, CPE, my dog. We had Mr. Brown. We had the new timer, Lady Divine as well. Kitty Cat, thank you. Cynthia Hart, Josh Collings as well. And then, of course, y'all know my awesome, amazing Amy is in here as well. All right, appreciate y'all. We're going to be back in the morning. We're going to finish wrapping up this testimony. If you haven't yet, like the video on your way out, subscribe, and hit the notification bell so you don't miss any time that we go live or drop a new video. All right. I appreciate y'all. I hope you guys have a great rest of your afternoon. And if you want to hear some dope music from some of the independent artists who are here in our community, make sure you check out the Song of the Night live. We're going to be going live tonight at 8 p.m. Eastern Standard Time. Looking forward to seeing y'all there. And as always, you know what to do. Keep growing, keep pushing, keep it classy. Peace. We gone.